Good morning, everyone. I think I'm going to start with just doing an address, especially for our public and for media. There are things that I need to explain as the chairperson, perhaps just for those who are following us as well on the stream. I've got panel members as appointed by the President, myself, Mmamoloko Kubayi, Minister of Justice, and then I've got Mr. Kani Maluleka, who's the AG for South Africa, AG for South Africa. We've got Ntabiseni Sipanya Mohali, who's the chairperson of the Gender Commission in the Country and Equality. We've got Prof. Somato Dafikeni as well, who is the chairperson of the Public Service and Administration with us. We've got the chairperson of the Human Rights Commission, Advocate Nisan. We've got Mavundlela, who is the president of BLA and also president of LSSA. And then we've got the president of NADEL, Mr. Mashini Mutlou, who's also part of the panel. I thought I'll introduce first as we start because this is our day one, so that we can explain where we come from. So those are the panel members that have been appointed by the President to assist. Subsequent to the appointment of the panel, various steps have been taken. We made a call for applications on the 19th of October, which firstly closed on the 7th. Then we said to go through the process, and we had to extend. We've done pre-screening, and I want to say, because I see quite a number of people are saying we have shortlisted. This is today the process of shortlisting. We have not shortlisted. What we did as a panel was to check suitability of the candidates meeting the minimum requirements in terms of what is required. And what we had requested was that for the candidates, either they submit their application or they are nominated. And when they are nominated, they must accept the nomination and submit with all the detail. After the final closing on the 24th of November, because after the 17th, maybe just to go back, on the 17th, then we had to write to Legal Practice Council, because at that time, after the receiving of all the closed submissions, we only had 6 people that met the minimum requirements. We wrote to Legal Practice Council to invite them for legal bodies to nominate or for people to apply, recirculate the ad, and then it closed on the 24th of November. With that, still, those additional did not meet any minimum requirements. Again, to clarify, this is as per the NPA Act in terms of the people who are fit to be NDPP, but also as the panel looking at the organization, which is the National Prosecuting Authority, its footprint across the country. I felt that you can't have a person coming to lead such an institution, maybe with 1 year experience as a manager. And that's why the management level of experience at executive level was 10 years in terms of that. So after the closing, only 6 still met the minimum requirements. So it's not shortlisting. We didn't have anything to shortlist, but also we are cognizant that we are not the appointing body. That's why we can't shortlist. The appointing body or the appointing person legally is the President. So our job is to find a shortlisted process that then makes a recommendation of shortlisted names to the President. So the process that we are embarking, even these interviews, are not interviews of shortlisted bodies or people. It's people who meet minimum requirements that would shortlist after this. So I thought that is quite important. But as well, we have, as the panel, decided that we will issue a public process for candidates who have been finalized, met the minimum requirements, the 6. We publish them both in our website as the Department of Justice, but also in media platforms, including newspapers, where we publish their names and their CVs. And the closing date for public comments was the 5th of November, which then, out of that process, we got 281 comments. And maybe just as part of transparent, general comments about the process, about even suggested questions for the panel, were 8. Advocate Bell got 8 comments. Advocate Khronye got 9 comments. Advocate Johnson got 209 comments. Advocate Kanyile got 8 comments. Advocate Mopp got 5 comments. Advocate Simelani got 28 comments. So it comes to 281. So the individuals today, and I'll go into the process of how we are going to conduct this process after just outlining where we come from, leading to where we are today with the 6 candidates that we're looking at shortlisting. Part of the process, as well as the panel, we developed a questionnaire that we sent to the candidates. Then the candidates had to fill that questionnaire. As part of the process, I will take the candidates through that questionnaire, verifying information, getting them to explain throughout that process. The second part of the process of today and tomorrow will be questions from members of the panel that will be posed to the candidate, and the candidate will respond. With the public comments, what we have done, we compiled all those public comments and sent them to the candidates for the candidates to give us written responses. And when they come here again, a member of the panel will lead in taking the candidate through those public comments, verifying their responses. It will be in summary. It won't be as detailed as you know, as you have heard. Advocate Johnson got about 209. So it will be summary of the comments that have been. Each member of the panel will lead each individual candidate in those public comments to say, this is what the public have said, this is what your written comments, and also will ask questions based on that as the panel. And that will conclude the process of this interviewing process. When we finish with all of them, the panel will then reflect who amongst these candidates meets the requirements to be shortlisted and their names forwarded to the president, for president to apply his mind and be able to indicate and take the decision, the process forward. And that's what I thought I should explain in terms of the process, where we come from to today and tomorrow with the candidates. We are going to take 3 candidates today, which is Advocate Bell, Advocate Mopp, and Advocate Johnson. And the 3 other candidates, Advocate Kanyile, Advocate Khronye, and Advocate Simelani, will be taken tomorrow, not today. So that's the process that I wanted to attend to. Then the second area I want to deal with, we have received a letter with intention to interdict the process. This letter comes from, where's the letter now? Okay, I put it somewhere. It's coming from Minde, Shapira, and Smith attorneys on behalf of the Democratic Alliance, of threatening to go to court urgently. The letter is dated the 7th, but was received by us as the panel today, so we had to reflect on it. I will not go into detail because we do believe that this is self-inflicted agency, but also there are no merit on it because we have not shortlisted. So the lawyers will respond to the attorneys and the DA, And I must indicate, amongst the comments we received out of the 201 that I've mentioned that closed on the 5th, Democratic Alliance did not submit any public comments in this process that we have received. So the letter has been received. It's a letter that threatens to go to court. We have instructed our attorneys, our legal team, to respond to the letter, and should their urgent application be brought forward, to respond to it. We do feel that there is no need to halt the process as the panel. There is no basis, and therefore the letter as sent is actually misguided, but we'll respond to it legally with the teams. So that's the process we want to explain in terms of what we have in front of us and how we are going to handle the process. I thought, let's start that process, take members of the public and media on how we're going to run the process and what is expected and how we're going to deal with the process. So thank you very much for that. I think I'll allow the panel to settle for about 2 minutes before we take the first candidate to come through. If the members can start assisting Secretariat, if you can assist in getting us the person through. Members. Good morning, Advocate Bell.
Good morning, Minister.
How are you?
Panel members, I am very well, thank you.
I'm okay. We're starting with you and we're going to proceed. I'm sure you're familiar with the panel members. Okay, thank you very much. I will not waste time with introducing them because I've done that already. Just to explain to you in terms of the process, we've sent you a questionnaire which you had to complete. I'll take you through that questionnaire. And then when I'm done, members, or even in between, because it's an interactive session, if there's a follow-up, any member of the panel will come through. And then after that, we'll have a question session that we engage beyond the questionnaire. And then lastly, you would have received the public comments that relates to you specifically and your response. So with that regards, let me just see who's the allocated member. Ms. Mmamoloko, the HESA, will take you through your public comments. She'll be the lead person in that area of your public comments.
Thank you, Minister. Before we proceed, when I went through the questionnaire, I noticed one mistake. Okay. I was appointed on 1 May 1995. I'm very proud of that because that is Workers' Day and not 1 March. Apologies for
or 1 May 1995 on your process of appointment. Okay, that is noted. Thank you very much. And Workers' Day. Okay, thank you. Just to start, you had to sign the form as well, and I'll take you through. So we've got section 1 that deals with your personal details, and that was where I was going to come to say all this information is accurate as per your form. You can confirm and all that. I won't go into that one, but going into, take us through your qualifications, why they are relevant for you to be an NDPP. Switch on the mic as well.
My tertiary education, I've got BA Law, LLB, and LLM specializing in labor law, and commercial law. Why I've got the qualifications? I don't only have the qualifications, but I've got the practical experience in applying the knowledge that I gained at tertiary level. Why I specialized in labor law? I was always fascinated in how we treat employees, fairness, and in commercial law, it was challenging at varsity, and I wanted to prove myself that I am better than that qualification. I studied at part-time LLB through UNISA, while I was a senior state advocate in the Director Public Prosecutions Johannesburg office. So at the time, it was challenging to be in court every day and to study subjects that you're not dealing with on a daily basis. But knowledge is power, and that knowledge has come in very helpful in my career as it expanded. I studied LLB and BA Law at the University of the Western Cape. It was challenging days, but I learned a lot of practical experience. I deliberately chose Western Cape because I grew up here in Gauteng, very sheltered environment where everybody knows you in a close-knit community. So I wanted to experience freedom, what it means to change the era that we were in the early 90s, to be independent and yet contribute to where we were in the country. Then the LLM, that was through UNISA that I studied.
Quite interesting as well. So link that, because you're saying to us that you also deliberately wanted to make sure that you've got the practical experience.
Yes.
And I'm seeing here, as you say, you corrected that, you've been public prosecutor from the 1st of May 1995 to 96. Then you became the state attorney, state advocate from April 1996 to 99. And then you became senior state advocate 1999 to 2000, deputy director public prosecutions 2004 to 2008, deputy director public prosecution 2008, or that one was junior, then you became a senior one until 2022, director public prosecutor acting 2020-2022, and then since 2022 to date, you've become the director of public prosecution. Do you think out of this work you've gained enough experience to be able to lead the entirety of the NPA with various divisions, the NDPPs? Like the law says, you can appoint 4 as an NDPP maximum, and all these provinces and all these offices.
Let me start with answering by where it started in my career and the era in which I was appointed. I have been in service as a prosecutor for the last 30 years, a public service, a public servant. I have seen and served through the NPA through all its many seasons of transition. When I joined the NPA, it was still the Attorney General's office. Soon thereafter, in 1998, the National Prosecuting Authority was established. Transition, great excitement. We were placed in positions as a female of color. I was fast-tracked, but I had to show that I can do the work, that I've earned my seat at the table, that I can prosecute, In those days, it was difficult. I think some of us have forgotten, if you're new, if you're a female in the institution, many of the judiciary and council had not seen women of color being in the High Court prosecuting. So you had to earn your stripes. You didn't even have to work hard, you had to work extra hard to prove that you're up to the task. As I was sitting outside, I was thinking, I always find myself when I move into a new position in this era of transition. And what I can say about myself and the NPA as well, we are resilient. Despite the obstacles that there is, we ensure that justice is done every day. But by looking at me, when I took the position of the director in the Western Cape, many of the senior management had retired, the support that the office had relied on for a long time. So there was an opportunity for me for growth, recruitment, recruiting people of potential, developing them, and also keeping the staff morale high. I've worked through instances where we couldn't recruit in the NPA for years. But what did we do? We used it as an opportunity. People were placed in acting positions where we could mentor them. So if the opportunities opened up, they were ready. Am I ready to serve the entire NPA? Yes, I've got the benefit that I've worked in two of the largest divisions. For the last 5 years, I've been on the national management of the entire NPA. My division is huge. We deal with multiple crime types, and we rely on all our stakeholders to do the good work. Crime is high in the Western Cape, but we haven't given up hope. We're innovative every day as to how we tackle crime and instill confidence in the public. So yes, I am ready to serve. Will there be challenges? Definitely. Will I be able to overcome it? Yes, Minister, with the help of good partners and a good support team.
Thank you very much. I think the other areas will be explored as we go in. I'm just getting so that the panel and all of us get to know you. Now, going into the area of your court experience, I noted that one of the issues that we were looking at, do you appear? And I know that DPPs don't have to appear in court. It's optional. Is there a particular reason you just decided not to appear?
It's not a question of deciding not to appear. Litigation is my passion. That is where I prefer to be. But if you are the strategic leader in the province, you must lead, you must have vision, you must have support and provide the necessary structures. As a deputy, I was in charge of the High Court role. My predecessor, because of the portfolio, did not always want me to go to court, but I would slip in opportunities to go to court. If our advocates are not ready, if it's a particularly tricky case, then I would go to court. I am at ease in court. That is where I'm skilled in. Thank you.
Thank you. I noted earlier on you spoke about your work and passion in labor law. But the questionnaire as well asked you about other areas of law that you actually would say. For example, quite a lot of work as well would go into criminal law, constitutional law. Maybe take us through. You've highlighted even administrative law. Maybe just leave it open.
Yes. As a prosecutor, you don't only work with the criminal procedure law. You work with the Constitution is your Bible. You have to know procedure, you have to know civil procedure, and also administrative law. That is what governs the NPA and how we work. So yes, there's been constitutional challenges in my office where I've guided, where we've submitted affidavits. So I have experience therein, but my bulk of experience is in criminal law. But you have to have knowledge of, it's not just a one way, of how it all fits in together.
Then we're moving to the next section in terms of management experience. I noticed that you started having substantive number of employees reporting to you from 1st March 2020. The previous years, for example, you'd have had about 4 to 6 advocates reporting to you when you were deputy director, and when you were junior. When you were senior, you had about 20 maximum reporting to you. It's only in terms of 2020 that you had about 693 when you were acting, and currently. Do you think this experience have given you sufficient understanding, noting that it's the Western Cape as a whole? Between 2020 and 2025 is 5 years. You've built enough experience. Maybe just take us through.
Maybe I can give context to why I've given those numbers. As a direct supervisor where you sign the performance contract with the advocate, those were 5 and more. But even as a senior state advocate in the Johannesburg office, when the national office at VGM was created, I was appointed as a senior state advocate. I had to take charge of the appeal role. There, many of the advocates report to you, where you guide them, where you enroll the matter. So you're not their direct supervisor, but you are in charge of that. Even so with when I was appointed as deputy, for most of the 20 years, I was in charge of the High Court role. So that is not just mentoring the 5 people that have signed a performance contract with me. It is training all the advocates in the division. On a daily basis, prosecutors would call you for guidance where you need to give assistance as the deputy director. So that is the content. So it's not just in the last 5 years that I've been managing people. Throughout my career, mentoring and managing others have been part of my work.
Okay, thank you. Then one of the areas you talk about is that your management skills or your style of management is primarily consultative and inclusive. And other people can argue that that type of sometimes that consultative can be something that you end up with a person who's indecisive because they're consulting forever.
I'm not going to switch off again. I'll sit on my hands. It is important to hear all the voices in the room, even the dissenting ones, for people to feel accountable and part of the decision maker. But as the leader, the final decision, the accountability lies with me. So it's inclusive, but I make the decisions. In the difficult moments, it rests on me to make those decisions. But you have to have your team on board. You have to listen to them. You have to listen to all the views. The Jocelyn Smith matter was one case in particular, where it had huge reputational damage, where not everybody was convinced in my office that we had a reasonable case. Some were concerned about malicious prosecution, and they had valid arguments for it. And then there was voices that said it's community interest, it's not malicious prosecution. So I had to sit, listen to all the views, and then make the final decision. So that is what I mean by being inclusive. But the decision has to be made, and it has to be made swiftly, and you must be accountable for the decision made.
Maybe let's venture into that. I see as part of your leadership and organizational development, you are reflecting that a good leadership means being mindful, ethical, decisive, transparent, and accountable of your own decision. What does that mean as an NDPP? When a person is an NDPP, what would that transparency mean? What would be that accountability? Because the public currently cries for accountability and transparency in what is happening.
Regular accountability and transparency is being able to give explanations for your decisions, entrust the public to know what the process is, but also protecting the integrity of the investigation as well. Public relies on information. We're living in an advanced digital era where information spreads very quickly. So you need to be on the pulse of what is happening. You need to explain. Not everybody knows how the law processes work. That needs to be explained. You need to be accountable for it. And some of the decisions are going to be difficult. It's going to be unpopular. But you have to explain it, and your guidance should be the rule of law, adhering to the values that are enshrined in the Constitution.
And do you think that an NDPP should appear before Parliament, which is politicians, to account for the
Definitely.
decisions that they have made in prosecution?
Parliament represents the people. We represent the people. We need to explain, to be accountable for the work that we do, the decisions that we are making, and the trust that has been given to us. Absolutely.
Thank you. And other members will come to some of the issues later. Let's go to the ethics area and integrity. Just to confirm, the questionnaire asked you if you've ever been suspended in your position or other previous one. Have you gone through disciplinary process? Currently, NPA, we have the ethics office. Have you been referred to that? Any of those that we need to be aware of?
I have not been referred to the ethics, Office of Ethics and Accountability, but a complainant has laid a complaint with the LPC, the institution guiding the governance of practitioners, yes. That complaint was dismissed because it was based on a prosecutorial decision that I have made. I've submitted a letter from the LPC admitting or showing same.
Was it dismissed because it was lodged at the wrong place, or there were no merits?
There were no merits in it, and it was lodged at the wrong place. I checked our file. The complaint was never further pursued by the complainant.
The next area, it's around your contribution. As we know, our country is that we're looking at mostly the contribution of individuals within the society, but also in terms of the pursuit for justice. And I noted that you concluded some of the high-profile, you listed some of the high-profile trials that you've been. Do you want to share one of them that you think is significant for us to note in terms of your contribution to law and access to justice?
I believe, Minister, that all the work that I do on a daily basis contributes. But a highlight would be the Jocelyn Smith matter, although I didn't prosecute in it. It called for decisive decision-making. It impacted that community. And redressing and being victim-centric, it was important that justice be served to that community. I asked my role planner, go out with SAPS, go and try and find a venue where we can have the trial there before I approached the judge president, because circuit courts is very expensive because the entire court personnel has to move. I said, go and speak, but be mindful, we are a party to the proceeding. We can guide the High Court where to go. At one stage, the invoice for the center where the trial were to be held was in the name of my deputy. I had to intervene and ask the deputy, remind the city that it's the public that they serve. There should be no account. We're not in charge of it, but speak to the High Court. And we handed it over to the High Court to take the negotiations further. That case demonstrates that if we all work together, collaboration, justice can be victim-centric and it can be swift as well. It was also a groundbreaker because we were testing the law. We were expanding the law. A child being sold for sale and the victim not being found was a first. Yes, in matters where there was death before, we've been able to prosecute, but this was developing the law. Another one that was quite challenging in my career is a previous political figure, a minister that was charged for corruption in the High Court. He was acquitted. The judge presiding over the matter was a very senior judge. In fact, he was a former judge president of the matter. I studied the record and was of the view that all the issues were not ventilated in open court. It is not an easy decision or process to have a decision of the High Court reversed. We were able to do that because the grip of corruption on the country is rife. We need not just to show, but the merits of that case showed that we must act decisively and swiftly against the scourge of corruption in the country.
Thank you very much. As I come towards the end of the questionnaire, can I confirm that you do not hold any directorship or interest in business as listed here?
Correctly so, Minister.
And can I confirm there are no health issues that will impact on your work?
No health issues, Minister.
That concludes the questionnaire, and I'll move to commencing the second part of the interview. And my first issue there, perhaps just share with us, one of the interesting things I noticed is that in the Western Cape office, there was cross-nomination. I'm not so sure if you're aware. You had somebody that nominated you, themselves nominated, and supported within the same office. And none of the stakeholders were coming through or any. Can you share with us, was the team sitting, deciding that we're going to nominate, one of us going to make it? What had happened in that regard?
Not at all, Minister. Both the candidate, Advocate Mopp, and myself were nominated by senior management.
Two more, actually. The people who nominated you actually also got nominated from your office.
Indeed, Minister. We were concerned as to the candidate, Mr. Mopp, and I, as to we didn't want rivalry in the office, but because of the team that we had built, the leadership that our leadership team was fine. When I took office, was fairly new. It was transferring skills, developing, and encouraging them that we need different views, whether you're matured, older, whether you're new in the province as well. So the management team have found their voices, and they're very strong about it. And I was reminded that, and this is what I tell prosecutors as well, we are in service. Servant leadership, that is what we do. Whenever I go to prosecutors, I tell them we are the people's lawyer. We work in very difficult circumstances, but communities look up to us. So when the call came, I was reminded, you were saying that to all of us. Now is the time for you to prove that servant leadership. I always saw my role.
So you guys discussed it as an office with the senior managers?
No, I didn't know. I only heard when the nomination process was already. I was approached by two senior deputies. I did not know that they had spoken to each other. I asked for an opportunity, it was a Friday afternoon, to reflect on the possibility of being nominated. The Monday, I was reminded. I said to them, it is a huge responsibility. We need to support, as management, whoever is appointed. The Western Cape has always been vocal, have been innovative, have been challenging. So for the division to make various nominations should not surprise anybody. There's always a question, what is the Western Cape division, the senior management saying? We are, whether it's a case happening elsewhere in the country, we give support, we give advice. We see ourselves as part of the leadership of the Western Cape, of the entire country.
Thank you very much. Prof. Fikeni has a follow-up on that.
I just want to check, Advocate, if there was no moral discomfort with the discussion of cross-nominations within the office.
Between the candidates?
Yes.
Yes, there was, that it would cause division, that others might feel that they are pressurized to make the nomination as well. But the emotional intelligence that both I and the other candidate have reassured us that for us, I was concerned about the office, what happens after that. But we've put good structures in place, good processes where we hold each other accountable. So yes, I felt a little bit uncomfortable. Two of us are being nominated. It's a huge honor to be called to this interview and to be of service. And we recognize that responsibility. There was also a concern that if you don't put up your hand, who else will be? I was reminded recently in a training session that you are the leader that you're waiting for. So nobody else might answer to the call. And as we've seen with the nomination process, very few answer to the call because of how difficult and challenging this position can be. And I think both of us are acutely aware of that.
Thank you very much. I'll move to the next area. You just spoke about the challenges. Take us through what becomes your vision and what are those challenges that as the NDPP, should you be considered, you will have to face and how you're going to deal with it. What will we see of the NPA under your leadership?
The Advocate Batoy has built a foundation. And now it would be my vision, or under my leadership, to accelerate that. The distrust in the MPA and the services that we provide, to address that is by having an ethical leadership team, by being accountable. I previously explained what accountability is, but adhering to the values as in Section 195 of the Constitution, the administration of justice based on being accountable, being professional, using resources effectively. How would that NPA look like? That NPA would be principled, would be accountable, would be ethical. Work-wise, how will it look? It will be looking at the IDEC, accelerating the work that they're doing, insulating them. They already have appointments, but to attract skilled professionals to deal with corruption. In the Glenister 2 constitutional matter, the STIRS principle was applied for an independent corruption body to be insulated. It has to be operationally and also financially independent. It has to have specialized skill, independent. The staff needs to be trained professionally. There needs to be a security of tenure. You don't want to appoint skilled persons and then you lose them through other appointments because there are better offers elsewhere. You lose that skill, you use time spent on that, and also to follow a clear prosecution plan in every matter, especially in high court, in high-profile matters, where we have a prosecutor-guided approach, applying project management principles, where you have timelines, outcomes, risks that you consider, but there needs to be an end date. You can't investigate forever, and updating the public constantly. A victim-centric approach, the scourge of gender-based violence. is not an add-on for a prosecution service. It should be at the heart of what we do on a daily basis, where we give comfort to the victim, to survivorhood, where we respond swiftly and compassionately. The work, and if we think of the Western Cape in particular, organized crime, the MPA has established an organized crime strategy. It's now fully implementing that, using the legislation that's available to POCA, racketeering, money laundering, but more importantly, taking the benefits out of crime. Asset forfeiture should be at the center of all the work that we do. Some call it disruption. I prefer to call it strategic, impactful prosecutions where it instills confidence and the community that we provide the service to feels safer. Economic development is important. How do you track investment? We've shown through the latest FATF recommendation, this country is resilient. If we put all our resources together, coordinate, and deal with money laundering, terror financing, then we can attract investments, we can build the rule of law, have principled institutions that community can rely on.
Maybe just going into that as my last segment of justice. You spoke about, when you talk about the vision, and you flagged gender-based violence, organized crime, and all that. But if we look at the annual report of NPA that just been released, recently tabled before Parliament, Western Cape is one of the lowest performing on sexual offences conviction. Also sitting at 68% below the target. You look at murder rates, it's sitting with 3 other provinces below, around 76%, which is one of the issues that we are seeing in terms of organized. I think the other one, you are in almost 3 areas. Western Cape is performing at the bottom, including the infrastructure, essential infrastructure.
Yes.
And we've seen 8.1% of postponement of cases out of prosecutorial residence. Now, link that of the performance of the Western Cape with what you are saying. If we flag sexual offences, gender-based violence as one of the crises we have in the country, but we look at the performance of the Western Cape, how do we get convinced that this will not be following you to the national level?
I can assure you that it won't follow me. If we look at the latest performance of the Western Cape, it was a concern for us. We flagged essential infrastructure, murder rate, as well as sexual offences. And we looked in particular which courts are not performing and where it is that they're not performing and what interventions we can put in place. I recently, 2 months ago, met with the prosecutors in charge of sexual offences to say the number has gone up. We have reached the target. It looks like our interventions have worked, but we mustn't, the plan mustn't just be to meet the target. Justice must be felt, victims must be seeing it. So we looked at best practices. For instance, on the West Coast, there is no Tutuzela Care Center. There is, of course, no excuse for not performing. We reinforced by sending the case manager of our sexual offences and community affairs to give training, to do screening, to support the prosecutor there. Their performance has been the best since it's ever been. Everybody is now following that best practice. In our Peru court, we had a victim support room that didn't instill dignity, confidence in the process. We are interviewed, when you do cases well, by the TV producers, they come out, they ask. So we ask them, we don't want donor funding, Go to Pero Court. After you've been there, then we'll speak to you again. Go help us restore dignity to those victims. Sexual offences cases are difficult by nature. Very often, the complainant wants to withdraw. But we need to ensure that that withdrawal is an informed decision, that we have taken you to the processes, you know you've been prepared by a court preparation officer. Just last month, I received, or 2 weeks ago, an email from a mother who had received services of that Pero court. She thanked the court, all the staff. She said it was the most harrowing experience what had happened to her child. But just by going to the court, having the security greeting her, taking her to that room that is so comforting, the court preparation officer preparing her and the child for what is to come, taking them to court, the guidance, the counseling that they receive, that is justice to the people. So, Minister, we are constantly improving. We are looking at the data. Essential infrastructure, in particular, when we looked, it was our Cape Town court, that area that was not successful. You start with introspection first. Do the prosecutor need training? Are we not presenting the evidence correctly? And we found multiple factors. So we sent one of the deputies out. He's given training to the officials who do the arrest, what must be in the statement. He's also taken the prosecutors to how the evidence must be led. That statistic has also improved. Murder in the Western Cape. Minister, the murder figures in the Western Cape is the highest in the country. It is a concern for myself as well as the provincial commissioner. I have dedicated an advocate, a senior in my office, to screen all murder matters, to see what we can improve and where we can improve it. The community started to complain. Witnesses are scared to testify. They are afraid. There has been several shootings at the court where people have been called, have been killed. That causes so much damage to confidence in the criminal justice system. To convince a witness to come and testify, put your life at risk. Yes, there's witness protection, and witness protection in the NPA does a sterling job. But communities are fearful. They are reluctant to testify. Just last week, for the second time in 2 months, I had to go out to Athlone Court, where I had to speak not just to the prosecutors, but to the staff that services their court, where the prosecutor had moments before the shooting happened, passed the shooter. So our people work under very difficult circumstances. It's no excuse. The following day, they had to be in court. So we have the screening murder project, and when I looked at what drives murders, what is the driver of murders in the Western Cape, it's firearms. It's whether we are addressing a possession of a firearm at the first instance properly so that it doesn't escalate to a racketeering matter. We have made good progress on that. We've got a project on firearms. The stabilization project has been established in the Western Cape to deal with murders, deal with safety at courts, and how we address gang violence.
Thank you very much, Advocate Bell. I actually wanted to check your stats over 5 years or since you've been. And if I look at the statistics, just on sexual offenses, there's been a consistent decline.
And we are concerned about
Let
it.
me
Yes,
finish.
yes.
Yeah, there's been consistent decline. And I'm trying to understand what you gave. I would have ended. You gave as a reason that you are now intervening and the issue of other areas not having Tutuzela centers. At the time you were appointed, sexual offences conviction rate in the Western Cape was at 80.4%. It has been dropping until we reach at 68%. Now, with this drop, these interventions over years, have you been able to do them, or it's only after
No.
the last financial report, the last annual report that you started intervening?
No, but
that will be my last one, I promise.
No, Minister, I have monthly meetings with senior management where we look at the stats, where we interrogate it, where we ask what can we do to improve, why are victims withdrawing matters. So it wasn't just a quick fix to get
Okay,
this.
Bell, these ones are the ones that have gone to court, so it's conviction rate, it's not
Yes.
withdrawals. These are conviction rates.
Yes, Minister, I hear what you say. But for a witness to testify in court, it's difficult to explain to the court, to bare your soul of something intimate that has happened to you. We take the witnesses to the process. We've got court preparation officers. We've got dedicated courts that provide these services every day on a daily basis.
Okay, I've got follow-ups on the matter. Let's start, Mr. Mmamoloko.
Thanks. Good morning, Advocate Bell, right?
Good morning.
Thanks. I am interested in this part in particular because recently there's been a declaration of the GBV as a real problem in South Africa. And then we are sitting with the Western Cape, as the Minister just said, probably on a sliding slope, which I'm sure we all do not want to see. And these stats that we're talking about now, it's only about the Western Cape. Can you at least find an imagination of what it would do to South Africa if that statistic is to somewhat find space into all the other areas in the country? Can you just for a moment reflect on what that would do to our fight about this thing? And also just 1 second, I'm just giving you an opportunity to explain it from where you see it, because from a strategic vision point that you're looking at from an NDPP position, you would have to then worry about this stat all over the country. And it would come in handy for the panel to understand it from your perspective. Can you at least just take me through that?
It would be devastating to the fight against gender-based violence. But also in the screening of our cases, we don't just look at whether it's a stat that would have a positive outcome. We apply the law, whether there is reasonable prospects of success, and we enroll all of that. For us, it's important that the voice of the victim is heard, that although a court might find a difficult finding, but there's reasonable prospects of success, we take you through the process, your voice is heard. Justice is not just always in the outcome. Yes, the outcome instills confidence, but it's also about being heard, about treated with dignity and humanity. That is what justice is.
Mr. Mklu.
Thank you, Chair. Advocate Bell, out of the concerns that have been raised, in as far as the declining statistics is concerned. And taking from your responses, it would appear that there is more of a reaction to the challenge that your division is facing. And if this impression is correct, then it's concerning. Because at the heart of performance management, and for it to be effective, there has to be regular monitoring and evaluation of performance. And I don't see this coming from your responses, particularly taking into account that this challenge has been going on and recurring for quite a long time. And what I get from you is the interventions that were or that have been implemented. And the impression is that these interventions have been put in place recently and as a result of reacting to this challenge.
It is, thank you for the question and the opportunity. It is not just recent interventions. The statistics, especially of gender-based violence, is monitored nationally as well. So it is not just like in the last year we've given interventions. We've raised conviction rate at the regional court forum as well. And there, a presiding regional court magistrate is chairing a forum just dealing with sexual offenses, the challenges arising. My office sits there and make inputs and interventions as well. So there's been constantly addressing us looking introspectively. Are we not dealing with the matters properly? Is it our case backlogs that take too long? So we've considered all of that in addressing it. And it's not just in the last year. We looked at capacitating those courts where there are sexual offenses, to train prosecutors better, to have experienced prosecutors that can do proper consultation with the witnesses as well.
Witnessing?
Thank you, Chairperson. Good morning.
Good morning.
Just follow up on a few questions. The first one is, it's linked to gender-based violence. It's the whole issue about domestic violence. And there was one prosecutor in Wynberg that refused to withdraw cases because it comes on... Oh, put it closer. Okay. Thank you, Chairperson. Yeah, it's that you. I don't know if we have to believe statistics, but Mitchell's Plain has got the highest record of domestic violence, which is linked to gender-based violence. And there was a prosecutor in the Wynberg court that has refused to withdraw cases when a person wants to come. And we see this throughout the country that, cases are withdrawn. What would your vision be? What would your view be? What would your protocol or policies be to ensure that we have, there are economic considerations why people are withdrawing it, but at least because the constant waste of money, making a case and then withdraw it, and then, it doesn't send a good message. But that's the first one. The second one is that perhaps you could explain the issue about the POCA Act, because as far as my knowledge is that the provincial government has passed a law in which is making gangsters, being a member of a gang, illegal. But I haven't seen any statistics of anybody being arrested and being sent on that. And how, if we are going to take that with you should you be successful in your leadership, take it to other areas where crime is like in the different areas. I take Motherwell in Kubayi and so on. But also the issue, and the third one is the last one from my side, you say that, you start off by saying that, crime, that is, you're passionate to combat crime, and that's where this. But the murder rates on the Cape Flats, for example, and the prosecution rates are like kind of chalk and cheese. It is like, okay, thanks. It's like chalk and cheese. Just some statistics is like anything from Nyanga, Kailicha to Menenberg to Hanover Park. You will find anything between 30 and 40 murders per month. But the prosecution rate, now my question is how your interaction with the police, and if it happens there, and should you be successful, how it's going to be, whether it's Motherwell, whether it's other places where it happens, Deep Split or Colorado, El Dorado Park. How is that going to happen? You do blame the issue about guns and so on, but it's the organized crime and so on that is there. So those are the issues that of concern, that that you have a province there. You say that you have good infrastructure, you've got good policies, you've got good programs and so on. Yet that issue about crime still is really not. We don't see cases. Yes, I understand that the intimidation, and we need to look at the policy, and the minister spoke earlier sometime about how we, on the whistleblowers, but also the witnesses, because witnesses get gunned down, and the question is, how did the gun get into Wynberg Court?
Let's avoid too many multiple questions, otherwise the candidate might battle to respond.
Thank you, Chair.
Please.
My apologies. Okay, I'll stop there.
Thank you, Minister. I've made notes. Let me start with gender-based violence and Mitchell's Plain being the highest, and how we're dealing with it and a plan for that. Yes, your stats is correct. We've also picked it up in our stats. The senior public prosecutor there was very concerned, also our stakeholders. They have developed an excellent pathway referral program, where if a victim of gender-based violence wants to withdraw a matter, she is counseled on where to find shelter, to make an informed decision, and what the impact of that withdrawal would be. It has shown excellent results, because it's not just the NPA working with the complainant, the victim, and you're right. Often it is because it is a family member who is responsible for the family. So it's although you're being abused, your income, your security, that of your family, you rely thereon. So that is why that referral pathway is important. So if you make that decision, you know the options that are available to you. There's counseling, there's an interdict that you can get, there's a shelter that you can go to. So, and we piloted in Mitchell's Plain. It has shown excellent results, and we are hoping with the work of our stakeholders that we can replicate it throughout the province. The prosecutor in the Wynberg area refusing to withdraw gender-based violence matters, that is correct. Not all prosecutors can withdraw matters. The senior public prosecutor is in charge with doing that. There are strict MPA guidelines on that, because we've seen today you withdrawn the matter, next week you're a femicide case. We want you to make an informed decision. We want you to be aware that there are services available where you can be safe. Your question on the high, let me start with your POCA being a gang member. And whether it's criminal and whether it can be prosecuted. The Commissioner of Police, in all our meetings, have asked that we develop the law in this regard, that we put a case forward, and that we also advance for the change of the legislation as to how that is being applied. In the stabilization project, that is one of the issues that the team will be looking at. You're correct, the murder rate is high in the Western Cape. But when we looked at the statistics provided by SEPS, and also from our own experience, there are 10 or 12 police stations that contribute to 72% of crime in the Western Cape. So it's quite, and it would be your crime of murder, robbery, extortion. So if we address those 10 or 12 police stations, we will be addressing 72% of crime in the Western Cape. But that's not something the NPA can do on our own. We can support SAPS in their work that they're doing. They're following intelligence on this, and I can't speak too much about it, but to bring stability to the province, to look at targeted interventions, to instill confidence, because to prosecute, and to prosecute successfully, we need evidence. We need witnesses to come forward and to testify. Witnesses are scared. It's in all our reports why we cannot reach the conviction rate. And it happened at times that as soon as a witness has left the court, they're killed outside court. So it's difficult to prosecute those cases. It's heartbreaking for prosecutors as well. But do you force the witness and put their lives at risk, or do you withdraw the matter? And it often happens halfway through. The matter is enrolled, court preparation officer has prepared the witness testifies brilliantly, but as soon as cross-examination starts, the witness changes its stance, and there your case goes. So it's of equal concern. But we found that with organized crime in the Western Cape, we have got most of the gang leaders on trial. But yet their reach is still out there. They're still benefiting. And we've cleared the vacuum for others. That's why there's fighting amongst for them to be up-and-coming gang leaders as well. The stabilization plan is designed to address this. Your top high level, your masterminds, and also the runners who are doing the shooting, to address them, to be able to get stability in the province. So it's of great concern to us. I hope I've answered all your questions. Thank you.
Thank you very much. The last one is Advocate Mokhane.
Thank you. Minister, there are a few follow-ups, but I'll be to the point. When you started, you said in the early 90s, your experience was that of being, what can I say, parachuted, for a lack of a better word. I know you didn't use that word, to be where you are today, and you have had to work doubly hard. What does it look like? What did you see yourself being parachuted, and in what forms, and how would you use that now if you were to be NDPP in terms of transformation? Let me just give you all of them so that I don't hog the space. And then you also said the leader in the province must have a vision. What is your vision currently as acting leader of the Western Cape? What is your current?
She's permanent, she's appointed.
Oh, appointed. Oh, apologies for that. As the leader of NPA in the Western Cape, your current vision, if you can break that down for us. And then you said also, you are at ease in court. That's where you're skilled. Now, I want to know how then would you manage a situation that just requires your understanding of what is happening in the courts, but your skills would have to be in strategic leadership, in management, dispute resolution, problem solving, everything else except being in the court, although understanding the court dynamics would help. And then the last part one, you mentioned the Jocelyn Smith case. And just now, you've actually, as you were responding to Mr. Nissen, you actually said that difficulties in terms of how people come forward, they get mad at sometimes after testifying. How then did we end up with a situation that from afar, for us as the public, was so sloppily handled? I'll tell you why I say sloppily handled. There were parties of people going every morning with Jocelyn's mother and others to go and look for Jocelyn. What was the sanctioning around that? Where were the police around that? What was the role of the NPA to manage that process? Where did it end? You know, that kind of situation. More so that up to now, as far as I know, I'm open to correction, Jocelyn has still not been found, you know. So it was worrying. You also mentioned something about people, you have not been referred in any way to the ethics office or ethics committee or found wanting in that regard. I just want to know if you have, throughout your career, have had experiences where there has been a team member who reports to you who has had ethical challenges that you have had to deal with, or you know of and have had to give an opinion, and if so, how have you dealt with it? Thanks, Minister.
Okay, let's start with also a lot of questions, but with my vision for the Western Cape. My vision at the moment is to stabilize the Western Cape, to instill trust in victims, the public, that courts are safe spaces, that we still, despite the challenges, deliver an excellent service. For me, the biggest challenge is the backlog in cases. And that is also where we lose cases if a matter takes too long to be prosecuted. Memory fades. I have been advocating for a continuous role in the regional court, especially in sexual offences matters, where when the complainant, the victim testifies today, the matter is finalized at the end of the week. That you're not expected in 3 months' time, 4 months' time to be cross-examined on it. That's also where we lose cases, and it's unfair to victims and to family members and even the rights of the accused if matters take so long to be finalized. So reducing those backlogs, and that is also what the judicial officer, the regional court magistrate in charge of sexual offences, is working towards, to reduce that backlog so that witnesses testify, matter finish to end. My vision is to instill trust, to create a safer Western Cape where we can charge, deliver a speedy, just outcome to the community. And also based on principles and ethical decision-making, bringing matters to a finality. We live in a fast-paced era. People want answers almost immediately. We need to keep up with modern technology. What we've done in the Western Cape is we have moved to create a safer environment. We've moved towards virtual platforms, modernizing. We have, in dealing with our organized crime matters, and especially matters where they are use risk, where we use other accommodation. We've got facilities at the correctional services where trials are being heard. We're also using spaces in the regional court where there's adequate facility to drive those cases, so that to reduce backlog and that those high impact cases are finalized. What I said on being accelerated in my career, and maybe I should expand upon it. In 1995, I'm a woman of color, I'm educated, I meet the criteria to be in the High Court. I didn't immediately have the experience, but I was mentored. I received the necessary training. There wasn't an aspiration, prosecutors, ATP aspiration. Words fail me now. But there wasn't the program. So it's on-the-job training. That's why I believe in paying it forward, mentoring others, so that they don't have to struggle. So that is what I mean by being acutely aware of being accelerated early. But you also need to prove your skills and work very hard. You can't always rely on being a woman and a woman of color to be appointed. You need to do a good job. And our work is important because it affects the lives of at least two families, that of the accused as that of the victim. I hope I'm answering all the questions. The sloppy, what you refer to as the sloppy handling of the Jocelyn Smith matter, that was a huge concern, both to the prosecution and the investigation, because suddenly everybody had become a detective. And they're interviewing witnesses, it compromises the case. Yes, you want community involvement. It is good that we haven't become jaded, that it's a concern to everybody if a child is missing. But it must be handled responsibly. So I share your concerns, and we did share it, and we, in guiding the investigation, try to shield the integrity of our case and our witnesses as well, to protect the case, the interest of the case.
Thank you very much. I think we'll move away from this segment. As I said, I concluded my question with that, unless if there's a follow-up.
I didn't answer the ethical, whether I'd been confronted. I'm not sure if it's needed.
Okay. You want to go?
I have always, throughout my career, my ethical principles is known. Certain things are a no-go for me. But I have been called upon my profession to make difficult decisions and to lead in disciplinary matters where there was corruption by an employee, a co-worker, at senior management. And it's difficult if that person is well-liked, it's well-respected, but that's part of being ethical, showing that there is a zero tolerance for corruption. So yes, I've had to make those difficult decisions in disciplinary hearings where I led the evidence, and the senior manager on senior management was dismissed.
Kenny, I think it might link with this.
Well, thank you very much. Again, I think much focus has been on the Western Cape, but the job is on the whole nation. If you say, according to stats and indicators of the performance of your organization, it has taken that long to start seeing results. If you are a successful candidate nationally, what would you do differently to yield results, not over the years, but almost immediately? Because there is an anticipation that the new head of the NPA will start changing things on a more faster pace with greater impact than to say we're still working on the systems. You said that the current leader has laid the foundation. So what would you do differently so that we begin to see dramatic differences, and also understanding that other 8 provinces may have different kinds of patterns and challenges and demographic profiles?
Can I just start off by saying there are prosecutors who work hard, committed, daily, and produce excellent results. There are challenging areas, and I think your question speaks to those challenging areas where communities have lost trust in the NPA's ability to deal with that. Ministers already pointed out gender-based violence. The NPA has already embarked on compulsory training for all prosecutors on gender-based violence as well as sexual offences. And as I've said, it has already yielded results in the Western Cape where these statistics have improved, where prosecutors are keenly aware of the victim-centric approach, and that is, as I've said, at the heart that we do. For us to make impact, principled decisions needs to be made. Operational independence and financial independence of the MPA is key at heart. There's been, and we've seen at the commissions, allegations of corruption. So corruption has to be addressed decisively, with urgency and with impact. And then the MPA, throughout, we not only have the IDEC, they will deal with the high-profile, highly complex matters. There you would have a dedicated team, skilled, knowledgeable in the law, that has to work. And how I would insulate them is through by protecting them from interference, making sure that there are systems in place, that those systems are monitored, that especially those cases, the prosecution plan, as I've said earlier on, is monitored with clear timelines, the risk assessed to it, the risk to prosecutors, the risk to witnesses, and importantly as well, engaging the judiciary, because we might be ready with those cases, but we will need courts for those matters to be heard and adjudicated with urgency, as well as getting our stakeholders on board. For corruption, DPSI, Intelligence Center, SIU, SARS, to take the profit out of crime so that those in charge of cartels are not making money while being prosecuting. So we will be attacking from all fronts, whether it's asset forfeiture, whether it's prosecution. We'll be, as soon as the matter is enrolled, ready to a plan to oppose bail, discussions with the judiciary when the matter will be heard.
Thank you very much. Ms. Maluleka.
Thank you very much. I'm curious about what you would do differently, because the matters about ensuring that there's good collaboration with all the different institutions that you've mentioned, that's, I think, well accepted as a principle. What would you do differently, and how would we know that you're doing a good job in that regard?
I would, if I were to be appointed, I would get an audit of the cases currently on the roll, manage those cases, have a clear plan, receive regular reports and monitoring upon it. In the Jocelyn Smith case and all our big racketeering cases in the High Court, that is what has worked. That there's a project, there's a team leader, that we get all the stakeholders involved, and there's regular monitoring of the progress that is being done, that the risks identified are being mitigated, so that when confronting with risk, we have a plan how to deal with it, to be always ahead of and anticipate what could be happening. I'm thinking now of the point that I've made of being a strong litigator. That skill is important when doing when being the strategic advisor. You must have vision, and you must be agile and adaptable as well. And you must be able to motivate the team, change management at times as well. And you must be able to pull resources together to be innovative. So this being a good litigator also means that you must be able to be a leader, to be strategic, to motivate and keep the morale high, especially when it's a difficult province like the Western Cape, where your staff don't feel safe in the work environment where they are, but they're still doing the job. Every day they're there. They're showing up. They're doing good work.
Okay. Proceed, Mr. Mdau.
Thank you, Chair. I hope I'm not elaborating the point and overflogging the horse, but I think the issue around how would you do things differently, strategically, to change the situation around, expecting that paradigm shift. But what I get from you is what is currently in place. Your specialization units, you've got specialized commercial crime unit that deals with commercial crimes. You've got sexual offenses courts or unit that deals with those types of crimes. But what I would want to hear from you is a strategic vision and a strategic shift from what we have, because what we have appears to be inadequate in dealing with these mammoth issues and tasks at hand. What would you come up, what type of strategy would you implement over and above what is currently in place?
I hear and I understand your difficulty with my explanation. One of the priorities of government in the medium-term development plan is building an ethical and capable state. That is, having institutions that we can trust, that are accountable, modernizing as well. I've already explained in the Western Cape how we are modernizing, how are we being innovative in mitigating the risk to staff, to witnesses by having virtual courts as well. Drastically changing the strategy of the MPA is not going to assist. What is going to assist is accelerating that. Yes, we've got the IDEC. Yes, we've got the appointments. How are we going to take it forward? By making sure that they have got the necessary resources, by being disciplined in how we execute our prosecutorial mandate. Yes, in sexual offences courts, there's development. We've got additional courts. We've trained prosecutors, and we've seen the results. So I wouldn't necessarily temper that, but it's now about constant monitoring and evaluation if we're making impact. And if we're not making impact, change the strategy. Be agile. Be flexible about that. It's about rapid implementation. so that we have that accountable, capable, ethical institution that the community can rely upon. By modernizing, keeping up with the pace of crime and criminals. That is what we're doing. It's not same old same. It's being innovative, trying different projects in different areas to have positive results. And that in the Western Cape has assisted, and it has yielded results in both our essential infrastructure and sexual offences. There has been an increase in the conviction rate.
Maybe let me just ask, I just want to hop on this one. You are saying if you are to intervene, for example, you'd put in place monitoring and evaluation to track the cases, to track the case backlog. Does that mean it does not happen currently? And I'm raising this in reference because you keep on going to Western Cape, but there isn't a sense you are giving us as a panel that, for example, as we work in NPA, head office will ask for us as the Western Cape that these are statistics that we have, there's intervention that we need to see, and therefore I will build on that. It's almost like it doesn't exist. I'm going to have to put in place, but if it does exist, why is not yielding the results? And what is different? I think the panel is trying to understand, Advocate Bell, what is different? Because the issue, as I stated, the statistics, and I can go to the statistics of national in terms of either the convictions and all that, because that is produced for the last 5 years. One can do average, and that's the public outcry that we need to see improvement. It's not only in IDEC, in all other areas that we need to see improvement. West coming to complex crime, that has to do with cyber crime and all those things, that now we've got to train and bring the NPO of the future and the prosecutors that are trained in AI. But these basics.
High-profile matters, Minister, I can assure you, are being monitored in the Western Cape. Nationally, each province has to give
Is it only high-profile cases?
And in the province, cases are monitored. There's outcomes. That's why we've got backlog cases at the regional court forum meetings, at the judge president. We have to account for our statistics and why it's not yielding results, whether it's infrastructure at some courts that's causing a delay. Do we move some of those cases? Yes, it is being innovative constantly. And I said it in the last...
Both DEC and PEC are in the provincial level.
In REC, but it all fits in nationally as well. I'm not sure if Minister is following me. Yes.
Minister,
okay, I just want to, if I can just jump in. So, as provincial head, you fit into the very top echelons of national leadership.
Yes.
You might not be in NDPP, but you fit as part of the key apex leadership of the national prosecuting.
Yes,
authority.
I am a DPP and I do fit in.
Yes.
Yes.
Could you maybe talk us through some of your own contributions at the national level and where they may have been implemented and how they then become a feature in places other than the Western Cape? Perhaps an example?
When I was in charge of the High Court role, we piloted pre-trial conferences. We piloted it first in the High Court, then in the regional court, and it was with the success. It was also replicated there. For years, the Western Cape divisions, plea and sentence agreements, receiving a just outcome was also one of the highest. Because of when I was still a deputy, the challenges that we have with sexual offences and making sure victims' voices are heard. With the support of the then director, I established a forum for sexual offences matters, where we discuss the challenges because of the concern with convictions. And that has been replicated throughout the country.
Thank you, Chairperson. It's the question about, nationally.
Yeah.
And one of the things of the NDPP is its independence.
Yes.
And you have stated your leadership skills and so on, and that you were a leader with regard to the staff, inclusive but also decisive. But there's also another factor externally, and that is influence and political pressure and other pressure. In terms of, do you have not a plan, but do you have a resolve as to how, when it comes to you, that you will maintain your ethical behavior and so on, so not give into that kind of, and protect the sacrosanct nature of the NDPP?
As NDPP, as public servant, my allegiance is to the Constitution and the rule of law. I account only to Parliament, who serves the people of the country, who represents the people of the country, nobody else. I have been at times questioned where I felt my independence was a bit questioned. And maybe I can expand on this a little bit. The Constitution and also the NPA Act makes it clear that the NPA decides on prosecution and the forum of prosecution. After COVID, the backlog in the High Court was exceptionally high. Because during COVID, and we could foresee this in our forecasting, we were only dealing with single accused matters. We had multiple accused matters on the trial. There was a new management in the jurisdiction of the judiciary. My advocates were questioned in open court as to why this matter is on the High Court roll. It affected, of course, confidence in the NPA in the area as well. Do we not believe in the victim's case? Have we not made a good decision? I addressed this with the judiciary. My concerns at the time were not well received, but I felt that my discretion and my constitutional mandate was being questioned, and it would have serious consequences. Section 179 of the Constitution and the NPA Act is clear. I had to convince the staff that we are in discussions with the judiciary and we are addressing it. The judiciary had valid concerns. Theirs is to effectively serve justice, ours as well. So we had robust discussions. For several months, we were almost at loggerheads, and that doesn't instill confidence in the justice system. But we were able, through working through it, to working through the stats, to breach that impasse. But I made it clear that certain questioning is not open for the discussion. Prosecuting is the mandate of the NPA. I'm pleased to say we're working very well with the judiciary in how cases are managed. They are responsible for case flow, that my office respects, and I am also respected for the decisions I made and at what forum to bring those cases. Because we view the High Court as a court of high impact cases. Bringing those Section 9, being a gang member, to expand the law on that, to expand the law on a child being sold. And if a child murder in the Western Cape or sexual offenses is what is impacting the safety of the community, it's at that forum that it must be held. Thank you.
I was going to say mine is a brief one. What is your definition of high-profile cases? I've heard you a few times say high-profile.
High profile is perhaps a wrong word. It is at the heart of what impacts the community. What would drive a community to feel safer and to instill confidence in the justice system? A high-profile matter might mean different things in different communities. In some communities, dealing with drugs effectively is a high-profile impact matter that affects the community. So it doesn't necessarily mean who the accused is, but it is how it impacts that community that the service is being delivered to. Prof. Iken?
Just for the record, you said you sit in the senior leadership of the NPA. How regular are such meetings where you all sit as the leadership? Do you hold them regularly so that you find expression and bring in your vision? If you can just take us through whether that has been functioning normally, regularly, at all times.
Since my appointment as acting DPP and DPP, and even when I know there has been at times monthly national operations meetings, but when the strategy is settled and we know what the work that needs to be done, those meetings are held monthly. The meeting with the entire NPA, with all the divisions, where it's not just NPS, National Prosecuting Services, that is held once a quarterly, where those issues are discussed. And if there's an urgent need for an issue to be addressed or finalized, a meeting will be called with the senior management to address that issue. For instance, when just before the strategy on dealing with organized crime were to be adopted, not all DPPs felt comfortable with the strategy and they wanted it to be more ventilated. So a special meeting was called to address the concerns that the DPPs had on that as well. So meetings are held regularly, yes.
Advocate Bell, you spoke quite a lot about trust. And in many respects, you were referring to it in terms of the trust that victims would have, right? But if you kind of zoom out a little bit and consider your own perceptions about the current levels of public trust in the NPA, what are those perceptions?
It is concerningly low. If you read what is there. And perhaps it's also because of the past, the MPA didn't communicate fully the excellent work that we're doing. I've picked that up in my interactions with community. We invite students to do job shadowing at my office, where I regularly interact with them. And often, early in discussion, I would ask, come and work for the MPA. We do this, we do that. And they're like, why would we be doing that? But once you unpack the services that we provide, the skills there are in the MPA, what an honor it is to serve, and what a noble profession it is, and the good work that we do. Beyond on just working in those court hours, but working with communities, doing outreach, perceptions change immediately, and there's trust that they see that we're human beings, we work very hard, and that we are a caring NPA. So also communicating what it is that we do and why it is important and why certain reasons, and provide detailed reasons accurate, and also not because of technology. It must happen almost as soon as there's an incident. We must be ready to communicate on that.
And maybe whilst we're talking about that, beyond communication, what else would you do to enhance the levels of public trust in the NPA?
Performance is key. Minister has pointed out sexual offences, the lag that there was in the Western Cape for quite some time, that it has improved. If you don't show results, you won't be trusted. You can bring a good news story, but you need to prove swift results where people feel it, to instill confidence.
I think that's helpful. The other thing you talked about is accountability as part of the narrative on trust. What would you do if you had to be appointed as the NDPP? What would you do to enhance the accountability of the NPA as an institution?
Accountability starts with good leadership, making sure that there are systems in place, that it's properly monitored, that there is, where there are transgressions, that it's executed upon quickly, but also lifting your staff morale, knowing that you would support them, that decisions have to be good decisions, and that we have to account for what it is that we're doing. And if you're not pulling your weight, that there will be consequences. So it's dealing with consequence management as well.
One of the criticisms, especially from civil society, of the NPA is how you deal with performance and accountability, transparency and accountability for performance. I'm not sure if you're aware of the criticism, especially around how you look at the statistics and how you communicate on that. What are your thoughts about that criticism, and is there something you would change?
For me, it is public education is also important. How we manage our stats as well. Stats and performance is important, but more importantly is that we are reaching the victims. We are not just statistics driven. We are about that your voice is heard, that you're treated with dignity and respect. We are not putting on the cases purely on the court roll because we will have a positive outcome. We make sure that there's reasonable prospects of success as well. And sometimes that is an acquittal. That is how the system works. But we need to be able to explain to community why there has been an acquittal.
Okay, no, thank you. One of the things around accountability, and especially around performance and perhaps other matters, is about being clear on to whom you account and when. Could you maybe share your thoughts on whom the accountability partners would be and how you would engage with them?
The balance between accountability, protecting privacy, and the integrity of a case, it's a very fine balance. And I think as prosecutors, we rather shy away from saying too much, and that might cause concerns about that we're not truly, or we're seen as to be not truly accountable. The NDPP was recently confronted before the commission when she didn't want to give details about a particular person. That is that balance of being accountable and protecting the integrity of the investigation as well. But we must be mindful of where our accountability lies. As I've said several times now, it lies with Parliament as well as with the public, that we are able to explain our decisions.
Thank you very much. Let's move to Mr. Mvundlela.
Thanks, Minister. I think to a large extent I'm covered. I wanted to just understand from you, Advocate Bell, that currently there's been an outcry, and I would call it an outcry in South Africa, that we have seen commissions comes and goes and all those, and people have been wondering to what extent is the NPA actually then taking these matters forward, and we have not seen, at least to a greater degree, perhaps the NPA from the head office point, and that's where you aspire to go, I believe. That's why you're sitting here with us. So how do you see yourself improving that environment, if at all? Perhaps it may have been discussed among senior management, as you have answered my colleague, the AG.
Yes, there has been a lot of commissions. Commission on state capture, corruption, and the NPA. What is the NPA going to do? I believe that my view is that the Zondo Commission, as well as the NACAC, the National Advisory Commission on Corruption, has laid the basis for what must be done to tackle corruption in the country decisively. The NPA now has the IDEC. The IDEC was established only last year. They now have the digital tools. They're trying to attract more skills, as I said, more investment to insulate them, to be able to prosecute. But the NPA cannot do it alone. There will have to be reform as to how corruption is decisively addressed in the country. Certain law enforcement agencies as competing mandates, how that is being addressed. So the NACAC's recommendations is key to implementing corruption, and all the stakeholders working together and even consolidating some of the mandates that there is. How the NPA will work is and we've seen it, asset forfeiture must be at the front of everything that we do, and we do it with urgency. Whether it's in your organized crime space, whether it's in your corruption space as well. And also having dedicated courts to hear these matters. In the Western Cape, we only have one commercial court. We've recently established a footprint in the Southern Cape. Those cases by nature takes long, and it causes a huge backlog. So there has to be dedicated courts where these matters will be heard. So it's the NPA, yes, leading, but everybody else must give support in us getting a case, because and what community often forget, these recommendations from the commissions are but recommendations. It has to be investigated. It has to be credible, admissible evidence before court, before we can take it to court. And the pockets of these suspects are usually deep. They come up with Stalingrad tactics where we need to change. That's why I talked about agility and flexibility. We need to be on top of it, change our prosecution plan, have the best of the best. The IDEC should be the center of excellence in the NPA. And that would be where I would drive, making the IDEC fully insulated, independent, and operational, as well as all the other forums where corruption matters are heard. There must be a clear plan how we're going to deal with those matters. And we must have, and there's the skills enhancement, the training has now commenced for our prosecutors to deal with cybercrime, money laundering, having the necessary technology available. We must be able to keep pace with the modern challenges that crime, especially commercial crime, has confronted us with.
Thanks. Given the big institution the NPA is. You now sit at the top and you have all this hierarchical flow of the institution itself. You are currently the head in the Western Cape. There is the head in Limpopo, Mpumalanga, and all over the places. How do you see yourself making sure that there is some kind of a uniform way of working throughout all these hierarchical layers of the NPA, because it can easily create a conflict.
That is why the prosecution policy of the MPA is key. It creates a standard of how prosecution decisions are made. That is where you have that standard, the norm. If you are arrested for drunken driving in the Western Cape, the same processes must be followed in Gauteng as well, where we have a standard. If there's a zero tolerance towards withdrawing domestic violence cases, it must be replicated across the country.
Thank you. Thanks, Minister.
Okay. Let's move to, I'm managing time now. Advocate Sipanya Mohale, your turn.
Okay. Thank you, Minister.
Your follow-up, you can wait and then you follow up.
Okay. I was just going to say, you know, as you're saying that uniformity in setting norms and standards, I would finish it off by saying, despite all that, or however, we still see poor performance. What would you do if you were to come in to deal with those, with the challenges around poor performance?
I would look at specifically where those poor performances are. Whether it's at a certain office, like we did with essential infrastructure. Why is that court not performing, but Wynberg is carrying the province in reaching it? What is happening there is, and we always start with ourselves. Is it the service that we deliver? Do we need to speak to SEPS and the other law enforcement agencies and have a clear plan there? It's about prioritizing the priority. Having focused, dedicated areas. We can't prioritize everything. And that's why the prosecution priority strategy of the MPA is important. In the Western Cape, murders are rife. We're struggling with sexual offences. Firearms is a problem. In Gauteng, mining, zamazamas, that is a problem. That is how you address it. And that is how you're being responsive to the crime in the area so that that community that we serve there feels safer.
Advocate Nisan, do you still have questions from your side? Thank you. Mr. Mutlo.
Thank you, Chair. Advocate Bell, now in response to challenges that you are facing in your division, there is a specialized court that you established in Khayelitsha. Did you establish?
The priority court?
Yes.
It worked wonders, but it had certain challenges. That court is no longer operational. The priority court initially started off as a drug court. The scourge of drugs was very high. Then it evolved to a court dealing with organized crime matters in the regional court. It was the same magistrate dealing with the same criminals. I am advocating, and I'm so glad you're asking that. So I'm hoping that my counterparts in the province will hear that we can replicate that in the bigger centers. I've spoken about the 12 stations that serves those courts, that we have a priority court at each of those centers to deal with the priorities of the community of that court services.
But you're saying there were challenges that led to that court
The challenges is that the same presiding officer, if I appeared in front of him today, I'm arrested for drugs, I appear before him because it's a gang case. tomorrow I'm arrested again, I appear again before you. So it's best to replicate it so that he doesn't know all the criminals in the organized crime area. And it's unrealistic to expect one court just to be dealing with all the organized crime in their division. We needed to spread that, and it's also, there were safety concerns attached to that. But it yielded excellent results.
But those concerns and challenges that you faced, didn't you foresee those challenges before you established that court?
It evolved. As I said, it started off as a drug court. It did brilliantly, and slowly it morphed into an organized crime, a court that basically just dealt with organized crime matters. I've had discussions with the regional court president to try and see, and she has made suggestions where we've placed cases elsewhere to try and address that. And when she looked at the establishment, she was fairly new in the province, that court wasn't an established court on the establishment of the division. It was a gentleman's handshake, and it worked well for everybody. But that is why it's important that systems not be dependent on who the leaders are at the current time, but that there are clear protocols in place for good practices like that to sustain.
Prof. Fiken.
Thank you very much. You took us through your almost 3 decades of career in the public service and also within the NPA. How would you characterize the institutional culture over that period of the organization itself? With all the changes that have been taking place.
There was the era of the dawn of democracy. And maybe I was, and it's not just because I was young and hopeful, but we were all excited and proud to be prosecutors, and we still are. I'm wearing my badge proudly. So on the lower levels of prosecution, nothing has changed. Yes, the morale is low. There's concerns about safety, and I might be, let me not say it, about salary, it has improved. So that morale is good. But as you move up higher, and we've seen at the previous interviews, there were concerns about the independency of the MP8. But there is a culture of working hard, of being committed. And I really want to pay homage to those prosecutors that work hard on a daily basis in very difficult circumstances. And that is where the face of justice is. It's not at national office. It's when you go into any magistrate's court, the prosecutors that serves you there, whether you receive justice. So there's a culture of working hard and dedication. There's some areas where you're correct, where there are concerns, and that needs to be addressed by principled leadership, accountability, and consequence management.
If you were the leader of the organization, how would you instill that ethical conduct across the organization in repositioning the organization?
The fact that we have the accountability structure of the Office of Ethics and Accountability is already assisting. I've looked at the stats that has been given. People are complaining. They're trusting the system as well, that their complaints will be addressed. It is also to show staff that this is our principles. We are the people's lawyer. Being the people's lawyer means serving with integrity, serving the people, and sometimes serving the people is even serving the accused, because we are officers of the court. By instilling that, and where that culture, that ethics is not followed, that there be reminders, that everybody knows what the strategy is, what we're working towards, and if there's transgressions, that there's swift consequence management and that there's reporting about those transgressions and how we've acted upon it. We need to build a more resilient prosecution team is one that trusts management, they trust the direction that we are going in.
In all those years, as a follow-up, have there been any divisions within the NPA that you have observed?
Divisions as to disagreement.
Not just disagreements where you deliberate, but where you say now there are divisions because there are blocks which take different positions at different moments.
There are robust discussions in the MPA where we feel are we ready to move in their directions. And that's why I say I am consultative. I rather hear the robust discussion from you. I am concerned about the ones that are quiet. Why are we not hearing from you? Are you following our direction? Are you being ethical and accountable?
Maybe let me follow up again. Have you observed during that period divisions, not robust engagements, which are rather professional, where you say during this period, I think I can observe disagreements within the organization? Or you have not witnessed any of that?
There has been at times when certain policy decisions or discretions from prosecutors have been taken away, that there has been disagreement. Where prosecutors question certain decisions. Disagreement on, for instance, and an explanation about how the TRC cases were managed. Previously, the TRC cases were managed in a dedicated capacity within national office. But since the NDPPs are coming to office, that was given to the regions, and it's been actioned and it's been worked upon. So yes, it was being questioned, and I'm sure that there was disagreement as well, and it's important work that the MPA is now accelerating upon.
Maybe as I conclude, there's just one thing that I can't leave without asking. You spoke about the issue of ethics and public trust, but also the perception. I listened quite interestingly. Now, you're saying that since the Office of Ethics and Accountability has been there are complaints that are going there, and therefore they're being dealt with. But also, we all know there's code of conduct of NPA that has been there. And do you think those are sufficient to deal with, for example, allegations and public assumptions or public perception that some of the prosecutors are corrupt?
And that is why the hearing, the concerns, and it's we don't know who is making that complaint. There's an anonymity in the complaints. It helps in addressing those concerns where there is, and I, even under the regulations, where I hear of allegations, I can now refer it to that unit to investigate that.
Okay, last point on that one. Do you think that all public prosecutors should go through lifestyle audit?
Definitely, Minister. And somebody told me that don't forget to say about the vetting and the lifestyle audits. That is key. That is where you will see the red flags, Minister. So we fully support that should be happening.
Let me hand over to Ms. Mmamoloko to take us through your public comments. It's your last segment.
Thank you.
Of your questions. I can see you are relieved.
Thank you, Minister. Advocate Bell, you'd be delighted to know, as you've seen, that the 9 comments you received from the public were generally in support of your candidacy. So there's not much to engage with because you've seen them and you've also had opportunity to reflect on them. I will use the time just to check on something with you. You talked earlier on about your triumph in having the dismissal of the case against Bongo reversed, right? Sometimes we try to learn from our losses and we neglect to learn from our wins. In an era where we are facing many more cases relating to corruption, many more cases that are sensitive and high profile, what have you learned from that particular case that you might want to bring forward in preparing for the future?
What I've learned from that case is prosecution must have a plan. We must present the court with all the evidence. So if we, and the courts must know, the educators, that we will challenge the outcomes if we are not happy. We've learned from that because previously, and it's very stringent procedure to follow to challenge a case. But it shows that, and it instills confidence that we're all equal before the law. It doesn't matter what the profile of the accused is. We will follow the letter of the law. We will take the matter on appeal. It doesn't necessarily, we're not influenced by who the presiding judge is. The issue is for us is addressing corruption and addressing it at all levels and instilling confidence that we will deal with corruption. We will not be defined by corruption in the country. It is unacceptable. It influences negatively the growth and the potential of our country. And it steals others of opportunities, especially the youth in our country with a high unemployment rate.
Thank you very much. I'm pleased to announce, Advocate Bell, that we've come to the end of your session, interaction with us. And thank you very much for availing yourself for this process and also for the work that you continue to do.
I just want to thank the panel for the opportunity. I am grateful. Thank you.
Thank you very much. Thank you. will assist you, should you be appointed as an NDPP?
Certainly, Minister. Of course, like most law graduates, I did a BA with legal theory as one of my majors. My second major was economic history. Of course, the BA degree lays a very good foundation for individuals who want to proceed to the LLB. Thereafter, I did the LLB, the Bachelor of Laws, dealing with the full spectrum of courses required. And that is obviously the pathway into the legal profession. And so that served me well in terms of getting into law as a practice. You would notice, Minister, that I have international studies as part of my studies. Just to explain that, I always thought if for whatever reason the law didn't satisfy me, I would want to go into the diplomatic corps and serve South Africa in the diplomatic corps. And so I was fortunate enough to be able to do the postgraduate diploma and thereafter the MA in international studies. And although not relevant to law, it does, in my view, build the candidature that I present. One has to conduct research in doing that. It's different to law, it's a different field. And it broadens one's horizon, and it certainly contributed to my development. Fortunately, I haven't had to use my international studies. The law as to date has satisfied me, and so I'm still committed to the law. Maybe, Minister, just to alert you to you notice that I had 2 degrees in 1 year, and I'm sure that would have intrigued the panel. Just to explain, and not many people know this about me, in my final year law, I failed 2 subjects. And I thank the Lord for that. It's an unusual statement to make.
I was about to say, that's quite interesting.
I thank the Lord for that, because the next year, a lady came into my life. And she's been with me for 35 years. Yesterday, we were married for 30 years, and I couldn't be with her. Fortunately, she understood my commitment to the country, my dedication, and my desire to serve. And so she agreed for me to delay my departure. So my wife and my son has departed on our vacation. We had planned to celebrate our anniversary, and I will join them tomorrow.
So I did share with the panel that we had to adjust your scheduled date of interviews so that you can be able to talk.
So I really
thought
wish
it was
to
still coming, the anniversary.
I wish to
anniversary.
thank you for that, Minister. And then after international studies, I started working. Whilst employed, I had the desire to still advance myself and continue my studies. And so you'll notice that I did two master's degrees. The first one in criminal justice and criminology, once again, gave me a very, very broad range of skills. The focus on criminology in particular gives one an understanding of the environment one operates in, the criminal mind to an extent, and it really served me well, and it serves me well in the discipline of law. My thesis for that particular master's degree, I did it on correctional supervision as a sentencing option, and I did my research at the Cape Town Corrections Office. The MPhil, everyone always asks me why an MPhil. To be honest with you, I didn't want to have a second LLM, and so I chose to do the Master of Philosophy in Law, and there I did my thesis on the asset forfeiture provisions and doing a comparison with the United States in terms of what we have available in South Africa. And I was fortunate enough to have someone who had assisted the asset forfeiture unit in South Africa with the development of our processes to act as a reference point. And so I did that. I'm not going to specify the MA International Studies, Minister, unless you wish me to say what the thesis was on. Maybe I should say what it was. I did my research on the African National Congress as a non-state actor at the United Nations, covering a broad period from the 1960s up until just before the dawn of democracy. In that period, and I tried to draw on the experiences of non-state actors at the United Nations and the role that the ANC played in that regard. That was my thesis for the MA International Studies. So, Minister, coming back to your initial question, I think all of those qualifications have contributed to the person that I am, to the candidature that I present. And so, yes, in each in its own way is a constituent part of who I am. Thank you, Minister.
Thank you very much. With that, moving on, looking from the qualification, because we're trying to ensure that we get to know you as the panel, but also the public gets to know you as well.
Certainly.
Your experience as a prosecutor. I'm noticing that you started as a public prosecutor, both in Kimberley and Makhanda, from 1992 until 95, becoming a state advocate under the Office of the Attorney General, Western Cape, 95 to 1998, senior state advocate, Office of the Attorney General, Western Cape, 98 to 90. Or 1998 as well, so it's July until October. And then you became, as NPA was established, became senior state advocate in the ID Investigating Directorate, Organized Crime and Public Safety, in 1998 to 2001. Deputy Director of Public Prosecution Asset Forfeiture, 2001 to 2003. Deputy Director of Public Prosecutions, Directorate of Special Operations, 2003 to April to October. Deputy Director of Public Prosecution, Directorate of Special Operations. The other one was regional, this one head office. November 2003 to March 2004. Senior Deputy Director of Public Prosecution, Regional Head, Directorate of Special Operations, 2004 to 2009. Senior Deputy Director of Public Prosecution, Western Cape, from 2009 to date. So your experience in terms of prosecution is vast. But tell us, how many people have you been managing in these areas? I'm looking at the others, looks quite junior. But as you go in terms of being the senior deputy and others, how many have you been managing people?
So the highlight, Minister, for me in terms of that managerial experience, in terms of numbers and volume, was when I was the head of the DSO, the Scorpions. And there, our staff complement in the Western Cape were 101. And it comprised of different disciplines. Obviously, there were prosecutors, because that was a main component, investigators, junior and senior investigators, analysts, crime analysts. We had a crime analysis division. And so we had junior and senior analysts, and of course the traditional administration that supported the work that we did within the DSO. When the DSO was dissolved, the prosecutors that were part of the DSO were integrated into the Office of the Director of Public Prosecutions. And so my role changed fundamentally. So from having been responsible for 101 people, all of a sudden I was responsible for 5, 6 people, 7 people, 8 people a year. So the role of the deputy director is different from a regional minister, and it's a strange construct because you are a manager, but you're also a lawyer. So it's a unique role. It's not a manager in the typical sense of the public administration. Of if you're at a particular level, if you were deputy director, you will have X number of people below you, director. It's different, and even describing being in charge of the people, it's a bit of a misnomer, because you may have someone reporting to you for performance information purposes, for performance reporting, but you may see only a sample of their work because of the checking system. The checking system is one where when files come into the Office of the Director of Public Prosecutions, normally 2 people are assigned to it, a junior and a senior. And so even though there are seniors who report to me, I might not even see that file. It's just the way the system is structured. And so I always try and illustrate the point that the fact that you don't have a large number of people reporting to you doesn't diminish from the role that you play. Because firstly, the role of the deputy, in law, you have the same power as the DPP. Obviously, the DPP is the head of the office and gives guidance. But your role is a critical one, supporting the activities of the Office of the Director of Public Prosecution. And that role does not require or necessitate you to be responsible for large numbers of people. Because when we try and set up what we do as an organization, you don't direct the 6 or 7 people that are part that report to you. You direct the operations across the board within the organization. And so the fact that I've, in the recent past, only managed a lesser number of people, I say with respect, doesn't detract from my candidature. Huh?
Currently, how many do you manage?
It's about 7 as well, Minister. Senior state advocates predominantly, 1 senior public prosecutor, who's placed in the DPP office for a particular purpose. It's not usual to have a senior public prosecutor in the office of the DPP or the Director of Public Prosecutions. This individual has been appointed to deal with the Community Prosecutions Initiative. And because it is still novel in the organization, in consultation with the DPP, we decided to keep the person at the DPP office working under my supervision until the initiative matures, until we form a particular view on how to expand the initiative or reconsider our position on the initiative itself, depending on the practicalities.
I got intrigued by where you reflect that you are a member of the National Joint Task Team that was overseeing the aspects of transition to a new structure from the DSO. Do you want to share that with us?
Yes, certainly, Minister.
And I'll say this in context that NPA is evolving over time with the introduction of IDEC and all this. So there's transitions that are happening. So if you can share with us.
Yes, certainly. And sometimes it feels like a bit of deja vu when I see the IDEC coming back into being. Certainly, Minister. Look, that the decision to dissolve the DSO, and I say this in the questionnaire, was quite an emotionally charged one for many members of the organization. And I think I was fortunate to be part of that process. So our leader, the NPA had a lead of delegation, as well as team members. I was a team member, and Advocate Willie Afmeyer, or Mr. Willie Afmeyer, he always reminds us he was always missed because he was an attorney. He was our leader. For the police, General Nchure was their leader, and together with various members. And essentially what we tried to do was to try and envision as the collective what we thought the new structure should be. It was clear we had made peace with the fact that the DSO was no longer to be, and the idea was to try and ensure that how do we dissolve one institution, one structure, create something new, but not lose anything in the process. So that when the new organization sets in or kicks in, it's a seamless transition. Obviously, we were concerned that some investigations were still pending, and so we tried to manage that. A key part of that process was the change management. In particular, what would happen to investigators. As I said earlier, as the lawyers, not much changed. A lot changed, but not much changed, if you understand what I mean, Minister. For example, my office didn't change. I remained in my office. So simple things like that didn't change. But for the investigators, for some of them it was a daunting task, because the DSO, panel members will recall, was comprised of senior investigators who had spent a lot of their career in the police and had been brought in for their expertise. But we also tried something different. We brought in university graduates, mostly black, skilled, excited, wanting to contribute to the safety and security of our people, and they were confronted with this dilemma, but going to the police. Because for many, it's inconceivable for them to have wanted to be in the police. The DSO represented something different, something aspirational, and they did not see themselves in the police. Some of the senior police officers as well, or former police officers, they themselves had concerns about going back to the police. Because you'll recall, Minister, there had been some tensions between the police and the DSO, and many of them were fearful that going back into the police environment, they would be victimized. So these were the kinds of concerns that we had to try and address, sought assurances from the police that wouldn't happen. And eventually, I think with some success, we were able to manage the transition. Of course, we, as the DSO representatives, we were negotiating. Truth be told, we were negotiating on the back foot because we were the ones closing down and the police were taking over the DPCI. But we tried to bring some of our thoughts, our suggestions, and it was for them to accept. All we could do was we could offer the advice, reflect on our own experiences, and share with them what we thought should happen in the new structure. But ultimately, it was there. So, and as I say in the questionnaire, it was a taxing time, Minister, traveling through the country, confronting people, looking them in the eye, and trying to give them assurance. And I think the key thing there was we were honest with our people. And I say our people are the DSO members, because we couldn't give them some of the assurances that they wanted. Because as soon as the one door closed and the other opened, we had no control. So we gave some honest reflection. And ultimately, it was for individuals to decide to join the new structure. Many chose to go. And I'm proud to say, Minister, some of the very best in the DPCI in the Western Cape now came from the ranks of the DSO. And I'm not diminishing the contribution of other members. I'm merely reflecting on, fortunately, there were some of the good people who remained, who stayed true to the cause, wanted to work, wanted to make a change, and they decided, despite all of their concerns and the fears that they had at an individual level, they continued with the journey, they joined the DPCI, and many of them are making a tremendous contribution to the safety and security of our people.
Thank you very much. And moving on your leadership style or management style, you describe it as a style that is inclusive and consultative, grounded in the belief that people deliver their best work when they are meaningfully engaged. I found it quite interesting because I think that's what Advocate Bell as well said. Maybe share with us.
So Minister, mine is grounded in my background, and I won't go all the way back to school where I served as deputy head boy. But at university, I was fortunate enough to form part of organizations where the culture was one of engagement, reflection, striving for the best, and that has remained with me. It's also my nature. I am never one to pontificate. I am never one to assert a title. I always try and use influence. And so from those formative years as individuals at university, in various structures that I served in, that's been the culture, and that's been my culture. And it's innate. And sometimes I'll sit in a meeting and I'll observe someone and I can immediately tell that that person doesn't share the background that I share because of the manner in which the person is conducting him or herself. Doesn't have that sense of how you engage with a group of people, how you try and build consensus firstly, ensure that people's views are respected, because that's empowering. If you create a platform where people feel that their views are heard, respected and valued, that's empowering. And often you find that some of the best ideas come from individuals. And so if you shut down dialogue, if you close that door, how are you going to do what the best amongst us? And it's part of my style. It's what I've always done. It represents who I am, and so I don't turn it on and turn it off. It's there. It's a permanent feature of my being.
So of the 33 years as a prosecutor, 24 years have been in management.
In management, that's correct, Minister.
Correct, okay. Now we move forward into the next segment of that, and we deal with the issues around that. If I can confirm that you do not have you've not been taken to a DC, nor are you currently facing any inquiry or investigation by the Office of Ethics and Accountability?
Not at all, Minister.
Not at all. But you have been reported. There's been a complaint. Take us through previously.
That's correct, Minister. So as you read from my background, Minister, I was the head of the DSO, and the DSO as I said earlier, was dissolved in 2009. And so we transitioned into the Office of the Director of Public Prosecutions. At the time, the DPP was Advocate de Kock. So in 2013, I received a letter from the chairperson of the disciplinary committee, the Bar Council, alerting me to this particular complaint. So firstly, obviously surprised, read through the complaint. I noticed that it reflected incidents that happened in 2005, 2006. So obviously I immediately presented this to Advocate de Kock. And I then went about preparing a response to him. So just for the benefit of the panel, what had transpired is a member of the public had complained to the Bar Council asking for me to be investigated. And the allegation was the complainant felt that I had not dealt with a complaint that she had made against a member of the DSO. She felt that I hadn't dealt with it with the necessary, as I should have, that I was dismissive. And the essence really turned around how I dealt with it. And she felt that, firstly, I didn't do enough, in her view. And she felt I should be censured by the Bar Council for that. And so I wrote a very detailed note to Advocate de Kock explaining exactly what had transpired. And what had happened, dear Minister, and of course I've refreshed my memory from the historical documents as well. I recall receiving a letter from the head of the DSO, at the time was Advocate Linda McCarthy, and the letter to me was basically an instruction to me to ensure that the letter, together with the complaint form, and the complaint form was a pro forma form which forms part of the NPA policy, that the complaint form be served on the complainant, and that the complainant be requested to transmit the complaint to head office. And so I arranged with one of the senior investigators, Mr. Haywood. I see Mr. Haywood's signature was on the document. Mr. Haywood then went and served the document on the complainant. So that would have been in January 2006. We heard nothing from the complainant. And then in February of that same year, I saw an article in the Son. I must say I don't read the Son much, but I still read the Voice. You know, the local tabloids gives you a sense of what's happening on the Cape Flats, and so it's a good source to get a temperature gauge of what's happening. And I was surprised when I saw the story, and I recognized the name of the journalist. And then I reached out to the journalist and asked her to facilitate a meeting. And unfortunately, the journalist is late now, Ms. Mendes. She did that. She arranged a meeting. The complainant, together with the mother, and Ms. Mendes came. And my thinking there, Minister, was, so our initial approach didn't work. We sent out the questionnaire, and there was no response. Clearly, the complainant had built up a rapport with the journalist. They'd been able to share her experience with the journalist, and I thought that would be a gateway. And the request was for the journalist to facilitate obtaining the form so that the form could be dispatched to VGM. In terms of the policy, Minister, I had no role, and in fact the policy was quite clear. The letter said to me, serve the document on the complainant, and as the supervisor, you're not to be involved in the matter. And so my role was not involving myself in the matter. My role was facilitation to try and ensure that the complainant filled in the form so that the process could unfold. Nothing happened so far as the journalist was concerned. I sent a follow-up email. Nothing came from the journalist. Thereafter, I recall that it was maybe I shouldn't mention the name, but the public representative at the Office of the Public Protector had written to me. And the complainant had written to his office to complain about the service delivery aspect of what she described as an investigation. And I thought, here's another opportunity now. In my own mind, I thought the complainant clearly is not engaging with us. My own endeavors to engage with to build a rapport and to unlock clearly hadn't worked. And so I requested the Office of the Public Protector to facilitate that, for them to engage with the complainant, get her to fill in the form, and then for them to transmit it to the DSO head office. Unfortunately, that also did not yield any results. And so that was the end of it until I received the complaint in 2013, some 7 years later. Of course, Advocate de Kock had considered my explanation. He wrote to the Bar Council saying he found that there was nothing in my conduct that warranted disciplinary action, and communicated same to the Bar Council. The Bar Council, I know, wrote back to the complainant, basically saying they're not doing anything, and I'm paraphrasing now, Minister. And that was the end of it.
Yes. No, thank you very much. We did receive the attached documents and the letters that relates to the matter. Going through again to the next segment is your contribution as per the questionnaire that speaks to your role in the work that you do, contribution in terms of law, but also in terms of access to justice or justice in pursuit of justice in South Africa. Any project, I see you've got quite a number of them that are written under your work as a leader of the collaborator.
Yeah.
Anyone can pick anyone specific just to share. As I said, we're getting to know you.
Yes,
to
Minister.
understand your leadership style, to understand your management style.
Could I go to the one on page 19, Project Mir, Minister? And in the bigger scheme of things, it was not a national story. It wasn't as big as LeisureNet. It wasn't as big as Pedentia. But when I was approached to consider authorizing the investigation, what struck me was here is a small municipality, a limited budget, and yet the officials there, political office bearers and officials, are dipping into money that could serve a community. And so it's not a typical DSO case. It's probably considered low value if one has regard to the value. But in my own mind, Minister, I thought, if we are able to effect change and to demonstrate to that community that it is not acceptable for officials and office bearers to have access to the money, it would send a powerful message. At the time, Minister, I say this in the questionnaire, I was responsible for the Northern Cape and the Western Cape as the head of the DSO. And so we did several investigations in the Northern Cape. And so that to me was a significant matter. As I say, not necessarily front page news. It may have made the Diamond Fields Advertiser in the Northern Cape. But I felt that the contribution and the impact we could make in such a small community would instill confidence in our people that law enforcement, that as the state, we care for them, and that we share their concerns, and to demonstrate that people must be held accountable. James as well. Maybe I can talk about James, Minister. And James. Of course, there was a lead advocate. I played a supporting role. I was involved in some of the negotiations. But there again, we were able to, as part of the process, to ensure that workers, maybe just for context, so the union and the union leadership were channeling their members to a particular company to take out loans. And of course, the interest rate was exorbitant. And let me say the allegations were that there were kickbacks. So, in our discussions with the company, eventually when they settled on, firstly, made peace with the fact that they were going to admit guilt, we were able to ensure that 60 million rand went back to workers. And because we had records, as part of the investigation, we had uncovered the records. So they knew, for example, Mr. ACM had received a loan of X amount. We were able to calculate the interest that the individual had paid. and we were able then to work out that Mr. ACM would get back, say, 20,000 rand. But cumulatively, it amounted to 60 million rand that was returned to working people. And so there again, a case where we were able to demonstrate that we are able to affect the lives of ordinary people, not just the big names. Of course, the big names are important, and the fidentia is important. Fidentia, Minister, was finalized or concluded after the DSO was dissolved. And so J. Arthur Brown was eventually sentenced on appeal from the state to the SCA. But that had happened afterwards. But a lot of the initial work we had done as well, and you'll recall, Minister, there as well, it was the money of orphans that were basically looted. So yeah, I'm very proud of that history and what we were able to achieve as the DSO Minister. I think we were able to try and achieve at a high level, deal with white-collar criminals. I wasn't in charge when we dealt with some of the other phenomena, some of the violent phenomena, so I don't lay claim to that. But these are the ones when I was heading up the organization, and I think it contributed to the kind of impact that we made as an organization.
Okay, moving to the next segment, can I confirm that you currently have no directorship, hold no directorship, nor any business interests?
No, Minister.
Not at all. Okay.
We're conservative by nature, and it's always been my view that I work, I earn a salary, and I spend what I earn.
And also, can we confirm in terms of health-wise that nothing precludes you or will be impeded?
Indeed, Minister,
you
nothing.
Your office. Okay.
But sorry, just take you back. I mean, it's not a directorship, but I did disclose my involvement in a bursary fund. I think I did disclose that in the bursary fund, the Rhodes University Black Students Alumni Fund. I'm not a director. I'm a committee member.
No, it's not in the disclosure.
It's not a directorship. It's not a directorship.
What is it?
It's a bursary fund. In my character reference, Lincoln Marley refers to it. Lincoln and myself, and together with another friend, we serve on that. It's not a directorship, it's a committee. We raise funds. We support black students who study law at Rhodes University, but it's not a directorship. So that's why I didn't disclose it as a directorship.
Okay, what is it?
It's a Section 18 vehicle that we've created so that we source funds from the few of us.
So you fundraise?
We fundraise amongst ourselves.
Or amongst yourselves?
Amongst ourselves. We have, each one is meant to give a particular amount every year. Some are generous, they give a bit more. Sometimes one struggles, including myself, and you give a bit less. But yeah, it's an initiative we've run, and we've been fairly successful. It's been, I think Lincoln reminds me, we've been doing it for 19 years, Minister.
Wow, that's impressive. Thank you. I think that's clear. I'm done with the questionnaire, and we'll move to the next segment, which I will start leading, and members of the panel will follow on that one. Okay.
Just one follow-up. Advocate Mopp, how are you?
I'm well, thank you. Yourself, sir?
I'm good, thanks. Between you and Advocate Bell,
Yes.
who is senior in the ranking of work?
Interesting question. At some point in the past, I was a senior, but now she's my senior. I report to her, and I support her in her endeavors.
As matter stands, she is your boss.
Yes, if you want to characterize it as that, she's the head of the organization, and she leads. I account to her, yes. I signed a performance agreement with her, and yeah, she's the head of the office, and I'm in that office.
And you are recommending each other for this position?
Well, it's interesting that you asked that, because when, I'm not sure how much I should disclose now of what you said, but when
about that statement. That statement.
No, I'm going to clarify now, Minister.
Take your time, just be calm.
So the context is important. We had a senior management conference a while back, and I pride myself when I go to. I may be based in the Western Cape, but I see myself as a leader of the organization. So the fact that I'm based in the Western Cape doesn't deter me when I get to a national platform to express myself and tell people what I think. That everyone in the organization knows me. Some may think I'm too opinionated, but if you don't speak, no one will know what you think. And so I do that. And at the conference, and it's no reflection on my colleagues and my peers, but I came to the realization that I have something to offer the organization. And that if the opportunity arose, I would avail myself. And I had a conversation with her. When the announcement was made that nominations and applications had to be made, I went to her and I went to see her. And I didn't ask what she was going to do. I came to tell her, or I went to tell her that I'm going to avail myself. She reflected on it, and I mean, eventually she's here, she agreed to it. But from the word go, I thought, given my contribution to the organization over the years, given what I see as a need for leadership, confident in my own ability, that I can lead the organization, I've presented myself. So that's the context. I didn't need to ask for permission. We had a very good conversation about it, and she knows I support her unconditionally, because it's not about me and the title or her and the title. It's about the work that we do and what we can do to achieve and meaningful differences in the lives of our people. And so that's what motivates me. And yeah.
No, thanks, Advocate Mopp. I just wanted to get that out there because earlier we asked Advocate Bell about it, and I just thought perhaps we should also get it from you. From
there is
that
a follow-up on it.
perspective.
Don't close it.
Thanks.
Prof. Fikeni, I can hear you want to close it.
Yes. Is it something common that you would recommend each other for any other role? And as such, can you share with us the discussions and the motivations that we should motivate for each other?
Well, maybe I should characterize. So I am here presenting my candidate. I'm not here recommending Advocate Bell. let me clarify that first and foremost, in case there's a misconception.
Yes.
So I think maybe where the not misconception, but maybe where the need for clarity is, the managers in the office, they got together and they had a discussion. Myself and Advocate Bell weren't part of that. They had a discussion, and amongst them, they've decided they're going to support both of us. Each individual made their own decision. In fact, I didn't even try until very late to see who signed it, because to me, whether someone had signed or not, it would not be a reflection of my interaction with that individual and the work that we do as a collective. So it was not a strategy between Advocate Bell and myself to say, okay, let's position ourselves. You do this and I do that. No. We had a discussion one-on-one because I wanted it to be clear. I wanted her to understand the fact that I'm presenting myself doesn't mean that I'm disregarding her. She's still the DPP, and that's why I say, and she knows unconditional support. And whatever the outcome here, I've said to her as well, if nothing comes of this for me, she knows I'll be back there doing exactly what I do every day, supporting her, because supporting her is not supporting her as Advocate Nicolette Bell, it is supporting the work that we do as the prosecution. So that was the discussion. So it's not... we're not trying to lobby here saying, okay, if there are two of us and there's six altogether, then what are our chances together? No. I want to clarify that. It's none of that. It's the managers who had independent discussions and who decided to support both of us.
Thank you, Minister. Mine is just a point of clarity. You were a state advocate in the Western Cape office 1st of May 95 to 30th of June 98. And then, this is senior 98, but for senior state advocate, it was 98, July and October. So you were senior for 3 months, and then senior for 3 months, that's fine.
Could I just clarify that for you,
if you could clarify.
Mr. Panyamacholi? So I became a senior in the AG's office, as we call it, the Attorney General's office.
Okay.
But then the transition had happened, the NPA was formed, and we used to call it IDOC, the Investigating Director on Organized Crime and Public Safety. That opened up. And Percy's son had been a deputy in the office, Deputy Director of Public Prosecutions. I think the panel will recall the legendary Frank Khan used to be the Director of Public Prosecutions, and Advocate Percy's son was one of his deputies.
Oh.
And then when the NPA was formed and Mr. Nguka became the NDPP, he drew Advocate Son into the Investigating Director on Organized Crime. So that structure opened up, and I essentially transferred in the position of a senior from what is now the DPP office to the Investigating Directorate, and continued as a senior in that environment. So no longer in the what we call the DPP office now, but in the Investigating Directorate. And there, different to the Scorpions, there we were prosecutors from the NPA with police officers who were seconded from the police. In other words, they were part of the police. They had a police commander. At the time, they had which is the equivalent rank of a brigadier, who was their commander. And so that was the difference. The police, we worked together, but the police had their own command structure. We had our command structure. And then when the DSO was formed, there was a single command structure. And in the case of the DSO in the Western Cape, I headed up that component.
Thanks. Mr. Mtlo.
Thank you, Chair. I'm covered. Thank you.
Oh. Okay, we'll move on to the next segment. The first one I want to raise is, because this position is national, and looking at your CV, your footprint is only in the Western Cape. Mm-hmm. How would you be able to ensure the organization in terms of exposure to deal with all the issues that relates to the provinces, different priorities in terms of those in those provinces, and your understanding of the challenges that we currently experience nationally?
Minister, and I am a humble person, but I must say, I think it would be seamless. I think I've been fortunate in that the roles that I've played at a provincial level has given me lots of exposure. It's not something new for me to have meetings with ministers, national ministers. I've been exposed to that. Provincial ministers have been exposed to that. It's not new for me to be exposed to the National Commissioner of Police, senior police officials at a national level. I've been involved in those kinds of engagements, or certainly have been exposed to that. Maybe not formal meetings with the National Commissioner. I don't want to overstate that. But when Commissioner Tim Williams was the commissioner, just to give you an example, I had a conversation with him about the provincial commissioner in the Western Cape, sharing my own views and my reflections on the provincial commissioner, telling him that I thought that particular commissioner was one of his best commissioners. So I'm not going to be starstruck coming to the national scene, Minister. As I say, I'm confident in my ability. And I think I can interact well with people, and I say humility because it comes back to my leader's philosophy. You must be able to speak to people, engage with people, build a rapport, and of course it's not to become friends, but it's about the professionalism. Each one exuding their own professionalism, and ultimately it's about the work that we do. As I said, I've been involved in national engagements. I've been involved in national task teams. I've been involved, I didn't put it in the CV, I've been part of national investigations, myself, a member of state security, and a member of police. I did an investigation many years ago. So I've interacted with people at various tiers. And I'm confident that it's not a step too far for me to do that. In terms of what the issues are, Minister, I lie awake at night worrying about the future of our country. I'm sure many South Africans do. I've now resorted to listening to a podcast at that time of the morning to try and get myself back to sleep. But I'm concerned about the future of our country. concerned about the threats that we face as a nation, the threats we face as the criminal justice system. And I'm in the prosecution because I want to make a difference. And that is why I'm availing myself, because I think I can make that difference. I can be part of that positive change. What I represent, I think I can do that. If one looks at what's happening at the Commission, Mmamoloko Commission, what's happening at the Ad hoc Committee, the picture is not very good of the criminal justice system as a whole. And so we need to change that, Minister. We need to change that fundamentally, because our people must have confidence in our ability to effect the change in their lives that they want. But it's not just about talking and explaining that to them. It's also about demonstrating to them that we are able to do that. And that is why I think the imperative for all of us in the criminal justice system is to get ourselves, to get our house in order, ensure that we have ethical, credible leadership who are committed to the cause and only to the cause, no other considerations, because there's work to be done. And some of these issues are detracting from the good work that is done every day by good police officers and good prosecutors. And so everyone is tainted with a particular brush. And so that's why it's important for the leadership to change that narrative. You know, Minister, I said earlier we're conservative by nature as lawyers. And I've been one of those who've been very reluctant to engage the media too often. But even I have come to the realization that we are being overrun in that space. We're being overrun in the space. People are saying what they want to, they're spreading falsehoods. And so there's a need for us to change tact. And I'm one of those, maybe belatedly, but I think we need to claim that space. And it starts with the good work that we do. Now, the media, if I can just speak a bit about that, it's contested space, because sometimes we do a lot of good work and you see none of that. So we do 9 good things, none of it's in the media, 1 bad thing, and that's front page news. So it is about trying to get the balance. And we've got to find ways of communicating directly with our people. One of our senior colleagues suggested in our meetings when we discussed it at some point, but why don't we take out adverts ourselves? Take out 2 pages on the newspaper and tell the good stories. Not a bad idea. I'm not sure what it would cost, but that maybe is an option. But I know there's youngsters these days, or young people, let me start with youngsters, young people these days, they consume media differently. So maybe there are other avenues to explore for us to try and ensure that where we do good, people hear about it, they see it, and where we don't do well, we explain what happened. Because that will also instill confidence. At least if we acknowledge we've done wrong and that we intend to correct that, that should inspire some confidence as well. Yeah.
You've reflected on one area more around communication, and I want to maybe package it together, because what I'm trying to get is your vision for the NPA. What is it that you're going to do differently? You've highlighted the challenges, the commissions that we are seeing, the ad hoc committees, but also one wrong thing done is in the... What would you do differently?
So let me start by saying, Minister, so without giving you a long convoluted sentence of what I see, what are the anchors that must underpin that? One is the starting point is obviously independence. And to demonstrate, because there is the narrative still that the NPA is captured and the NPA is this and the NPA is that, is to demonstrate that our decisions are only informed by 2 things. It's the law and the facts. And that communicating those decisions is one way of doing it. And so there must be a clear understanding that those are the only considerations. Anything extraneous to that is ultra virus. So firstly, that's the first thing. It may not be different, Minister, but it's a question of reinforcing. Once again, in the context of some of the noise, and I'm not saying noise because it may sound demeaning, but of the concern. Let me say the concern that people have that the NPA is not independent. And I'm talking about decision making when I talk about independence, Minister. The second one is I've touched on this, the question of ethical leadership. And it's interesting that one of the critiques against me by a member of the public was that have I been subjected to a lifestyle audit. So that's an initiative that I welcome and endorse. Because if the view is that a person who has been subjected to a lifestyle audit is more credible than one that is not, then we must embrace that. Because that's part of instilling the confidence that we want to have. But it's more than just that document saying that you're fine. It's also your conduct, how you conduct yourself to ensure that we are an ethical organization. Then, the coming part of that is being a capable organization, Minister. And so there, I have some ideas about how I think we can change things. Firstly, before we develop the NPA to be capable, there are a couple of prerequisites in my view, Minister. The first is we need to stabilize the leadership tier. To stabilize the leadership tier, because the NDPP is leaving now. The Cox post is still vacant. Sis Oma has left. Her post is vacant. Someone is acting. And I believe there may be other changes as well at that senior leadership level. So we need to stabilize that. The second thing that I would want us to settle is, what is our operating model as the organization? What is our delivery model? We thought we had settled this question a while back, but there's still murmurs in the organization about what is our operating model. And what do I mean by that? Where does delivery take place in the organization? In my view, the delivery vehicle of the organization is the office of the DPP. That's the delivery vehicle. So prosecutions result under the DPP, and so we must reinforce what happens there. So why is that important? If we agree, of course, this is my view, Minister. We'll have to engage internally about whether my view prevails, but I have a very strong view that that is the model. The DPP office is the delivery vehicle of the organization. If we agree on that as an organization, then the question is, what role does head office play to support the DPP? Because the NDPP must play that role. Because if we disagree on the delivery vehicle, we need to have a different capability at head office compared to the one that I have in mind. And so we need to settle that. Once we settle that, then it's a question of how do we ensure we have the capabilities to deliver then as an organization. So let's start at the DPP office. Firstly, we need to ensure that we not only are able to deliver in specialist environments, we also need to deliver within what we call general prosecutions. The normal prosecutor in the regional court, that's the bulk of us. And why is that important, Minister? My concern, and it's not only my concern, there are others who share the concern as well, is that the congestion in the court system at the moment is of such a nature that prosecutors in the district court are hardly litigating. So what happens there? People pay admission of guilt, there may be a plea, and so you don't have a prosecutor being exposed to litigation leading evidence. So what's the consequence of that? Now that individual must learn to litigate in the regional court. And we can't afford that because the regional court is where we deal with serious matters. You must have the basics as a prosecutor when you get to the regional court. Yes, you can refine your skill there, but you can't learn to prosecute in the regional court. It has an ancillary effect, Minister, which I'm just going to mention and park there because it's not part of what I need to do as someone who aspires to be the NDPP. If a district court magistrate is not litigating, is not hearing evidence, and goes to act in the regional court and has to hear evidence for the first time in the regional court, it has consequences as well of the quality of decision making you get into in the regional court. And as we know, the regional court is a very important forum. The High Court may get all the glamour, but the regional court is really the engine room of dealing with serious offences in the country. So it has that consequence. So one of the things that we are doing as an organization is we're bringing back the tutor, and the tutor will play a role with the aspirant aspirant prosecutors. I want to broaden that role to see to what extent.
Explain it more, because we do have currently the aspirant prosecutors program. So
yes, maybe just to give it a bit more detail, Minister. So the panel know that we have the aspirant training program. So I'm not suggesting that I'm bringing that in. That is there. It's individuals, law graduates, members who've been at legal aid, who are absorbed into the program, into the prosecution on the basis of an aspirant program. It's a 12-month period, and thereafter they may qualify to become prosecutors. We're able to absorb most of them, but not all of them, not all the time. So in the past, Minister, we used to have what we call a tutor, and the tutor's focus was to upskill the aspirants. Then for career pathing, it became a bit of a cul-de-sac for some of the aspirants and for the tutors, and they felt they didn't really see a future for themselves because they were stuck in that position and there was no career path. So most of them were absorbed into senior public prosecutor roles, and so the tutors fell away. But the tutors are being revived now, and so I see the tutors playing a role not only with the aspirants but also with the district court. But then, Minister, insofar as the regional court is concerned, and I'm dealing still with the general prosecutions, I would like to see retired, experienced prosecutors being brought in to mentor regional court prosecutors, because we know there's a deficiency now, and it is not one that the manager can cure, because the manager in the regional court is an extremely busy individual, managing the engagement with the police, the quality of the dockets. So it is very rare to find a control prosecutor or an SPP being able to go into a court and to observe what is happening with a particular prosecutor. So my idea is to get retired colleagues who have the necessary competence to play that role. And that you almost do an in-person assessment of every prosecutor in the regional court. What is the shortcoming here? This person is fine. No, we know he or she can continue. This individual needs a bit of work, and so that is quite an intensive job, and that is why I'm saying, Minister, it's not something that the normal line manager can do. It has got to be an additional initiative for that to happen. And so that's my vision for the regional court. Because once again, I repeat myself: the regional court is a critical forum, and we must succeed in the regional court. And so putting a mechanism like that in place, or an initiative like that, will really ensure that we have the people that are able to do the job. Now let me deal with the specialist environment. So there is a capability initiative now to ensure that we have the requisite skills in the specialist environment, and so we are fortunate. We have some colleagues, I believe, who are abroad this week as part of that initiative as well, to try and see how do we put together a framework that capacitates the individuals in the specialist environment. And so we'll have to reflect on that. What exactly does that mean, and how can we do that? The other thing, Minister, if I can just talk about prosecutions generally, is and sometimes the middle managers tell us the young prosecutors don't want to read anymore. Huh? They want to watch TikTok videos. They want to do, and I say, but you can't do law without reading. So one of the things, Minister, I think we should consider as an organization, because look, we have training. But I like the idea of this continuous professional development, to compel you to do something. And don't tell us you want to do something which is miles away from where you are, that it's a nice to have. Let's look at where you are, what are you involved in, and let's try and build a framework where you can ensure that, because that forces you to upskill yourself as well. Can I just say this, Minister, when I speak to prosecutors, and I normally speak to the aspirants as part of my governance portfolio, I always suggest to them that the pinnacle of prosecution is being at the DPP office in the High Court. But when I do that, I do not demean the regional court, nor do I demean the district court, because some colleagues find their space in the district court, and they're happy to remain there, and they choose to remain there. Some choose to remain in the regional court, and we respect that. But we need to ensure that the individuals in those tiers are capable of delivery. So that's on making sure that we are able to do our work as an organization. Then in terms of leadership, Minister, sometimes I think it's a bit of hit and miss. Because there's this fear, I can't say who my successor is going to be. And of course that's important, because that's not acceptable. But it shouldn't be a mystery in the organization about who the contenders are. It shouldn't be a mystery. And so what I would like to see is for us to look at individuals who potentially could be, and I'm starting at the lowest tier of leadership, a control prosecutor. What must you be able to do to be a control prosecutor? Let's identify people, let's give them the exposure, so that when the control prosecutor retires or leaves, we have 4 or 5 candidates. We're not scrambling now to say, who's going to do this job? Same with senior public prosecutor. The same with chief prosecutor. I can go through the tiers. Same with deputy director of public prosecution. And Minister, one of the critical things that we're going to be confronted with as an organization is at the DPP level. That DPPs are going to be leaving now over the next few years. And so why should we wait for my colleague in a particular province to leave, and then we start saying, okay, now who's going to be that? Why can we not have a group of individuals that we put through a process so that they are capable of filling that role? And I've seen the commentary, Minister, about the appointment process, and of course it's a presidential prerogative in terms of the NDPP, deputy nationals, and as well as DPPs. But I like the idea of this process. Huh? I like the idea of a process where people come and present themselves. Because for some, I'm not including myself in that, but for some, they may never get an opportunity to present themselves because they may not be noticed. Huh? They may be somewhere in the organization and the head office doesn't know about them. So it will afford that opportunity as well. But more coming back to the point, internally, how do we build that base so that we have a cohort who are equally capable of taking over that responsibility? So I'm still busy with capability, Minister. Then if we come to modernization, everyone is talking about the phase we are in terms of the transition in the digital environment. Everyone's talking about the use of AI. But Minister, I'm not sure if you know, but we still use Excel to do performance reporting. And the Adv Mmamoloko will know that many of the findings are human error because data is captured at a local level, at a court level. It's consolidated at a court center level. It's consolidated at a court, the cluster level, and then it goes to VGM. So there's lots of scope for us to make errors. So as part of modernization, of course, we must leverage technology.
IJS.
Exactly. Yeah. But Minister, before we even get to that level, I want to try and see what can we do so that a prosecutor doesn't have to fill in a sheet at the day, and there be a consolidation process, so that we can try and ensure that as a manager, you don't have to wait until the end of the month. You have a dashboard, a weekly dashboard of what is happening in your environment. What's happening at a particular court center. Because that will not only benefit us as the prosecution, it will also benefit the presiding officers. I must park that, Minister, because that's an entire topic on its own in terms of our engagement and at the court center level. But to come back to the modernization, so certainly I would want to see that. I know the current governors believe in the ECMS, Minister, the current governors in the NPA. And so we've done quite a bit. We've engaged with the Office of the Auditor General to try and see how we use ECMS as the primary vehicle, but we also supplement with manual stats. And what that process means in practice, Minister, it's prosecutors doing that. Not support staff doing that, it's prosecutors doing that. You know, Minister, I'm part of a group, it's a WhatsApp group. I'm maybe a bit of a voyeur, I don't contribute, but it's the ECMS group. And it's the ECMS group. Okay. Prosecutors engaging with someone at head office who's trying to assist and to facilitate. And it pains me, truly it pains me, when I see people are writing late at night on weekends, there's this problem with the system, I can't get on. So the system, in my view, is not what it is intended to be. And you'll recall, Minister, we are in the center of the value chain. So the police load, if the police load, we can't do anything on ECMS. So we rely on the police to load. Then we must play our role in the ECMS. And I must say, there are many offices where DOJ officials are assisting us, Minister, because the prosecutors just cannot get to that function. And why is that function important? Because the outcome in court is not going to be captured. I have another view, Minister. Maybe I can just share this now. The NPA is not responsible for court information. The NPA is responsible for performance information for the NPA. And often it gets conflated. And we get asked to explain what the court outcomes. I know the DOJ is undergoing a transition, and my own idea is, if the OCJ takes responsibility for the entire structure, my own view is the DOJ can become the vehicle that is responsible for court performance and the outcome of court performance, and to engineer itself so that they drive that process, the DOJ. It's just an idea, Minister, to play that role. so that we can focus on NPA performance, so that we manage the performance of the organization. So that was modernization. Of course, I spoke about independence earlier. I spoke about capacity, professionalism. Professionalism.
And perhaps even going into, are you saying these things are not done now? Because we're looking at the future.
I'm looking at the future, Minister. I'm saying we need, as a country, we need an institution that is responsible for court performance. Because the OCJ, if you look at the OCJ report,
No, I'm meaning the whole thing. Everything about leadership, about independence, about capable organization.
Some of it we are doing, Minister, and that's why I emphasize some of it we need to reinforce. Some of it we need to reinforce. So I'm not suggesting that all of this is novel, but I think my ideas about developing the next tier of leadership, doing that now, the role at the regional court of having retired individuals, those are my ideas about how I think we can build that cohort. Because that speaks to the professionalism that we have. That we have people who are able to and are capable of doing the job as well.
Yeah,
and
because
people,
I want to link that to performance. You sitting in Western Cape, and I said this to the previous candidate, which I'm going to flag with you, and we look at the conviction rate. For example, performance or postponement in courts due to prosecutors is sitting at 8.1. So I take you are part of the management in the Western Cape. So you would work together as a team to look at performance of NPA within the province. So postponement of cases is 8.1. And I flag it because we should have 0 caused by NPA. But coming to the other, let me finish the stats. The other issue, we look at performance. In the statistics of performance, as per the last annual report, and then we can go to the last 5 years that I've done, because on the sexual offenses, I've gone to the last, and others I've looked. But the worrying when I looked at the last 5 years, because that's what I do, to evaluate performance of the institutions and the organization. When you look at essential infrastructure, which is critical, I mean, this is infrastructure that we need as a country, where it has been damaged and we need conviction rates. You find that Western Cape together with Free State are at the bottom. We're sitting at 73%. And I'm going to go to the 3 where we are at the bottom, and I think it's quite too much for me to have a province having 3 areas where they are at the bottom. And areas which are critical. Murder, we are at the bottom, hovering together with Free State, Johannesburg, and Limpopo. We're sitting at 78, while others are sitting at 80 and 90%. Worse is sexual offenses. Sexual offenses, we're hovering there with Johannesburg and Northwest, but also we are at the bottom there. Now, with sexual offenses, and this is what I was saying, because, I mean, this is one of the critical areas where even President declares it a national crisis. But you look at our performance over years, looking at, you've been in the Western Cape for some time, for almost all your careers. The last 5 years, we've been dipping in terms of stats. Now, as a candidate for NDPP, the public wants to know, are we not transporting one problem from which could be contained in one province to becoming a national problem? Because if the interventions are not working or the ideas are not working in Western Cape, how would they work when it becomes complex with difference in cultures and languages and all those diversities across the country?
No, thank you for affording me the opportunity. If I can start with infrastructure, we've discussed this in great detail in the division, and we've as a consequence of that, we've tried to work out remedial action. If you look at what causes us to have that level of conviction rate, essentially it is the quality of the evidence. So in the initial phase, if you look at when we debrief, what is going wrong with essential infrastructure? Because it should be obvious. Huh? The written reports we get, so these are not people just telling us off the cuff. Written reports we get it's the quality of evidence.
Explain that.
So the police officers...
Because police would say that you guys blame them unnecessarily. when it's you who are not going to win cases? Maybe explain.
That's why it's always important to have us in the same room at the same time, Minister.
Unfortunately, in this case, I do not have that opportunity, but take us through.
But just to come back to that, so it's the quality of the evidence. So sometimes an individual is arrested with a piece of infrastructure, and when they get challenged as to why are they saying this infrastructure belongs to Eskom, to Telkom, whichever, they make concessions that no, they're able to. There are no markings on the contraband. We've had cases where the police have mingled some of the evidence, and so the SAP 13 record. So it's normally a question of quality of evidence. So what have we done, Minister? And that's the important part. We've said, but let us engage with the individuals who will do this work. Whether it's at the Metro Police level, whether it's the SAPS members, so that we can explain to them what exactly is required. What is the evidential chain that's required, and what is required when you identify a particular item? Describe it. And so that work happens not only with detectives, but also with the frontline staff, because they are the individuals normally. If you talk to a detective, he or she will say, no, but the uniformed people did this arrest, the shift was changing, they didn't do the affidavits, they'll do the affidavits tomorrow. So we've tried to suggest, but we need a different approach. The affidavits, because that is what the case is based on, the affidavit is critical. You can't come and tell me 6 months later what you recall of the incident if it hasn't been documented. We're going to have difficulty. So what we've tried to do, Minister, insofar as infrastructure is concerned, is to focus on that in particular, to show that the quality of what is required in the docket. If I can come to murder, Minister, and so I acknowledge the fact that you say we're at the lower end and that we are at 78, and the performance standard that we expect is 74%. So we meet the targets. Can I just say this, and I say this to all managers, in the main, Minister, if you look at our performance, we by and large meet our performance indicators. But that doesn't mean, and I'm known to say this, and I'll repeat it here, it doesn't mean you can go to Kailicha or to Mitchell's Plain on a Monday morning and tell our people that the NPA in the Western Cape is achieving all of its targets, because it means nothing to our people. Performance indicators are just that. It doesn't impact on the lived reality. So
That's
why?
not correct.
Sorry, Minister.
The target for sexual offences is not 68.
No, I said I'm at murder. I said 74 for murder, 78. I'm coming to sexual offences. The expected performance standard there is 70%, but I'll deal with sexual offences now. Just insofar as the murder is concerned, Minister, we have not a unique phenomena, but a lot of the murders that we have in the Western Cape is gang-related. Gangs are involved. And so we have a very, very real problem. We have a very real problem. Because in many of those cases, we are not able to put the charges to the accused. Because witnesses may observe something, they'll file an affidavit, but when it comes time for us to lead that evidence, they're reluctant. And that's if we're lucky that we get to a stage where we have a docket and we are able to identify an individual. In many instances, there's just silence. We don't even know who the perpetrator is. We may have a sense, but we don't know. But turning to the ones where we actually litigate, the other phenomenon you have is a witness testifies in chief, everything is fine. As soon as the cross-examination starts, all sorts of concessions are made. And that is our reality. So Minister, with respect, I think for us to achieve 78% in that environment where it's very challenging, we are meeting the expected standard, but it is not having the desired impact in our communities, because that is where the violence is still prevalent. So how do we remedy that? If you look at some of the big cases that we're doing at the moment in the division, dedicated teams of investigators, dedicated prosecutors. I'm sure you would have heard, Minister, that on the bigger organized crime cases now, we put 3 prosecutors on a case. So that's resource intensive. Huh? But why do we do that? One, we demonstrate the importance of the case to show that you can't intimidate all 3 prosecutors. You may try to. If something happens, there's someone else who will pick up pick up the spear and continue. But that kind of dedication has given us the platform where we have now many of the big gang leaders in the Western Cape before the High Court. Many of them at an advanced stage. So coming back to the issue of what do we do with murders? Minister, one of the issues that's been bothering me is what can we do better in terms of witness protection? I mean, I know of the recent incident of witness D who died, and I heard your comment in the media on that. And that is what happens in practice. I've always I'm not originally from the Western Cape, so I can make fun of them sometimes. Although my wife says I've been there for 30 years now, I'm one of them. But I always found it amazing that individuals in the Western Cape do not want to go onto the witness protection program and be relocated. For whatever reason, we have difficulty with that. And I've been asking myself the question rhetorically in my own mind, what can we do to make it not appealing in the sense that there's some benefit to be had, but what can we offer our people so that they have comfort that if they access the system, we are able to look after them, look after their families. And I know all of this costs money, Minister, but we have to do something as a country. We've got to find a way of saying, in an environment where we need witness testimony to ensure that we deal with a particular phenomenon, in this case, gangsterism and murder in this instance that we're talking about, we've got to offer our people something. And so I would really want to engage with witness protection to see what can be done to have that. I know people have romantic notions. They watch movies and they think we can do all sorts of things. And so there are limitations. But if you look at some of the key cases we've had success, Minister, we've had people on the witness protection program. So the program is not unimportant. It is an important vehicle or tool that we can use. So with respect to my colleagues in the rest of the country, different phenomena that they're dealing with, ours is slightly different. And I did say, I qualified that statement by saying we're not the only ones. I appreciate that there are other parts of the country that are experiencing similar phenomena as well. Sexual offences, Minister. Sexual offences is, as we all know, a very difficult environment. So we meet the expected performance standard, but that, once again, is not ringing the bell and celebrating, because we know that there's more to be done. So we meet the expected performance standard, and I must say, Minister, we invest a lot of time. So the expected performance standard is 70%, Minister. Huh? 68%.
Yes.
Okay, well we just short then. But we invest a lot of time in sexual offences, Minister. We have, I'm sure the DPP would have spoken about this, we have structures that focus exclusively on how do we deal with sexual offences. Once again, when we debrief, when we ask for written reports, in most instances it's a question of quality of evidence. So to me the important part is how do we as the collective ensure that when the complainants engage with the system, that the system is of such a nature, whether it's at the TCC or with the detectives directly, that we create the environment that gives the individual confidence to firstly to enter the system, because that's one of our main challenges, as we all know, is that many complainants don't want to enter the system. They may go to the TCC, access some of the services, but not follow the path all the way through to the court system. They'll follow the path, go from victim to survivor with all of the support services, but elect not to do that. So in terms of sexual offences, Minister, we have a very strong regime, as I say. And I actually think that is the model that I would want to replicate elsewhere, despite the fact that we may be a bit short now. Because what we have with sexual offences is we have dedicated prosecutors in the regional courts in particular, where most of these are heard. And those individuals...
Can you explain that? Because I'm battling to understand what you are referring to. We do have, in all the courts where the sexual offences courts are, we've got dedicated prosecutors for sexual offences.
So
but
maybe
the issue here, which I'm referring to your performance and statistics, and I'm trying to understand when you say you're not as bad, it's almost like you're brushing. But this is a performance, I've said, over 5 years, that has been dipping. From 1920 financial year, if you look at those annual reports, it's 5 years consistent going down on a critical matter like this. I don't know if, because the issue when you say we've looked at it, the courts we do have, I mean, Where we've designated sexual offences courts, we've got specialized prosecutors focusing on that across the country,
Yeah.
not only in Western Cape.
Firstly, Mr., can I assure you that
What are we dealing with, and
First-
what intervention there?
Firstly, can I assure you, I'm not demeaning the performance. I take it very seriously. It's and I've always said it's a difficult environment. Not every prosecutor can do that. So we have dedicated courts, Minister, but not all of them are pure sexual offences courts. And that's part of the challenge that we have. So when we talk about the model of ensuring that the prosecutors there have the necessary training, have the necessary expertise and the capacity, and there we rely on the SOCA unit to play that role, which is a very important role, because we recognize it's a specialist area that we need to focus on. So it's really ensuring that the individuals, because that is what we need to do as the prosecution, is to ensure that the individuals who are there are capable and are able to do the work that's required of them. I accept that we may not be meeting the performance standard. That will be a question of evidence, Minister. And as the guarantee I think we need is that the individuals who are in the environment are able to do the work that is required of them. I think that is the guarantee we need. Huh?
Minister. Okay.
I just wanted to go back to your framing initially, where you said how media and the perception out there might be distorting the actual performance. Is it the perception or is it the actual problems in the performance of the NPA? And then somewhere you went on to recommend a number of reforms, so I was a bit not sure as to whether you're saying the problem is performance or the problem is perception.
No, thank you for the question, Professor Kenny. So if I can deal with my suggestion of reforms, that is to reinforce the performance. So in other words, I'm not saying that the performance itself is a problem, because I try to draw a distinction between the work that prosecutors do on a daily basis, the good work that is being done, and a lot of it happens at that particular tier. So that needs to be reinforced. The fact that we're doing well doesn't mean we rest easy. We reinforce that. And the reforms were in the context of my concern that we need to ensure that the people have the requisite skill set to be in that tier. So the distortion, in my view, happens with where things go wrong, and they go horribly wrong, and they have gone horribly wrong. We've seen that in the media. Is that is the theme then that is communicated, and the assertion then is that the entire organization, that particular instance is demonstrative of the entire organization, and that is the perception that we need to correct. That yes, where we've done wrong, firstly we have to acknowledge that we've done wrong, and then tell our people, but what are we going to do differently? But then, in the same breath, not lose sight of the fact that there is a lot of good work that is being done by prosecutors on a daily basis, and that's the distortion I referred to, Professor Kenny.
Maybe just a quick follow-up on that. Then you went on to highlight a number of interdependencies which make NPA not to succeed. Can you neatly isolate those things, inherent weaknesses within the NPA, as different from all other interdependencies that may be caused by the judiciary, the environment, and several other things?
Certainly, Professor, because the point I was making, maybe emphasize the point. A prosecutor must own the decision to prosecute. Because once you take the decision to prosecute, there's no hiding place. Because once you've decided to prosecute, at that stage you must be confident, firstly, that the facts supported, the law is on your side, and that you have the prospects of a successful prosecution. In those instances, it doesn't help then to come and say afterwards, no, but the case was weak because of so and so and so. So I'm with you there. So that you distinguish that, because that you must address up front. In other words, once I make the decision, I own the process now. So and that's the point I was making. to be able to own the process, you must be a skilled prosecutor to be able to present your case to court. Of course, there are no guarantees that every time that you'll have a conviction. But you must have the skill set to do that. And so if things go wrong, in other words, if not achieving a conviction is as a result of your conduct as the prosecutor, that's something we must deal with. That is clearly our responsibility. A silly example, if you don't call a key witness in a case, you close the state's case. There must be consequences for those kinds of things, where you do things which are obviously wrong. So our job is to ensure that we have the capability to present the case. I'm not talking about beforehand, and I'm not talking about finalizing the case, because there's also challenges there in the delays in getting the cases finalized. That's a separate process. The process I'm focusing on now is owning what we present as the prosecutor. That is our responsibility, and we must stand and fall by that responsibility.
Maybe just on that one. So you are going back, because I think what the follow-up is about is when you made a reference, when I said the statistics, and you said it's because the investigation has not been, and that's why I made a comment about the police, and you said that that's why you need us in the room. But now you're acknowledging that the responsibility to take the case to court is that of a prosecutor. Yeah. And therefore you can't blame the police, because you'd have made a determination that this case is ready. Therefore, the conviction rate of any of those cases can be the fault of the police.
I'm with you, Minister, and we're on the same page. Just maybe if the impression was I said that we blame the outcome, the point, I wasn't doing that. I made a different point there in terms of the investigation. You'll recall I even made the point that sometimes we don't even get the individual, so we discard those cases completely. So I'm unequivocal. And I think I'm consistent, Minister, that when we decide to prosecute, there's no one else to blame. It's our responsibility. I think I'm consistent there.
But then what becomes the reasons? Because what we are trying to understand is that your understanding of the difficulty, and as I said, because it originates from what I said, that you're sitting with this performance in the Western Cape, and the nation is watching and saying, are you not transporting the problem there? And we wanted to understand, do you understand the complexity of these cases, why we've not been able to have the success rate that we would want to see, and the percentage that I've named? Murder rate in the Western Cape sitting at 76. It means we are not able to prosecute the others in the rest of the cases. And I can name the number of cases, because it's versus against a particular number of cases, as you know. The issue of sexual offenses. One woman raped is one too many. Now, we are not able to prosecute. So it can be the issue of investigation, because you would have determined that this, and what we are trying to understand, what is the cause and what interventions have been done? Would that translate to national? Will you be able to assist us so that we don't dip in terms of statistics?
No, I'm with you, Minister. And that's why I spoke about the interventions at the prosecutor level, to ensure that the prosecutor has the legal wherewithal to be able to present the case. I made the point earlier about quality of evidence. That is an important factor, the quality of evidence, because sometimes the quality of the case that you present deteriorates in cross-examination. That is a reality. So the assurance I can give you is that the process of ensuring that we have the right people with the right technical abilities to present the case to court, that is the assurance that we need. To be able to evaluate the evidence properly, to make decisions. Some people are conservative, and they say, look, I may not want to go to court. I won't do that. I say there's no need for that discretion. We have a process that we follow. You evaluate the evidence. If you're confident in the evidence, you're confident that it meets the evidential threshold, and that there is a case, and that there's a prospect for success, then you have to prosecute. And I think that is the assurance I'm giving you, Minister, to say that is the responsibility of the leadership, to ensure that the individuals who are in the field, who are executing those responsibilities, are capable of doing that. Because if they are not, that is a disaster.
Mr. Mavundlela, and then you'll come.
Thanks, Minister. I wanted to understand from you, Advocate. Do I have to understand you to be saying the system is not holding that the prosecutor-led investigation process is actually not yielding the results we would, as a country, ordinarily aspire to have? Should I understand you that way? Or that we don't have adequately trained or capable prosecutors, as you say, who are able to own the decisions that they make to prosecute? Just so that we are all clear, we don't misunderstand you, and we then understand where are the fault lines. And if you were to be appointed, you would then be able to go and correct those fault lines. Because I can tell you, whoever is watching these interviews is interested in that question.
Yeah. No, thank you for that. So firstly, I'm not suggesting that prosecutor-guided investigations is not working. That's certainly not my thesis. That works very well, and we have a number of instances where that work. Of course, we have the model with the specialized commercial crime prosecutors, who in many instances are co-located with detectives, and so that model works. We're talking about the general prosecutions now and the regional court, and so that model doesn't always apply. So by and large, those dockets are ones that are dealt with by station detectives. So that's the distinction I'm drawing. And let me also clarify, I'm certainly not being alarmist and saying that we have incompetent people in the regional court. I'm not saying that. I made the point earlier, we have prosecutors doing a lot of good work on a daily basis. I'm talking about ensuring that we have the pipeline, that we continuously have that expertise at that particular level to reinforce that. That is what I'm talking about. It's maybe a different proposition. But certainly, I'm not diminishing or demeaning PGI. It works. It's a model that has been well documented in South Africa. So I'm certainly not doing that. Yeah.
If you were to be appointed, sorry, Minister, just one question. If you were to be appointed, and I want to take you back, maybe 2-3 questions back, you have said that, and I hope that you said that maybe in passing, that whoever wants to sit there, let them stay there, quote unquote. And I found that very disturbing because you were talking about succession planning, as you eloquently put it, that we shouldn't be surprised as to who should then ascend when one person gets to either retire or resign or something, because people will retire and resign. What should I take out of that? Should I take it that we may be sitting with management that says we will motivate those that wants to be motivated, but we will not put in place measures that would make everybody want to be motivated? Or is the environment so demotivating itself such that people have become comfortable with being salary earners because then they don't see any growth out of themselves? Is that how we should understand it?
No. And I'm trying to contextualize the stay there. I thought I made the point in the context of a process where someone who aspires to be a DPP is able to bring their candidate forth themselves. I thought I made the point in that context. But to touch on whether, because that's mediocrity that you're describing now, where people are just there to earn a salary, do the bare minimum. That is certainly not the place or the prosecution services that I think we are, broadly speaking, or one that I seek to lead. I'm always at pains to say that there are prosecutors doing good work on a daily basis, and we must always acknowledge that. And to the extent that we've gone wrong, it's been in a few matters, and a few of those are too many. I take the point the Minister made earlier. Any one of them is one too many. But to decry or to demean the entire cohort of prosecutors is what I'm deliberately trying to avoid, because that is not accurate. And if you are here for the salary, I think the point I was making, sir, is Mr. Mmamoloko, is about people who feel that they are happy in the district court. They find fulfillment. That's the point I was making. You remind me now. Fulfillment in the district court. And I'm saying that that should not be demeaning. You shouldn't look down on someone who finds fulfillment in the district court. For whatever reason, that's the point I was making. Thank you for reminding me about it. Same with the regional court. If people find fulfillment in the regional court because that is difficult work, it's fulfilling work because you're dealing with serious offenses, if people are comfortable there, then I respect it. So it's certainly not about, yeah.
Okay. Mr. Mtlu.
Thanks, Minister. Advocate Mopp, I find it a bit problematic. There are certain answers that you gave. And let me give context here. At the heart of the question now is performance management. Now, what I find from you is, and it's an impression, you'll correct me if I'm wrong, it's a belated diagnosis of the problem, of the challenges that has resulted in Western Cape being plunged at the foot of the rankings in as far as those three areas are concerned. And I'm saying this against the backdrop of your response with regard to the 68% specifically in relation to sexual offenses. That you appeared to be taken by surprise that you were, not really meeting the standard, which is at 70%. So then what comes out of you in terms of the proposed interventions? It would mean that these are proposed interventions that you are imagining as being, forward-looking. It's not something that you, having diagnosed the problem or the challenges at infancy stages with your team, because you are a manager currently, that you put in place such interventions. And if you did put in place such interventions, you should be taking us into confidence in terms of what measures did you then put in place and what was the success of it, because this poor performance has been going on for quite some time, and we don't get to hear from you those type of interventions. So at the heart of this question is performance management, meaning you should be able to demonstrate monitoring systems as well as evaluation of performance at acceptable intervals.
No, thank you. Thank you for that. No, we certainly do that, sir. I was surprised at 68%, you're right. I didn't think we were at 68%. But that's another matter. I accept the figure. So we do exactly that. That is why we have monthly meetings. That is why we have a component. We have a deputy director of public prosecutions that manages what we call the sexual offences team with the senior prosecutors from those individual courts who sit and they go through that very process. What is going wrong at a particular court centre? What can we do? What can we do differently as the prosecution? We have that in place. And so I am surprised that it hasn't translated into 70%, because the figures that I last saw was more than 70%, but I accept the figure the minister gives, and you're right, I was taken aback by it. But we do that, so it's not a question of ex post facto analysis. That is exactly why we have the management meetings. We sit there as a collective, and then the individual teams. So we look at it broadly at a leadership level. How are we doing as an organization? Where are the pressure points? Where are the challenges? And then at a theme level, if I can call it that. In other words, the senior prosecutors who are responsible for those courts that we speak about, they then have the more detailed interrogations, feedback to us at a leadership level of the interventions that are being put in place. So I'm with you. It's part of our process.
One last one.
Maybe just to confirm, the figure used, it's on the published annual performance report of the NPA of 2024-25.
No, I accept that, Minister.
Proceed.
Thank you. Thank you, Minister. And one last question relates to your remark that you always have or engage in a rhetoric in as far as these challenges are concerned. You ask yourself questions, and at some point you would have sleepless nights and start having that monologue, if I may call it that way.
Yeah.
The challenge that I have with that is, as a manager, the moment you identify a performance gap, you need to deal with it at management level, raise it there, so that you come up with workable solutions at that level. And I don't get that from you, except that you engage in rhetoric.
No, thank you for giving me the opportunity to clarify that. So the point I was making when I was talking about the sleepless nights is about my concern for the future of the country and the challenge that we face in the criminal justice system. But to speak directly to your point, sir, that's exactly what I do, sir. And I'm able to do that not only in the area that I'm responsible for, but I do it across the board. Because when you sit at the management level, and this is something I preach to senior public prosecutors, to deputy directors, when we sit as a collective, you're not sitting there representing your particular court. And you mustn't sit there waiting to hear when I mention your court and then you want to speak about it. You're there to share your views as a collective. And so we do that, sir. So if the impression is that I pontificate in my own mind, I have a monologue, dialogue with myself, and I don't do anything insofar as the core responsibilities at work is concerned, then that is not correct, sir, and I need to correct it, because that is exactly what I do. My style is to share with colleagues, share my ideas, because the vantage point of the governance coordinator allows me to do that. So thank you for allowing me to correct that.
Fundis.
Thank you, Minister. Good afternoon, Mr. Mopp.
Good
afternoon. There is a view, real or perceived, about the mistrust in the criminal justice system. And you have proposed in order to address some of the perceptions out there through a media campaign. And you have mentioned, taking out ads and also maybe with the newspapers. But if in the event that you're elected, would there be a media strategy that would not only be a media strategy, but an engagement strategy that will bring in all sectors of society and across the country for people to understand, the work that's being done? Because media, a paper, you read it today, tomorrow it's forgotten, but engagement with people and then do that. But it must be underpinned by real work being done and work that people can trust. And then what would your strategy be on that? That's the first question, Minister. And the last one, very shortly. On the issue about safe houses and witness program, we know that for a number, not only in your province but also in other provinces, when we do go or do we take people into a witness program, somehow information is leaked because of the issues relating to that, whether it's corruption or whether it's cahooting or whatever, and so on. What would you bring to ensure that the witness program is solid and people can trust it and people will be able to be protected, and so that you can then have your solid evidence and so on, in order to have a solid case and a solid prosecution?
Thank you, Vanderson. If I can start with the engagement, yes, certainly. The fact that I spoke about communications does not mean that I do not think that is important. In fact, that's critical, that the NPA has that kind of dialogue with civil society, with stakeholders, with communities. And you're right, it's not talking for talking's sake. It must be on the back of some clear deliverables. And I think that is an absolute necessity. I know that we have started doing that as an organization, maybe not as extensively as people would want, maybe not as broad in terms of the engagement, but certainly my idea would be for that to happen. But as I say, on the basis of what has transpired. So it's not just communicating a positive message of we intend to do the following, but also to demonstrate that we have done the following. So certainly, maybe I didn't expand sufficiently on communication, but you cannot just communicate, sit at VGM or sit anywhere and issue press releases. You've got to have that face-to-face engagement with communities, because that is also where you get a sense of the real perception that people have of the work that you do. And a lot of that engagement actually is advocacy work as well. You'll know, Reverend Sin, that there are lots of imbizos in the Western Cape. And at each imbizo, we have to explain bail. And so you can't tire of that responsibility. You've got to explain to our people how the system works. And it's critical that we do that and that we continue doing that. So certainly that is part of it. Insofar as witness protection is concerned, it's a responsibility which is currently located with the NPA. And I must say, if we have regard to witness protection, I'm happy to say that over the last several years, no witnesses have been harmed. I know we went through a bad patch a while back, so things are looking good. It's more about, the point I was trying to make, it's more about that our people understand that witness protection is available to them and that it will meet with whatever the requirements are. And so the reluctance that I sense is the question of location. So you get taken from Lavender Hill or Site C, and you're taken to Mpumalanga or to Limpopo and Northwest, and I think our people battle with that adjustment. But to the point in terms of what we can offer, I think we have a solid system insofar as what the current offering is, because the point I'm making is that the individuals at witness protection are limited by what the current service offering is. And it's the service offering, I think, where we need to have a discussion about what more can we do to try and be, to have a program that is, and I don't want to use the word enticing, because enticing means that, there's something for me to be had at witness protection, and therefore I avail myself. So it's not a question of that. It's real witnesses who can add value to cases and to see how do we address the concerns that they have so that they're able to be absorbed into the program. Leaks, it is so that a common refrain is that when individuals say they've reported a matter to the police, everybody hears about it a few minutes later. And so that's where the need for ethical leadership across the board comes in, so that we also have consequence management when those kinds of things happen.
Advocate. Thanks, Minister. I'll just be brief. I think to a large extent we have actually focused on the NPA in relation to the Society of South Africa. But one of the things that has come out both at the Madlanga Commission and Ad Hoc Committee was just the internal turmoil, for a lack of a better phrase, that is inside. Can you take us through some of the key issues in terms of that turmoil? And I'm using that word deliberately because I don't want you to shift away from it. We know there are challenges inside. So if you could tell us about what those challenges are, and if you were to come in, how you would deal with them. Thanks.
Just clarify, Advocate Mmamoloko, are we referring to the turmoil within SAPS or within the criminal justice system in its entirety?
No, NPA.
At NPA?
Yes.
So I'm intrigued by your characterization of it as turmoil, and I interpret you to be referring to the question of IDAC having effected the arrest, an arrest of a senior police officer.
No, it's everything including that. Let me remind you that the current incumbent, when he went to the Madlanga Commission, actually, was it Madlanga or Ad Hoc?
The Ad Hoc Committee.
Ad Hoc Committee actually said she underestimated the I don't know what to say, but the challenges internally. And why I'm raising it with you, you've been there for close to 30 years or something like that, and I'm not hearing you mention them, and I'm wondering, is it not because of this glossing over the cracks that makes the cracks to deepen, the water to seep further, and then it becomes a culture of the organization. That's why the limited impact. So tell us what those cracks are, if any, and how, if you were to be appointed, you are going to deal with them. NPA cracks. Okay.
Thank you for the clarification. So, Adv Batoe has said a number of things. She spoke about underestimating the challenge, and she hasn't always articulated what she means by that. You'll recall when she started off, she was very negative about the state of the organization. And in the recent past, she's tried to walk back some of those comments. When Advocate Batoe was appointed, and I'll mention two things which I'm on record as saying within the organization. When she was appointed, we were convened as the senior management, and the panel can confirm this with her and with others who were there. When the senior management convened, she called us all in to speak about her leadership. I raised with her the issue of the perceptions of the NPA being captured in a public forum. Got up in the plenary and I raised that with her. I said, there's this perception of what has transpired in the organization. Some of us have observed things, but we don't know the context, and so we cannot make definitive findings ourselves.
Chair, can I intervene? I would like you to go to your views about the current situation. If, oh, okay, all right, all right.
Yeah. Thank you, Minister. And I said it's critically important that when you build a team, because she's coming from outside, she's had a view of us, those in the organization. If you want to build a team, then we must know who did what. So that people are afforded an opportunity to explain their conduct, and maybe they are able to give us rational explanations for what they have done. But at the perception level, we may be thinking, there are a few individuals. In my own view, I always thought there's 6 or 8 people who did things wrong in the organization at a distance, not the entire organization. And if people spoke about the NPA being captured, in my view, I thought there were 6, 7, or 8 people who had to account for what they did. I raised that at the very first meeting with Advocate Batoe, and I said it's important for us to go through that process because we need to have that process so that we can build a team once that is done. So let us know who did what, let them explain themselves, then we can build a team and we can move together as a collective. At the SMS conference I spoke about earlier, the one that we concluded, I think it was October, I again got up in the plenary and I said, the one thing we haven't done as an organization is we haven't amongst ourselves spoken about what state capture was and how it manifested in the organization. And I lamented that fact. And I said that it's a critical step that we have missed as an organization because there's a very strong perception that the entire NPA was corrupt. There are many of us who feel, like I do, there were a few individuals, and I'm not saying definitively they were part of state capture, I'm saying that they needed to explain their conduct so that we could all understand what happened. And so that didn't happen. And I think that was a missed opportunity. Because now, as you say, ma'am, we are still being characterized as being in turmoil. And this is how many years after the fact. And so if I become the NDPP, that is something that I would want us to do as an organization, to have an honest discussion amongst ourselves and say, what exactly is this, the turmoil that we speak about? Advocate Batoe spoke about, initially she spoke in the media about, she's concerned about the elements who do not respect the rule of law in the organization. I was alarmed by that statement. It bothered me. When she was asked to explain that, she referenced one instance. And there again, it is critical for us to have a proper understanding to diagnose the problem properly. Are we talking about 1 or 2 individuals who are anti-constitutionalists, who are anti-rule of law? Or are we talking about an organization where this beset by this? My view is that we are not an organization beset by people who are opposed to the rule of law. We are not beset by people who are anti-constitutionalists. That is my view. And so I would want to interrogate the assertions and the evidence that people who make that statement. Because once again, good people are being tarnished by referencing the entire organization when we may actually only be talking about individuals. Because if it is an individual or at an individual level, it is easier to deal with. If it is beset the organization, of course, then it is much more fundamental. And that is not my view, that we are an organization beset by those kinds of elements.
Thank you. Thank you, Advocate Mopp. Just to stick with this for a moment, is it then your assertion that the gap between where the NPA is and where it should be in the minds of the public, for it to be trusted, right? For it to be trusted, the gap between it, where it is in reality, and where the public sees it, is attributable to mere perception? If you look at the matters around skill, matters around ethics, matters around actual performance on the mandate, I just want to be clear, is that what we should understand from in terms of how you see things?
Certainly not. I would be the first to say it's not only at a perception level, because there have been very real failures. And so it cannot be just a perception. And when I talk about that, I always try and distinguish between the cases that are high profile and those that happen in the ordinary course. And so in this context, we're talking about the high profile failures of the organization. And so there have been demonstrable failures. And in some of those, we, once again, from a distance, you have a sense that something has gone wrong. We've asked questions. We know that there are investigations that are happening. We have not been favored with the outcome of those investigations. And because that would be a critical element of firstly, the diagnosis, and also then what needs to be done. Because once again, it is critically important, to be fair to all concerned, that the individuals in those instances are able to explain, account for their conduct, and then on the basis of definitive findings, we are able to act. So to crisply answer, no, it is not just perception. There have been real instances, but we need to understand what happened there so that we're able to remedy that and so that it doesn't repeat itself.
So if you are appointed as NDPP, your first order of business would be to do that diagnostic on those things?
Well, some of it is underway already. There are processes that are unfolding, and maybe I haven't been privy to what the outcomes are, but certainly I would want to know for myself, to get a sense of what exactly transpired in these instances. Because I think we've all acknowledged that some of it has done real harm to us as an organization, and we need to understand what happened there.
Maybe also linked to that, earlier on you talked about independence, and you referred to it in the context of independence on decision making. Mm-hmm. Maybe if you could just take us through your own thinking about what would make for optimal independence by the NPA, and what would that look like? Yeah. And perhaps how would you get there, given where you are now?
So I know it's a very topical point, the question of independence, civil society, NGOs. There are a range of actors who've spoken about an independent NPA, one that is not a program of the DOJ. So my understanding is, and the NDPP has communicated this to us, that the minister supports that particular initiative. The president supports it. And so my understanding is that the minister is seized with that process at the moment. If the minister were to request me to share some views for us to look at developing models, to assist the minister arrive at a decision, I would certainly be welcome to do that. But the one critical area, if I can just touch on in terms of what in my view, how it manifests as the independence in terms of the NPA having its own accounting officer, I'm very clear in my mind that person is not the NDPP. I would not support a position that dictates or that suggests that the NDPP is the accounting officer. I'm opposed to that model. I do not think the design of the NPA is of such a nature that the NDPP must have that responsibility. I'll be more amenable to exploring the option, like the OCJ has, where we have the SG who manages the administration, the Chief Justice who provides leadership to the entire country. That is a model that I favor. But of course, once again, at the request of the minister, because it's the minister who drives that process. I think the NDPP is on record to saying that it's something that it's an aspirational goal, but it is located with the minister, and the minister is, as I understand, driving that process.
Sorry, so this is limited specifically to matters around accounting officer, or are there other aspects? I'm just keen to understand your aspirations on the qualitative aspects of what you mean by independence.
So it's squarely within the realm of decision-making, prosecutorial decision-making. That is the responsibility of the NDPP. It's a constitutional mandate, and that is what we must protect. And so that is the domain of the NDPP. And that is the one that I'm availing myself to play that role.
Prof, a follow-up on that.
I just want to check, given all what has been asked, if you can identify a particular intervention where Advocate Mopp initiated, conceptualized, championed, and implemented in face of all these challenges, not the one that the national office or the provincial director did, something that you initiated and saw through.
In terms of, just to clarify, Professor, just broadly speaking, or crime type, or just an initiative?
An initiative that impacted and changed some of the challenges that we're facing within the NPA, that was initiated by you, conceptualized, you championed it, and you saw it through to the completion.
Off the cuff, I have difficulty for one that I would be able to take through the entire value chain. I've been involved in conceptualizing a number of initiatives, whether it's at a structural level in terms of defining the role of a particular committee or championing particular causes. But where I'm located, it is one where I can conceptualize and delivery happens elsewhere. So there's no one that I can say I've taken from point A to point B, just off the cuff, Professor Fikeni. I wouldn't want to take credit for other people's work. But certainly that is the role. So my role is not one that takes it from A to Z. It is playing a role at a conceptual level and then at an oversight level. So that's why I'm constrained to try and give you something specific.
Yeah, they were doing follow-up. I'm concluding my section of performance. And this part, I want to conclude it about the cases that you dealt with. You were the lead investigator in the Shirin Duan case, where state was criticized for basing its case on one person and not being able to pull sufficient evidence. The second area, where you were a lead person, it was when you were in the DSO, and as well here, you are said to have met and communicated with the complainant in the 32 million tender rigging scandal in terms of that. It was also one of those. And the last one, in terms of being part of the review panel, that relates to the SARS rogue unit, that eventually the cases were withdrawn. And the state took public beating of it because it was felt that prosecutorial team was timid and was scared to go for powerful people. Are you able to reflect on that performance as an individual?
I'll do that, Minister. Just to clarify, the 32 million tender, I'm not familiar.
This is where you are saying it's the tender rigging in terms of the parliament scandal. Here there was a report that you have communicated with one of the complainants. It was again publicly reported. Okay, let's deal with the other two.
I'll do the other two. I'm trying to reflect on that, Minister. So on Diwani, so Diwani was a series of events. You're correct, Minister. I was involved with the police putting the case together.
Not the lead prosecutor.
I was the lead prosecutor, yes, Minister. So, but there were several prosecutions. Huh? I was the lead prosecutor. That's correct. I was the lead prosecutor. I was, yeah. My colleague, I was the senior prosecutor, and we didn't base our case on one witness, Minister. So, just for context, so we had the first individual that was convicted who pleaded guilty, Zola Tonga. He was the taxi driver who picked the couple up from the airport, and he was the one who was the interface with Mr. Diwani. So to that extent, he was a single witness insofar as the interaction between himself and Mr. Diwani was concerned. But then we also had other witnesses, Minister. We had one of the individuals who was in the vehicle, Mziwa Madora Kawabe. He eventually, when confronted with the evidence, pleaded guilty. We had one 204 witness, Mr. Molombo, and then we had Mr. Mgeni. He went on trial and he got life in prison. So the evidence, insofar as Mr. Diwani and the interactions between him and Mr. Tonga, of course, there was a single witness. But if one had regard to the evidence holistically, Minister, one was able to construct that insofar as the events as they unfolded, there was corroboration for the explanation that Mr. Tonga gave. An important part of the evidence there, Minister, was when. So the couple stayed at a very luxurious place. They decided to go and have supper at a restaurant that not even I would take my wife to on a Saturday evening. No reflection on the restaurant, but these are wealthy people. And on the way to the restaurant, and our thesis was the reason why they had to go to a restaurant in the Strand was because that the plan was to take the vehicle into Guguletu, and for the murder to happen there. And so we have a situation where, and I'm explaining the evidence so I can come back to the criticisms, Minister. We have a situation where on the way to the Strand, the vehicle goes into Guguletu, and supposedly it's to go and see the nightlife in Guguletu, and to see Mzoli's and what township life is like. But in real terms, as part of our case, in real terms, what must happen is that the assailants have predetermined where they're going to meet with Mr. Tongo at an agreed point between NY, I forget exactly which NY and which NY, but that was the agreement. So what happens in practice? They set off, they go into Guguletu, but the assassins are not in place. They couldn't get transport. Huh? So by the time they get to Guguletu, now nothing has happened, and so now they have got to go to the Strand. They don't spend much time in the Strand. Tonga's version is that Mr. Diwani is badgering him, but this was supposed to happen, do something. So the
Advocate Mopp, we might not have the luxury of time to listen to the whole.
Okay.
The issue I'm raising, you are the lead prosecutor. This femicide. And the criticism is that because the case was thrown out of court for insufficient evidence.
Yeah. So
that's why I'm linking it, hence I said it's about performance.
Yeah.
Now, I moved from the performance of the institution in the Western Cape, and I've moved to your performance.
Okay. Let me deal with it more crisply then, Minister. So the judge felt that she could not rely on our witnesses. Huh? And when I was interviewed about this by the media afterwards, I said, in my view, a different judge would have viewed things differently. One of the mental blocks, and I say this with respect, that the judge had was that she could not accept that one of the witnesses himself was not a criminal because he knew criminals. Now, if you've grown up in the township, even if you know township life, you know you can be on the straight and narrow, but you know where to get dacha, you know where to get mandrax, you know who the guys are breaking into houses, you know who steals cars, you know all of those things, but it doesn't make you a criminal. And so at the level of analyzing and evaluating the witnesses, the judge was unable to distinguish between law-abiding citizens who are coming to offer. Of course, they were part of the conspiracy, no doubt about it. But it doesn't mean that because they were part of the conspiracy, you can disrupt all of the evidence. So that's the one witness, the 204. She didn't believe him because he happened to know criminals. Mr. Kwabe, when he testified against Mr. Mgeni, was a very good witness. The morning before I was meant to lead his evidence, he confronted me through his lawyer that he wanted a reduction in his sentence for him to testify. We had entered into the plea and sentence agreement with him. He got 25 years, but as part of the stipulation was that he has to serve 2/3 of his sentence before he's eligible for parole. He wanted that to be removed from the 105. And so the quality of his evidence, Mr. Kwabe, compared to the person that I led against Mr. Mgeni, he was a very different person because he wanted to extract something from me. And of course, we cannot compromise, Minister. Firstly, it's not permissible for me to do that. And I disclosed that to the defense. I had to disclose to the defense that this witness has now tried, on the morning of me leading his evidence, tried to engineer a deal with me for his evidence. So that was another important witness. Even the family of the deceased were shocked at his evidence.
So it's not necessarily that the judge didn't believe him. Because when you started, you almost gave that it was the fault of the judge. That didn't, you say the judge seemed to have had a mental block. But as you explain, I don't know what word you use, almost like mental blackout. But as you explain, there was a problem with the witnesses, as the judge has made the decision.
So, Minister, I was referring to a particular witness. I referred to the 204. The 204, that's the context in which I made that point. So Mr. Kwabe was not as good as he was in Mr. Mgeni's trial, but, Minister, I would not, on the basis of his evidence, despite that, have dismissed his evidence outright. Zola Tonga, once again, gave his evidence years after the fact, may have made some errors, but in the main, I felt there was a sufficient basis for the accused to be placed on his defense. The judge had a different view, and she exercised the discretion. So it is not a question of basing it on one individual. And certainly, Minister, I've asserted this before, I do not think that me leading the prosecution is what resulted in that outcome. Not my capability, not my ability, not the way we presented the evidence. If I can go to...
Mm-hmm. Yeah, I'm getting a bit confused, Advocate Mopp, because a 204 witness is an insider. Mm-hmm. It cannot be someone who is in the community who knows criminals. Mm-hmm. The 204 is an insider who now is going to give the prosecution critical information so that they secure conviction in return for them being exonerated or getting a lighter sentence. I just wanted to clarify that, because the way you put it, it was almost like it's this community member who, as a result of being a community member, may have come across the information and wanted to help. No, a 204 is usually one off. I just wanted to clarify that.
No, thank you very much for that. I mean, I try to restrain myself with giving too much of the facts, but I mean, thank you for the opportunity. So the context of this particular individual was that he worked he was a receptionist at the hotel. Mr. Tonga used to ferry passengers there. So how he became involved, Mr. Tonga asked him if he knew of anyone in the township who could do something. People who had access to firearms, and because he had met Mr. Kwabe at Mmamoloko Beach on one occasion, and Mr. Kwabe had bragged about what he's involved in, he thought of him immediately. So that was the context. Then, of course, he became involved in the. So his role was he was the intermediary communicating. Mr. Tonga would communicate with him. He would communicate with the assailants, and as much as I said to him that he was a project manager, in his own mind, of course, you know, the individuals sometimes try and downplay their role. But that was his role. So he was an upright citizen, but knew people, and that is how he became the 204, because he was the intermediary between Mr. Tongo and the two eventual hitmen.
Mr. Mutlu?
Thank you, Minister. Mr. Mopp, what I want to establish from you is when this 174, Section 174 discharge was granted, the judge made a remark with regards to lack of corroboration between the three witnesses. And that talked to the issue of credibility. And me and you understand that there is case law with regards to how credibility will impact an application of that nature. It will be in cases where the evidence is so dilapidated that the credibility of evidence presented is so poor that it cannot be relied on. Now, for the court to arrive at that, the prosecution ought to have foreseen at a very minimum in terms of evaluating prospects of success, looking into the merit of the matter. You should have been in a position at that stage to make that call and determination and make a decision whether or not to still pursue prosecution. Don't you think that failure to make such consideration is in an indictment on you, a direct indictment on you, in terms of poor judgment in handling this matter?
No, thank you for the opportunity. And no, I do not think it reflects on me, sir. We did exactly that. We knew it was a high-profile matter. We had spent years trying to get the gentleman here with the assistance of the British authorities. So it was certainly not a question of us not having done a proper evaluation of the case. We did exactly that. And that is why I say the judge exercised her discretion to say she was of the view that the evidence was of such poor nature that he shouldn't be placed on his defense. And we had a different view, but she exercised the discretion. So it's certainly not a question of us having done that. The person who prosecuted the case with me is herself a very accomplished and seasoned prosecutor. She heads up the organized crime division in the Western Cape. So certainly, so we were not wrong to prosecute.
Just a follow-up on it, Minister. Surely there were other avenues at your disposal. There was a legal remedy or recourse at your disposal in the event that you were of the view that the court erred in its findings. There could have been an avenue that you should have explored, which you failed to do, which would be to appeal that decision.
Yeah. So you're right when you say we didn't explore it. It doesn't mean we didn't consider it, sir. We did consider it, and whether we should get to the point of filing the appeal. And after our analysis, we concluded no, we shouldn't do that.
Thank you.
To the next one.
Sorry, Minister.
The SARS unit officials.
SARS, yes. So, Minister, I'm not sure my role. I was on the review panel. Myself and two senior colleagues. The leader of the team was a DPP, together with another senior deputy, and we reviewed the evidence. And our conclusion was correct, Minister. It's not a question of being timid. In the main, I drafted that report based on the work that we did, and of course my colleagues contributed, and eventually the leader of the team settled the document. But that is one of those instances where I also thought the people involved here should explain themselves. Because, Minister, that docket was several lever arch files. And it was clear, you read the affidavits, you read the investigating diary, and the investigation is going towards Polokwane. Then all of a sudden, you see, no write-up in the investigating diary, but the investigation pivots. All of a sudden, these three individuals become the focus, and that is pursued eventually. And the memorandum which was prepared to get the concurrence of the DPP in North Gauteng was not an accurate reflection of the quality of the evidence. So I take exception to anyone who says that I am timid to prosecute. I reviewed the documentation. We wrote up a detailed report for the NDPP to consider, and it was clear there was no basis for that prosecution. And I lament the fact that the colleagues who took the decision have not explained themselves so that we can engage and understand how could you arrive at the decision, because from what we read as that review team, there was no case.
Does that mean, I'm going to take you back as I conclude and give over to my team, to the panel. Is that having any, because this I picked up from the media. So this has been an analysis by the media. Is it one of the areas that has influenced? Because earlier on when you spoke about the media, it was quite interesting. I think Prof followed up on your views about how the media reports. Is this one of the areas that has led you to have that perception?
Certainly, Minister. I mean, if the accusation is that we are timid to prosecute based on a recommendation not to prosecute particular individuals, then yes, because those individuals do not know what the substance of the docket is. It is the docket, the facts in the docket, and the law that governs decision making. If you don't look at I always say, when you go through your process, it's the law and the facts, and that decision may have consequences. Your manager manages those consequences. You don't look at the consequences and take a step back then and reconsider. So yes, I mean, if it's different if it's informed criticism. That's why I said if one could engage with the colleagues who made the decision, then you would have a better understanding of what led them to that position. Minister, we didn't deal with the 32 million tender. I'm still not familiar with that matter. A tender at Parliament that I met with a complainant.
It was reported to you, I want to offer it. You were head of the DSO, and then one of the issues that led to, it's a parliament, and I want to get the full name of the company that was involved in the 32 million tender. But the complaint was that at that time that members of the DSO had communicated, but it was during the transition where it was being disestablished. I don't know if you remember that. So the concerns was about not being able to deal with the matter, referring it because the DSO was being disestablished and therefore didn't have to.
I have some vague recollection of that, Minister. But if I say that it would have been in the context that we had no legal authority anymore to do anything, and that because once the DSO was being dissolved, because part of that process I spoke about earlier was not only about personnel, but it was also about case transition, taking cases from the DSO, moving it across to the police. So if I say that it would have been in the context that I no longer have legal authority to do anything, and that it now has to go to the police. Huh?
Okay. No, the context I was coming to was your analysis around the media perception, how you've been reflected even in the media, whether it informs feeling that it has been negative towards you.
Well, not to me, Minister. I mean, I take criticism, and where criticism is warranted, I'm the first to put up my hand and say, I've heard you. But when it is unfounded, then I have to at least try and set the record straight. And so to the extent that the allegation is, or the assertion is that I couldn't assist the complainant, it could only have been in the context that I no longer had legal authority to do anything, and that the authority now vested in the police, and that the police would have been the appropriate vehicle to deal with that matter. Because, Minister, just to emphasize that point, so prosecutions remain in the prosecution. So if a matter had matured to the level of a prosecution, obviously that was retained. Like J. Arthur Brown is one of those where the prosecutor dealing with that matter transitioned into the DPP office and continued dealing with the case. But investigations, of course, the NPA no longer had investigative power. And that was in the police then.
Let me ask Mfundisi. We'll start with you now. Okay. Mafundlela?
Thanks, Commissioner. To the extent that you may have been in the prosecution space for this longest time, Advocate Mopp, I just want to get your sense. If anybody or society is having all this outcry about possible political interferences in your space, and I call it that's your space because you have been there for this 33 years, what would be your immediate answer? Would you agree? Would you disagree?
I would disagree. And speaking for myself, I've always said I'll be happy to go to a court of law to testify that no one has ever tried to influence any decision that I've had to make. I'd be comfortable doing that. And I would like to believe that all of my colleagues would be able to do that. Of course, there have been contexts where the allegations have been made, and those are, once again, it's a handful of cases. But because they are prominent cases, the narrative then becomes that you are captured. I went to the deputy minister at an event somewhere at Alliance Française. I even forget what the topic was about, a member of the public just passed and said, because I was introduced as an NPA member, I wasn't in the DS, I was in the NPA. Oh, the NPA is captured. Huh? And I thought, okay, so do you have the engagement? I mean, it was just a little passing comment. And so I take to heart. Huh? And despite that, I am never embarrassed to say I work for the National Prosecuting Authority because of the good work that colleagues do. I recognize that there have been mistakes. I recognize there are question marks in some instances, and I too also want answers on some of those. Some colleagues have started saying they work for the National Ports Authority, and it's a sad day if you have to place yourself under Transnet to get away from the NPA. So yeah, it's I would like to think that my colleagues can all offer the same that I'm offering to say. I'm confident I can testify that it doesn't happen to me, and that they were able to do the same. And I'm not including the 6 or 8 that I say there are question marks about their conduct, and that must all be accounted for and explained. Yeah?
So if elevated to the NDPP, that would be your approach to things. You'd be able to say, in all these peculiar cases in which we may be perceived to be politically influenced in taking these decisions, your approach would first be, let's then clean our house, review these matters and see if perhaps there is any credence to the criticism.
Certainly, and not necessarily on the basis just of speculation in the media. But where even within the organization, people have said, okay, we don't know the facts here, but we would like to understand what transpired here. It's important, and that's part of that process. And the process I was talking about is not a cathartic process to say, let us know who did what in the organization. It's not that. It's for that very reason, so that we know who did what. People can be held accountable, and conversely, people are afforded an opportunity to state their case. And they may very well convince us that their conduct was rational and lawful, because that is required for us to build the team. If you still have doubts about, I'm not so sure about this, it's not healthy. And it feeds into this narrative, that there are problems in the organization. So it may be cathartic. So, but that's what I'm saying. It's not the objective is not to have a cathartic experience. It's fact finding, making determinations, and remedying where remedy is required. And where people have been vindicated, also communicate that we've investigated, we've interrogated, and in fact people have given rational explanations, and that their conduct was lawful, so that we build that team I'm talking about.
Thanks, Minister Mda.
Prof. Next.
Can I write on that question, because I think we've been skirting around it? What's your threshold to say an organization is either captured or has internal problems? Should it be a majority of cases, given the sensitivity of the sector? Imagine if 1 or 2 judges were found to have been compromised, the perception out there. It doesn't have to be a majority. Even when we talk of the state capture, you don't have to say we have 30-something departments. Only 5 departments have a problem. What's your threshold? Because I'm struggling with this notion that no, it's a few cases there. And yet, some sectors, it could just be few sectors, and the perception, given the scale, the scope, and the impact they have on society, it become that generalized perception.
So to answer the question crisply, the threshold is 0. And so that's why I'm lamenting the fact that we haven't had a process where we can demonstrate and account for those particular cases. And so that is why it festers and lingers. Because there's no communication, there's no determination, a definitive statement to say, but this has been an issue in the organization, we've interrogated it, we've lanced the boil, this is what we found, and communicate. So when I say 0, in other words, we cannot afford to have even a single instance of a perception of being captured. So that's the 0 threshold I speak about. It is untenable to even have that mentioned in the same context of the NPA. So any instance of that nature must be addressed and dealt with.
Let me come on that one again. We know for a fact that there has been attempts, sometimes successful, of political influence on the NPA. And as such, you have lived long enough in that organization and you have not made a very clear categorical statement in your assessment of those moments. You say, no, it might just be a few individuals here and there. And yet, in society, they know for a fact that there has always been this pressure, and as such, no other NPA director has lasted and finished their term.
So just for context, so the one that we know definitively is Mr. Piccoli, because that was ventilated. He was able to demonstrate an attempt to influence his decision-making. So that's been ventilated, and that's why we can say categorically that that is a firm instance where there was an attempt by an executive member to interfere in prosecutorial decision-making. So that one is clear. The others I speak about, Professor Fikeni, is where we don't have that clarity, and that is I'm saying, that's why I lament the fact that we don't have that clarity. Because for us to make definitive statements like we can in the context of Mr. Piccoli, we need to have the facts. And from where I'm sitting, I don't have the facts, and I don't think that society has the facts. And even within the organization, maybe there are a few who have perceptions, but we don't have all the facts. And that is the opportunity that I lament that we've missed, for us to be able to get to grips with what exactly transpired. And as I say, it may be at the perception level where even I think, but this conduct, I would like it to be explained, and that someone may be able to offer an explanation. And so that's the opportunity that I.
So to you, only Piccoli case out of the many successive cases, you would say definitively, this is the case of political influence, whether successful or not.
So I'm very clear to draw a distinction between that one where it was definitive and where there are allegations of interference. And that one, the point I'm making is that one, the interference was demonstrated. In the others, we have not seen a clear demonstration of that influence. There may be very strong views, there may be very strong perceptions, but that does not carry the day. Can I maybe just by drawing an analogy? The other day, I heard a comment, and this is a matter that I was involved in. The comment was, in that particular case, the police believed that the accused was guilty. Now, I was involved in that case. And it may very well that the police believed that the accused was guilty. But there was no evidence to suggest the accused was guilty. And so that's the distinction I draw between having the perception and having a factual basis to make a statement like that.
You covered. You are covered. Okay, you come on that side.
Thanks, Minister. There's one aspect that I wanted to probe you on. What is your understanding of transformative constitutionalism within the ambit and context of prosecutorial function? And as you attempt to respond to this question, please cover the aspect of your role as NDPP in operationalizing it.
It's an interesting question. I mean, I must say I haven't really reflected on that in that context, because normally I would look at the transformative agenda within the Constitution is to try and look at society broadly and how we seek and how we achieve redress more broadly. So the NPA is unique in the sense that it is not a typical government department, and I say that not in a pejorative sense, but with respect, because it's a unique function that the NPA plays. And so without having given it too much thought, off the cuff, I would say to you, sir, that there is limited scope for the NDPP to play a transformative role in terms of the broad context of society, because you are charged with the responsibility of making decisions without fear, favor, and prejudice within the context and the confines of the criminal law. So in terms of playing that role as a decision maker, I say it is a limited role. Where there is scope for the NDPP to play a more broader role in terms of a more transformative role is in the prosecution, broadly speaking. The composition of the prosecution, there you have greater scope to ensure that the transformation agenda that government broadly seeks to achieve, that you're able to participate in that, to give effect to it, and to ensure that the NPA is a transformed organization. Not decision-making, but in terms of how you conduct yourself. In other words, are we really able to, as an organization, to say that Batupile means Batupile? Are we living that expression as an ideal, as an organization? Are we treating our people with respect and with dignity? So that is where I see, in that broad rubric of a broader responsibility of the NDPP and the role that the individual must play, that is where I see that transformative role manifesting. I would be reluctant at this stage to say that it is within the context of decision-making. Because unlike the judiciary has a role to play there in terms of how they interpret the particular statutes to give effect to the transformative aspirations of legislation. We are not in that position. We're dealing with criminal law. I always like to say it's right and it's wrong, it's black and it's white. My wife is a psychologist, and she says there's a massive gray area that I overlook. But it's the law and the facts and decision-making. There's no role for a transformative agenda in terms of decision-making on a case basis. But taking a step back and looking at your role more broadly speaking within the organization, certainly there's scope for you to play a role and to execute a transformative agenda in the organization.
Thank you very much. I think we'll go to Mr. Mavundlela on the public comments. It's your part as we conclude the...
Thanks very much, Minister. Advocate Mopp, it's interesting to me, and I believe to everybody who would have then realized that members of the public who commented on their perceived suitability were only 5. I'm not sure whether it's because you're not very well known, or because you do a lot of good things.
I'd like to think it's the latter, sir.
or whether you you are those kind of people who does their work and just walk away and never look for accolades. But whichever way that it comes about, be pleased to know that none of them is actually objecting to your possible elevation should the president feel that you are a capable candidate to be put in that position. So I just thought I should let you know of that, because I know that the panel would not pick up anything on public comments that are either negative on your name. So you can rest assured that as you try to do your work harder every day, the public is watching you differently.
Thank you, sir.
Thank you, Minister.
Maybe you missed this one. There was somebody who actually commented that you were too junior.
Yes.
Did you notice that?
I noticed that, Minister, and I hope you read my response, Minister. Huh? Because I think, and I say this with respect to the individual who made that comment, the person focused only on my rank. The person didn't look at my experience in the organization, the different roles that I've played, that although I've been based in the Western Cape, I've played leadership roles at a national level, and that my experience broadly, and my submission to the panel was reflect my experience broadly in the organization, what I've done, and then measure me on my interview here today as well, and not focus on title or the position. As I said, I've always seen myself as a national leader, and I engage as a national leader. In as much as I don't let the title restrain me in terms of my engagement, I don't let the title dictate or assert authority. It's more about influence. And I think I offer that within the organization.
The other one, I think Mavungela went through. The other one is on the lifestyle audit, which I think you did. But the person says you are since compromised, and I think you responded.
Yeah.
Can you call that?
Minister, that individual, I mean, I hope you read it, and I must apologize, but some of these things you've got to put in context. Yeah? The allegations that were made against me that I was trying to favor a friend who in fact had no real authority, and that is why I took the trouble to demonstrate to the panel the process that one follows, my interventions, how my interventions came about.
Oh, this is in relation to Mr. Dana.
To Mr. Dana, yes, because that's the same individual that says I'm compromised. Huh? It's in that context. Huh? And hopefully the panel will appreciate the detailed response I gave to demonstrate that it's not true at all. Huh?
Please explain publicly, because this process, as others say, it's a public process.
Certainly, Minister.
We don't want to make evaluations secretly.
Certainly. So a member of the public wrote to the panel indicating that I'm a compromised individual, that some time ago I protected an individual that is a friend of mine that I used to work with, and that I withdrew a Section 252 authorization, and goes on to list a number of allegations about impropriety on my part insofar as the Section 252 is concerned. So for the benefit of the public, Section 252 is a provision in the Criminal Procedure Act that authorizes a Director of Public Prosecutions to authorize conduct by the police, not be called traps and undercover operations. So there are certain thresholds that the police require the authority of a Director of Public Prosecutions to conduct those activities. And in the Western Cape, that is one of my responsibilities. And so there's a process where the police, in writing, submit their application. I consider the application. If I have concerns, I write back to the coordinator, who is the interface in the police, with the applicant. We try and resolve it on paper. If not, I meet in person with them to explain my concerns or seek greater clarity. So in this particular instance, this was what they call an intelligence operation. In other words, the outcome of the investigation would not be a prosecution. It would allow the police to broaden their information with a view to then subsequently conducting what we call court-driven operations, where the objective of the operation is to secure an arrest and a prosecution. So this was what we call an intelligence operation. So members of the South African Police Service who were based in the crime intelligence wrote, and they wanted to conduct I don't want to use legal technical terms, but it's in the parlance it's a reverse thing. In other words, so they were going to provide the contraband to an individual. And so the objective here was to infiltrate a group of Chinese nationals who were operating in the illegal abalone space. And the idea was to obtain abalone and transfer this to China, to these individuals. And normally, Minister, when this happens, the resource is normally held by the Department of Agriculture, Fisheries and Forestry, DAF, as the custodian of the state resource. And so they play a critical role in empowering the police to do that. And so normally when there's an operation of that nature, DAF are the ones who make the abalone available. So I had a number of difficulties. I won't go into all the details on the first iteration of the document. And I sent it back with comment. I received the second one. I still wasn't happy. And I then called for a meeting with the operatives. And the proposal had moved to the point where they wanted to now use a legal company to export illegal abalone, on the face of it, illegal abalone. And my fear was that a legitimate company is now going to put illegal abalone through its books. They have to declare the revenue, and there will be tax implications. And so I invited my colleague from the tax unit. We had a discussion with the team, gave them some feedback. They knew I wasn't happy with the application. I reduced my concerns to writing again to the police coordinator. And then I went on leave, my annual leave, and the application came back, and a colleague of mine approved the application. Of course, I was on vacation. So when I returned in January, at some point I received an application from the police, an amendment application. They wanted to change the operatives who were working on the operation. And I authorized that. It was a change in personnel, who was the coordinator, etc. The same day I got a phone call from Mr. Dana. And it's okay if I mention his name, Minister, huh? But he's a former colleague. He worked with me in the DSO. He was a senior state advocate, and he reported to one of my deputies. He called me, asked for an urgent meeting. There were some concerns. So I granted the audience, and an entire team arrived. A brigadier from crime intelligence, together with the colonel. The colonel was the direct commander of the applicants. The brigadier obviously is in charge of the entire component. A brigadier from the DPCI, and then Mr. Dana. And the brigadier and Mr. Dana were the ones who actually led the discussion, and they were explaining to me that there were a number of concerns that they had with the operation, that DAF had asked the police to comply with a number of conditions, which the police didn't comply with. And so the brigadier's appeal to me was to withdraw the authorization. So even though I didn't issue the authorization, because it's my portfolio, I'm entitled to withdraw the authorization. But I wasn't happy with the verbal briefing, because that's not how you do things. So I said to them, reduce your concerns to writing, and I'll consider your concerns. Of course, on the face of it, the concerns were valid, on the face of it, but these were verbal explanations to me. A few days later, I received a request in writing from the head of crime intelligence, a major general. In other words, the operatives are within that component. The brigadier, the colonel was with the brigadier spoken to me, and now the general, who's the most senior person in that entire division, writes to me, explains the non-compliance with DAF's requirements, and requests me to withdraw the authorization. So based on the written request, I issued a directive to withdraw the directive. In other words, the directive becomes null and void, and I asked them to reinstate the situation before the authorization was issued. So what that means in practice is now the abalone that the police have, that the operatives have, must be returned to DAF as the custodian. The abalone that's returned to DAF is not the same abalone that went out. It's poor quality, it's more slime than anything I'm told after the fact, and of course there are many concerns. So Mr. Dana, who had spoken to me in the meeting, had also mentioned that he's preparing a report for his Director General on this very issue. And of course, I don't know what transpires between him and his Director General, but the next thing that happens is I receive a letter via the DPP requesting me to assist the DAF investigation into what transpired in this particular instance. So I did that. I prepared an affidavit, much along the lines of my explanation to the panel of the sequence of event and what transpired. And I subsequently testified in 2 disciplinary hearings of DAF members. So the public comment was that, firstly, I tried to protect Mr. Dana. Mr. Dana was one of the targets of the operation. It's just the furthest from the truth. Mr. Dana was, in fact, the person who alerted me to the wrongdoings, ensured that the police were able to write to me to withdraw the authorization, and tried to remedy the wrong. But unfortunately, the damage was done. And you would have seen, Minister, from the documents I presented, that there was disciplinary hearings. There was also a public protector investigation. And so the allegations against me that I favored Mr. Dana is the furthest from the truth. In fact, Mr. Dana should be commended for the role he played here in trying to assist the state.
Thank you. I thought it's important because it's a public comment, so that it's not seen as if we didn't deal with it. The other area I want you to deal with as the last one, because the others, it's more around whether you'll prosecute white people, whether you'll prosecute friends, and I see I don't think there's a basis, but there's this one, which you are saying you don't know anything about, and I want you to go on record on it. The Walker Bay canners, part of IJ, exported lobsters illegally.
Yes, Minister, I saw that and I was intrigued. Walker Bay Cannery, part of I&J, as they say, and Glomax was the second company that I mentioned. I actually Googled that to see which companies these were, and it seems these are companies that are based in the Western Cape, in the Hermanus area in particular. And where I saw their names was actually in an official government document that they were two companies were amongst the companies that were getting quotas to harvest legal abalone. But the comment also makes no allegation against me, Minister. It just says it makes those statements in the context of the 252 operation, but it's not relevant to the 252, and so therefore all I could say is I noted, but I don't. No allegation is made against me.
Okay. Yeah, I just wanted you to reflect it because, no, it's linked to the 205. So I saw the lobsters as well.
Yeah.
A link to that. I thought, let's clear it. You've never had interaction with this company so that we close.
Maybe as context, Minister, the company that would have been exporting it, I don't recall it being any of those 2 names,
Okay.
just for the record.
Okay. No, thank you very much, Advocate Mopp. I'm happy to announce that we've come to the end. I can see the smile as well. Come to the end of our interaction with you. I want to say thank you very much for availing yourself and coming through and having this conversation with us. And wish you all of the best. Travel misses. I know you delayed your travel. Hope you don't miss that flight. You are able to get onto it.
Minister, I was quite emotional early. So can I take the time now to thank you, firstly, for the indulgence. I know it's an indulgence. I mean, I had no right to request, and on behalf of my family as well. No, I can't miss that flight. I'll be in trouble. So thank you for that indulgence, and also thank you for the engagement today. I appreciate it. I appreciate the tough questions. That's what it's about. Huh? It's not meant to be a walk in the past, and I hope that I've been able to demonstrate, firstly, my ability to engage with critical questions, my ability to offer solutions, because I do believe that I have the ability to lead the organization, to inspire confidence, and to be the next NDPP. Thank you very much.
Thank you, Advocate Mopp. We'll take lunch break for 30 minutes and resume. It's fine. Let's get Advocate Johnson in. Good afternoon, Advocate Johnson. You can settle down. Hope you're well, and apologies for keeping you waiting. We delayed a bit. We're running late with our schedule. Yes. Do you have a copy of your questionnaire with you? Not yet. Please just make sure that she's got it in front of her. I'll give you a copy. While the team, I'll explain the process while they get you the copy so that you can have it in front of you. We're going to have, let me start by the panel. I hope you're aware of the panel members. I'm going to ask you to switch on your mic.
Good afternoon to the panel. Good afternoon, Minister.
Good afternoon, Advocate Johnson. I'm going to, the first, how we do the interview is the questionnaire that we send you and you completed. We'll take you through. We allowing both the panel and the public to get to know you. After that, there will be questions from panel members. And then I must check who's taking you through the public comments. Okay, Mr. Motloung will take you through, as the lead person from our side, all the comments that we've received. We've sent them to you. I think you got the highest comments.
I have, and not positive comments, but I do accept the comments, and I know we'll deal with them as we go through the process.
We will deal with them at the end, so you'll take you through so that you go on record, responded. But we have also received your response in many of them. I'm going through that. In terms of your response, so we'll deal with that. You don't have to pressurize yourself in between to answer them. We'll give an opportunity just to go through what has been asked, and then you can deal with. As we go through, Section 1 deals with your personal information.
Correct?
In terms of, you don't have to switch it off. Did you get the copy?
Not yet, Minister.
Not yet, or they're still, okay, let me wait a bit so that you have it in front of you. Oh, okay. Prof says there are no commercial breaks, unfortunately for me.
Thank you, Minister. I do have a copy.
Okay. Section 1 deals with your particulars. I'm not going to read them out, but move immediately in terms of your qualification. So would you take the panel through how these qualifications are relevant as you have them to the position of being a National Director of Public Prosecution?
Thank you, Minister and panel.
Let's ask them to move your mic closer. Move it closer. I don't know. They seem to have moved it a bit. The other candidates, we could hear them clearly.
Am I more audible?
Yes, perfect.
Thank you. Minister and panel, I studied for a B.Juris degree, and many, many moons ago when I initially enrolled for that degree, back at the time at the University of Durban, Westville as it was, that was the bespoke degree for prosecutors. Ordinarily, those who wanted to go into the profession as attorneys would do the B.Proc. I had always wanted to be a prosecutor. I then studied for an LLB degree. And then when I joined the Directorate Special Operations, colloquially the Scorpions, I realized that having investigators and prosecutors under one roof meant that I needed something more than just those two qualifications. And I then enrolled for a diploma in criminal justice and forensic auditing at the University of Johannesburg. And what these degrees do is they have given me a different approach to how I go about looking at crime, looking at the criminality, looking at evidence, and how to assess and judge, both in terms of evidence and the law. It has held me in good stead in terms of being able to deal with a varied type, as the panel and Minister would see from my legal background. It has helped me to deal with a whole host of matters. So in terms of being a national director, it gives me a strong legal background, a strong legal framework. What it has done is, having put me in the prosecution service, having exposed me to the kinds of work I've then had to do, the managerial roles that I've had to play, that then says, let us look at her. Should she then be considered as an NDPP? It is not foregone conclusions that these legal requirements actually put you in that position. It is the experience that has allowed me to be considered.
Let's move to that area there that you're talking about the experience. The mic is off, sorry. Let's move to that area of your experience, and I'll just go through as you have summarized it. 96 until 98, a prosecutor.
Correct.
98 to 2009, state advocate.
Correct. In 1998, yes, till
1998.
2004 April was a senior state advocate.
Okay, yeah, we'll come to that. Because I'm looking at it, perhaps maybe you'll have to explain.
Sure.
Because I'm noticing that you've got state advocate and then you've got senior state advocate, and they are overlapping. June 1998 until November 2009. And then you've got senior state advocate, December 1999 to March 2004. Would you explain that one? Because there's an overlap there.
Unless that...
Just under 6.
My apologies, Minister. That would be a typo.
Okay.
The state advocate is from 1 June 1998 to 30 November of 1999.
Of 1999, okay.
1999.
No, it's correct.
Then the senior state advocate from 1 December 1999 till 31 March 2004.
Okay, so that has been corrected. That's why we want to go through properly so that we have
Understood.
the record. And then you've got under the DSO, senior DDPP, 2006 to 2009. That's correct.
That is correct.
And then again, until 2019, just explain that one. So you moved from DSO, but when you moved to NPA, it was still the same position.
It was still the same position. It was when we were disbanded, Minister.
Yes.
So you kept your rank. You, however, chose an office, and I was allocated by choice to the DPP office in Pretoria.
In Pretoria.
Yes.
And then you moved then to the head office from 2019 to 2022.
That is correct.
And then you became the head of investigating directorate from 2022.
1 March 22 to date.
Till to date, okay. Then we move, this one you're saying you moved from 2022 no? to date?
To date.
Okay. And then as we look at that, in terms of your work experience, if you can tell us, in terms of your areas of involvement in law, as per the areas, I see here you've flagged some of the issues, your legal background, in terms of the areas, criminal law, all matters are related. Administrative law, you didn't explain much. You just said none except labor matters. And then on constitutional law as well, you just said that it's just filing papers. Maybe explain that. You didn't provide more details on that one.
So in terms of the administrative law, I always, and if I'm wrong, I'll be corrected, I always saw the involvement of prosecutors in the disciplinary processes as part of an administrative process. And so that is where the overlap between administrative as well as labor, because it is a different issue, it is also dealt with differently, Minister. And that, I hope, clarifies. In terms of constitutional law, it is in relation to the criminal work we do, but in the matters where applications had been brought against the NPA, to wit, in some of our matters, both in the Celebi and the Pistorius matter, there was then the filing of constitutional law papers, applications being filed in the Constitutional Court. However, in both those matters, the NPA was fortunate in that the justices decided on the papers and therefore did not need to hear us on both those matters.
Okay.
But that would be the full extent of my involvement actually in the constitutional law framework, Minister.
And I see you've been appearing in court. You stopped appearing because you are now head of IDEC.
My last matter, yes, was November 2021. I had always liked to prosecute. I was one of very few deputies or a senior deputy that still wanted to go to court. I did organized crime matters. I had an affinity for cash in transit matters, organized corruption, crime matters. So yes, I was in court. And I think that also helps me a lot. I get to see people differently, and I get to see the institution differently.
Okay. Let's go to your managerial level in experience. I think the Section 3 deals with prosecutorial experience, which we have dealt with. You've been a prosecutor almost all your life. We're moving into the managerial experience. You've not given us more in terms of what you are currently managing. I see here you're saying, I have supervised at any given time between 20 to 30 people.
That was
this
before,
is only at IDEC?
Before IDEC.
Before IDEC.
Before
it
IDEC.
says at IDEC. Okay.
Yes.
Take us through.
So how it does work, Minister, and I'm sure that you and the panelists are aware, when you are in the office of a DPP or you are the coordinator of a specific component, there's very few persons that you are responsible for, and that would limit the numbers. In my time at the DSO, I managed investigators, prosecutors, we managed analysts, and we managed the cases. But it wasn't more than 20 or 30 at a time. So
at the DSO?
At the DSO.
Okay.
At the DPP office, when I went there, you manage a team. It depends on which cases. Most of the time at organized crime at the DPP office, we did have a coordinator of organized crime. I was a deputy there. I then managed those persons whose cases I oversaw, and you also then managed, Minister and panelists, their everyday administrative issues. So whether it was leave, whether it was discipline issues, whether it was resource allocation, case allocation. But in the main, one managed their operational issues. And then as a manager in the office of a DPP, you then form part of the senior management structure of the DPP, and so you attend to ensuring that we achieve the annual operational plan, you make input into the strategic plan, and you ensure that the strategic objectives of that division and or component are achieved.
Okay. In that office, how many people?
In the office of the DPP?
Of the DPP, that you were reporting to you?
In the office where I was at the organized crime component of the DPP office.
So because of, based on the number of cases, it will be between 6 and 7 at times?
Give or take, yes, that is correct, Minister.
Okay. And then now with where you are,
at
IDEC, you can have your water.
I hope you don't mind. I have juice.
No, we don't mind.
Sorry.
Feel comfortable.
My sugar levels were running low.
Okay. No, it's okay.
So thank you. At IDEC currently, we are a staff contingent of 128. As Minister is aware, we are only a national footprint at this time, even though we have cases over and beyond the province of Gauteng. We are 63 females, 65 males, and we have quite a varied representation also in terms of our race equity. And we are quite proud that we are 63 to 65. And I think as the gender equity, we might overtake the males soon enough. We are still busy, Minister, with recruitment. In fact, last week, financial investigators were being interviewed. There were 33 positions, and interviews happened over a span of 3 days, 11 per day, and that process continues. So the staff contingent will grow, but the management currently is of 128, which includes myself.
And that's besides managing the Section 38s are managed by you directly, or by various advocates?
The Section 38s, I have engagements with them. It is preferred, however, Minister, that the Section 38s are managed by the Deputy Director who oversees that matter, given that it is a prosecution-led model, and because we have to account for the work. I would not be able to account legitimately for the work. Auditor General knows that when we sign for things, we must be able to say work was done, money is to be paid. So the practicalities are that they fall within a team.
And then tell us about your management style. You didn't highlight. Your form is highly summarized, so I'm going to probe quite a lot from you.
Absolutely, as Minister is entitled to do. Sometimes I think that I'm too much of a people's person, but I think that has held me in good stead.
What do you mean by that?
I am consultative. We must talk to one another, top down, bottom up. It's not slogans. You know, Minister, when you come into a new unit, one that must still stamp its footprint, you have to know yourself. What that meant for me was, what would I want from the people who come to IDAC? And you cannot have them guessing. So it was lots of meetings. It was lots of operational meetings, getting to understand the landscape and what had come before me. My management style is to know my people. I pride myself. I'm perhaps one of the few who knows, if not 90% of the staff by name. I may not know everyone by first name. I will know them by their surname. I take the time to get to know them, because if you do not know your people's strengths and weaknesses, it becomes an impediment to how we operate. It becomes an operational issue. And I think the one last thing there for me, in an environment such as ours, it's not just gender and race and cultural diversity. We are bringing together people from different capabilities, different qualifications. Everyone knows better. Investigators want to be better than prosecutors. Financial investigators are better than criminal investigators, and vice versa. You have to be measured. You have to be tolerant, and you have to be understanding. And I think that has been how I have conducted myself.
Some people say that those who are consultative, they tend to be indecisive.
Consultation does not mean indecisiveness. Mm-hmm. In an environment such as ours, the first 2 years were consultative. Okay. Since IDAC became permanent in 19 August 2024, trust me, Minister, we have to be decisive. We are permanent. What do we need to do? We were given an opportunity 2 years prior to map the landscape. We are decisive in the things we do.
Okay. Let's move to the next segment, which is segment 5, section 5. You have indicated here you have not been suspended for any position. You've never been subjected to any disciplinary process. Correct. Can I confirm that? In terms of your office, in PA, we've got the Office of Ethics and Accountability. Have you been reported there?
I did receive a letter yesterday. Mm-hmm. That as a result of the complaints, one of those was escalated to the Office of Ethics and Accountability. I'm not sure what was sent to them. I just received a letter, Minister, that said, we have received a complaint. We will not be looking at it. It has been escalated to the Office of the Minister. But that was yesterday. I cannot give you details. I do apologize. That is what I got.
The ethics office didn't look at it. They're
The
escalating
ethics
it to
office
me.
looked at it and said they will not be conducting a pre-investigation. The matter is referred to the office of the minister.
Okay, I have not received it. We'll look into it. But as far as we know, there's nothing that currently
None.
has been lodged. Okay. And in terms of a complaint brought to you against anybody, you are saying none. Are you a member of anybody?
No, Minister.
Legal-
Except
you're
for,
not-
I think as prosecutors we are automatically members of the Legal Practice Council. But, I should say, way back when, prosecutors were asked to be members of a union. I am a member of a labor union. I have been since 2000, as are all prosecutors. I think whether you're at the PSA or wherever it is you are affiliated. But that is a membership. I don't know if, I don't want to miss
IDEC
anything.
is allowed for you to be a member of a labor, you know.
Not
Is
a-
it not
it's-
senior management that is not supposed to be members of
I
labor?
know that we all, I know many of us way back, I think this happened in 2000. I'll have to check my membership.
Please
I've never
check.
used it, Minister, to be clear. I've never
Because-
had cause
yeah.
to use it.
My understanding is that the minute you become a head, you shouldn't be, because you are now part of the employer.
Yes, I've not used it. And I don't know. If something has to be rectified, of course I'll rectify it. Not having used it, Prof, I'm not sure what the rules would have been.
I just want to check, when you say you've been a member since 2000, surely there are interactions if you're a member. Either you pay or you get correspondence, or are you saying it's a dormant membership?
I have only back in 2000 when I became a member, I know that it goes off my salary, but there haven't been communications because I've not needed to communicate, and they haven't communicated with me.
And it's still deducted up until now?
I'm sure that it still is.
Okay.
I don't want to say no. Then someone looks in my salary advice and it is. I will look, and Minister, I take your point. And I think it falls away in the sense of I've never used it, it's there. I do understand my responsibilities, forming part of a management where I'm an employer, and I will make sure that if that is an issue, that must be rectified.
I'm trying to check. We tend to be more vigilant for our own bank statements, so that even that 99 cents that is deducted for
Yes.
apps, you mean you haven't checked?
No, I'm saying I'm sure it is still being deducted, but I have no communication over and beyond the deduction from my salary.
Okay.
Thanks, Minister. Advocate Johnson, we have to get this one clear. You not having that engagement with the union
Yes.
does not impact on the validity of membership. You're saying you are a member, so the fact that you have never accessed the membership benefits,
Not at all.
that is actually irrelevant in as far as the validity of your membership is concerned.
Understood.
And now I just wanted to understand, is it your position that you were not aware that as a manager, senior manager, you are actually not supposed to be part of a union?
Absolutely.
Okay, thank you.
And hi, Advocate Johnson.
Good afternoon, ma'am.
How are you, ma'am?
I'm good, ma'am.
Thank you. And you are saying your specialty has been labor law in the main,
No, criminal law.
criminal law?
Yes.
Oh, okay.
Only
So
criminal.
labor law came in only when you are representing or dealing with NPA labor law matters?
Yes, and in all of
Okay.
those, I have only chaired in the labor law matters. I have not represented any employee in the labor law matters, given that as a senior manager, I saw that as an impediment, and we had long debates about those back in the day. But I had only chaired in labor matters of the NPA.
Okay.
Sorry,
Okay.
this is interesting. Advocate Johnson, you are a lawyer, right?
Sure.
And for all intents and purposes, if you were to chair any disciplinary hearing, there would be two parties there.
Correct?
And for all intents and purposes, one would be represented by an employer representative or an employee representative.
Correct?
Didn't you get curious, having signed the form at one point, about the fact that there is this relationship that you have with this body that actually appears before you as a chairperson in a hearing, and you are a manager, senior manager in the space? Didn't it occur to you, at least for you to be a little curious?
I haven't been, and I know that it's
Sorry about that.
sorry, I do not want this to seem as though it's a glib answer. It isn't a glib answer. It didn't occur to me because I was just doing what was within the mandate and what was expected of me. I chaired the disciplinary knowing that I had to be objective on all fronts. Who appears should not be relevant. It is the evidence that is placed before you. That is all that I could and did adjudicate on. If you start to wonder about parties, you make yourself prejudiced and biased to the process and should therefore recuse yourself.
No, Ms. Johnson. That's not even my point. My point is simply, you are a member of this union, you have joined it. And my colleague sitting there has said to you, the fact that you have joined this union means that there would be deductions, whether you received service or not, it's not the issue. All that I was at least interested in from you in this context is, having been a senior manager for that long, didn't it occur to you that for all intents and purposes, I've been a member of one of these unions, not on the basis of whether you like or you dislike any of the parties or you have to believe or not believe them, because that was not the part you had to adjudicate. What you had to adjudicate is the complaint that is before you, not the persons that are before you.
Correct.
But then I wanted to understand, that's why I asked you, didn't it occur to you to be curious one day to just wonder, what happened with my membership with this union for the past 25 years? That's all that I'm asking you.
No, sir, unfortunately, I didn't.
No, that's fine. Thanks.
Chair. No, thank you so much. Good afternoon, ma'am.
Good afternoon.
It's very interesting because, I mean, I just want to ask you a question. Is it the same if you're in a disciplinary hearing and the person is in front of you, the union rep is there, is it the same union or is it a different union? All the staff members in that unit of where you are, how many unions, perhaps I should ask how many unions are there, because there will be a majority union and which will be recognized, and if you're a member of that union and there appears to be a disciplinary hearing and here you sit and you chair and there's a union rep and there's the union member and you're also union member, doesn't that constitute a gross conflict of interest?
So, just to be clear, sir, I think the last disciplinary I chaired is well over 10 years ago. And I cannot remember which union would have appeared. But what I can say is in the past 10 years, I haven't chaired any disciplinary matters. And I am not aware of the memberships of the staff at IDEC. I think the only one that I am aware of, only because staff would indicate the PSA is having a meeting, and they would usually go to the head office at the VGM, but I'm not aware of their affiliations, to be clear.
Thank you very much. In these disciplinary hearings, there usually would be a declaration of interest up front. And I'm sure you might have gone through that exercise. And at that point, even if it's 10 years ago, did it occur to you that you'd also say, I'm a member of a union, even if my membership I'm no longer actively aware of? That's one. And also as senior managers, when you are negotiating salary, unions are negotiating this or that percent, didn't you take interest that my union is bargaining for this salary? Yes, I'm a senior manager, and so forth. What will be the outcomes and so on? Or even unions coming to say, as a member, would like you to advise us on A, B, C, D, E.
So on the second point about the salaries, you will find, Prof, if you speak to people at the NPA and colleagues who'd come with me a long way, that was one of the lesser things I did worry about. And I hadn't ever been approached by any union, let alone the one for which I have a membership. I left salary issues. As a senior manager, that had always been my take. If there is a salary progression to be given, we will be told by the NPA. I didn't engage. I never asked anyone to engage on my behalf either, not in all of my career, because that isn't why I was at the NPA. I am aware of colleagues who would have, but I didn't. And quite a few of us, by the way, I'm not a saint, quite a few of us did not, because the work came first. In terms of the first question, Prof, I honestly cannot recall. I know that we had to sign forms. I just cannot tell you which ones I would have signed at the time. But if it is an issue of contention, I would rather go back and look at it than give an answer that I'm not confident of.
Let's move on to this one. Let's move on. I'd like to go through the form section 6 on the financial and proprietor. Can I confirm that you hold no directorship?
Correct.
Nor any business interest?
None.
Okay. And you have declared that there's no health issues that would impede you from doing any of your work?
None.
I don't know if it's me who's mistaken, but I noticed on number 4 you didn't tick. Have you ever had civil judgments, maintenance order, debt review order?
Not. I think
you don't have?
Yes.
Yeah, because I see there on 9, I didn't have that, so I wanted to check that one.
None.
Okay. I think that's the questionnaire we had with you. Then I'll move to the next segment of our questions that will come also link even to performance, which other members will follow. Now, you've just taken us through what you are doing at IDEC and having to lay the foundation for 2 years, and therefore since 2024, formally starting to even fill the vacancies and closing. If you can take us through the vision, should you be appointed as an NDPP, what are the issues that we'll have to deal with and how will you respond in looking at where NPA is today and what you have as a vision of it for tomorrow?
So Minister, if I could start with performance. Currently, in terms of the NPA's performance, the 3 areas where the performance is not what it should be are the areas of corruption, the area of GBVF, as well as the area of organized crime in terms of what is ordinarily called serious organized crime dealt with by the DPCI, the Hawks. Coming in, what a national director would have to do is to understand what is it that we do not have, that we need to have as prosecutors and as an institution. What is glaringly clear is that in terms of the capacity, all of those specialized units need more capacity. But numbers doesn't of necessity equate to performance. We therefore need capacity that has the relevant capabilities. And to that end, Minister.
Explain that.
To that end, we need to ensure that the prosecutors are trained in those relevant fields. When you look at the aspirant prosecutor program, from what my limited knowledge, it tends to be quite generic. the prosecutor program has got to aim to attract and retain a higher graduate than what it currently does. It must also ensure that the prosecutors coming into the aspirant prosecutor program are not just trained on general crime trends that they have to prosecute in the lower courts. They must know what the NPA comprises of, what their career path will be, and we have to ensure that those in those specialist units also make input into the curriculum and the training of the aspirant prosecutor. We need individuals who will also be able to understand what the performance output of the NPA must be. You see, Minister, where we are, we often make the mistake and say to staff in a very generalized way, for performance, we need to prioritize. What does that mean to prosecutors on the ground? How does that equate to performance? And I say that is where our ability to communicate with our staff becomes important. A national director must ensure that the entire institution understands, one, the strategic objectives and what we need to do to achieve those. One may say, but as a national director, there are special directors, there are directors of public prosecutions. That's their job. I beg to differ. A leader must ensure that his or her people understand what the institution is about, what their role and function is, and what they will bring through their performance to the indicators and to the achievement of the NPA. So performance, together with training, becomes a critical exercise. I am aware also, Minister, that we have programs with School of Prosecution at Justice College, so that it's over and beyond the aspirant prosecutor program. Existing prosecutors are also going back for touch-up courses, an important course that they are going to go for, which had already started. And what I like is I think we use a retired judge, and we also use outside counsels on leading expert evidence. It has been a shortcoming. It therefore limits our performance in specialized areas. It also means then we are unable to achieve our indicators. We also then have, through the School of Prosecution at Justice College, money laundering training. But then we have to say, how does an NDPP and an NPA change the game in terms of the specialist units? What we are doing is, through the German-funded training, which Minister is aware of, that there is specialized training on organized crime as well as complex corruption. But the training then, which is quite different, is not just for the NPA. In those training programs, Minister, we have investigators from the DPCI as well as the South African Police Services. I know we have spoken to colleagues as well from the revenue services that where applicable, they are able to join those. So what it's saying is we are looking at managing the NPA's output differently by ensuring that we have a better, more capable staff. And then I think the last one for me would be, in terms of the main categories, is the morale of staff. We should never take people for granted, because disgruntled people can become quite an impediment to your operational activities and your output and your performance. You need to understand what brings their morale down. Is it just people who are disgruntled and grumpy? Is there legitimacy to the complaints and or the unhappiness they feel? And it becomes important that you don't take it for granted. But if you have the staff understanding that our work is to serve the people of the Republic, and we do that by ensuring we put out quality prosecutions based on evidence and the law, and that they are valued because that contributes to the output of the NPA, I think that is one way that we'd be able to just change that morale. And also, don't let people think that you favor one above the other. That would be the biggest mistake. Not all of us are equal. You do tend to build relationships better with some than with others, but you should never isolate staff and never let any category feel as though they do not bring something to the table. And where they don't, you've got to engage. Have your managers engage them about what it is that is going wrong and why we are not getting to where we need to get to as an organization.
Looking and listening to what you are raising now, Advocate Johnson, I go to your performance as IDEC and look at the statistics. This is the report that we've just tabled before Parliament. And it goes with the issues that the public have been raising about, and you are saying, and correctly so, you have identified the areas that NPA is not doing well in terms of stats on convictions. Corruption, GBVF, organized crime. Corruption falls under your work. And I look at the report, I see in terms of authorized investigations. I look at enrollment of cases versus what is expected. If we look at last year, we've moved from 2023-24 from 3 to 9. But if you are to look at the report of what would be expected as investigations, where, for example, you would have accused persons of 177, someone's entities about 22, but I must read it properly. Yeah, I'm reading it. If you look at that stats that we've provided in the report that we provided versus what we have as enrolled to court, that stats doesn't look good.
And I appreciate that. And if I may explain.
Because we need to understand, and I said to even this is consistent. I don't want to be told by the public that you've moved from one problem, you've made it a national problem. If it's a problem of performance is sitting at IDEC, maybe we have an opportunity to fix it there. But if we take you and bring it to NDPP, then we're expanding the problem of non-performance. Maybe share with us what is happening, why this performance?
So and I can speak for IDEC then, Minister. Yes. If you take IDEC, you would appreciate that when IDEC was formed by proclamation in April of 2019, it didn't have permanency. It didn't have a permanent structure. It worked on seconded individuals or duty reassigned from the DPCI and some from SAPS. When I took office in March of 2022, there were only 22 criminal investigators. There were a few more prosecutors than criminal investigators. And we had the majority of the staff that were there, financial investigators and other prosecutors, were all on contract. We then moved into dealing with the matters and enrolling the matters that we could. When IDEC then became permanent, Minister, you do see that there is a difference in the performance because we do have a bigger capacity. We don't have all the capacity, but that is not an excuse. We do have a bigger capacity. The cases themselves are voluminous. And Minister would appreciate that what we have to do is to be sure of the matters that we have to enroll when we enroll. We have been challenged and criticized, and legitimately so. If you take the matter of Matsela Koko, we received criticism that that matter had been enrolled, and then the matter was struck off the roll. And to explain, because these matters are so large, if you are not careful and carefully consider where you are with the evidence, what else is left, what specialized services are required, we enrolled that matter earlier than we should have. That was a lesson we took. And in taking that lesson, we seek then to make sure that our matters are better prepared. The investigations are finalized to date of enrollment. We have ring-fenced matters so that we don't have open-ended investigations. You will appreciate that the matters that are on the roll, if you take the Transnet Transaction Advisory, if you take the Transnet Locomotives matter, you take Alexco, etc. These are really big matters, Minister. And so we wanted to ensure that the matters are as ready as they can be when we enroll these matters. We had to take that lesson learned. When you make that kind of error in judgment, the public has every right, as they did, to criticize us. We have to show that we learned a lesson from there. So in terms of the enrollments, it takes longer because of the volume of the matters. But you will see that there are more investigations authorized than previous. It's because we now have a bigger capacity in terms of criminal and financial investigators, so that investigations are now churned out much faster than they used to be previously. Is it a satisfactory scenario in terms of the numbers? No, it isn't. But what it does say is we are careful about what we enroll, when we enroll, and we have to be sure that our enrollments are based on the evidence and the law. These are cases that affect people's lives. And so when we are accused of prematurely enrolling, it does not bode well. So those enrollments are key enrollments based on the year-to-year target. And although we've met the year-to-year target, and we will as well this year, both in terms of money laundering, investigations authorized, and prosecutions enrolled, we have met the targets each year. But it is slow.
Are this the only one, the Machela Koko matter? Because there are quite a number that we would not have done well. Or the Newman one, we were managed to appeal. You appealed and then you won. You got the appeal.
Yes.
And then, is that the only one that has fallen off out of the matters that you're dealing with? There was a withdrawal representation of matters as well?
No, there was one. The other matter, Minister, the court struck the Estina matter off the roll in August last year.
Yes.
And what had happened there is we had made disclosure to the defense a year before, and we were in court in August of last year. In April, I believe, we made electronic disclosure of the hard copy disclosure we had made. And when the accused appeared in court in August, they said to the court they didn't have enough time to go through the electronic disclosure. However, that which was electronic had already been made available in a different format a year prior. And that matter was removed from the roll for those reasons, because the court correctly felt that if you look at it, they should be given an opportunity to go through every medium of evidence that they are given. And for that reason, that matter was removed.
And this change of strategy, where you say you've learned, you're saying, as IDEC, we have learned that enrolling prematurely, and therefore we have changed. When was that change of strategy?
That change of strategy happened, Minister, shortly after the Coco matter was struck off the roll. We had to sit down and we had to understand why that matter got struck off the roll. When it got struck off the roll, two key areas of work were still to be done. We estimated it would take between 6 to 8 months. It was for the digital forensics and the financial forensic report. Unfortunately, it was not finished in that time. So these were a specialist field of work on both areas. So we had to sit down and say, given what sets us back, we have to deal differently with how we work out the time frames for completion of that work. It's also become easier, Minister, because procuring the services is now easier. We also have Section 38s on board, together with the prosecutors, and the ability to assess the matters are done quite differently.
Then going back into the role of becoming an NDPP, as you have reflected on the GBVF states that is not satisfactory together with organized crime, and would agree these are the two areas that the public would not understand why we are not doing well. Should you be appointed, what would you do differently in these areas?
So, Minister, I really became keenly aware that the NPA was not doing well in the GBVF in September last year. And you would appreciate it's not my field of work. And we were in Parliament. And I remember it very clearly. I think it was the 11th of September. The previous minister, Mr. Malani, went with us to the Justice Portfolio Committee on a different issue. But Mem Kwebane raised with the National Director if she could explain why in a quarter in the Western Cape, 245 GBVF cases were withdrawn. I heard about that for the first time. And that became a reality. I remember that when we went back, I do attend the EXCO meeting, which is the NDPP and her deputy nationals. And I raised at the meeting that what did we do wrong? It might not be my field of work, but what has the NPA done wrong? And one of the suggestions I remember making, only because you cannot come up with a solution when you don't understand. I asked if we could ask the special director and/or the DPP to please provide the reasons for why those matters were withdrawn. What were the lessons to be learned? Because you cannot have, in one quarter, 245 is a number way too many and unfathomable. I am aware then, given those engagements, documentation went out from the head of the NPS at the time that this exercise is to be done. But what also then brought this matter more keenly to the fore was the Omotoso matter. And so this is what we had to grapple with. And I sat in some of the engagements because I was also unable to understand what we do, Minister, if I may. In the corruption matters in IDAC, we have a whole host of people that sit together. They are a team. But before matters are taken to court, we have an advisory panel. The advisory panel must be presented with the evidence, the challenges, the charges. And this is a panel that has nothing to do with the cases. That panel is also not an IDAC panel. It is from members in the Specialized Commercial Crimes Unit within the broader NPA. They also invite investigators to that body. It gives us a different method of assessing our matters. And I couldn't understand why we didn't have that in sexual offenses. And so, for me, what a national director is supposed to do is to understand, one, what is the NPA's GBVF plan? Is it sufficient? I understand that there is a plan. I understand that with the GBVF now being declared a pandemic, that there has to be a different methodology. I think the methodology talks to our specialization, and are our prosecutors on par with what is required? What has become clear is if these matters were withdrawn, and I would assume invariably in the lower courts, which would be the regional and the district courts, it means that we have to get in there. What is the training that is required? What is the relationship between prosecutors, not just victims, but those who can provide a service to those victims? Are we using the TCCs? Where there's no TCCs in an area, Minister, who does a prosecutor activate to ensure that victims are prepared for court, not just through consultation with the prosecutor? What specialized services does the victim need over and beyond, I think, the psychosocial, medical that is provided through the TCC? But there has to be a different engagement between the special director of SOCA and the DPPs and those prosecutors. Who's keeping track of these high-profile matters? When do they keep track of the high-profile matters? Someone must intervene and engage. So whether it is the special director or the DPP who engages with the prosecutor, they have to keep their finger on that matter. What do their people need? Do they know that that matter is a high-profile matter? Have they assessed that matter correctly? And also to have ongoing training in terms of dealing with GBVF. It's a very sensitive matter. And I think in the manner in which I just generally understand how it is conducted, it cannot just be, it is a case to prosecute. It has its own nuances, and prosecutors need to understand what those nuances are. So as a national director, a national director has to make sure that the plan is implemented. Relationship with stakeholders internally and externally is being optimized, and that we have enough facilities to prepare our victims and witnesses. Because one of the complaints that I did see is that at the last minute, victims and or witnesses do not want to go to court. When they do go to court, they're not as prepared as they should be. They falter and or fail in cross-examination, and that talks to us as prosecutors and whether or not we prepared them properly.
And on the organized crime?
On the organized crime, Our relationship with the DPCI, as well as the detectives' organized crime, is critical to how the NPA operates. And given that the NPA works on the prosecution-guided investigations, I've always had a challenge if prosecutors write long notes to investigators. Do this, do this, do this, do this. It has to be prosecution-guided, as in sitting down with the investigator, understanding what that matter needs. Now, with organized crime, Minister, there is an organized crime strategy that was formulated by the NPA in consultation with the stakeholders. It was signed late in 2024. And what that seeks to do is to engage with different stakeholders, with SARS, with the FIC, as well as the DPCI, and what it seeks to do also is to have a better engagement with crime intelligence. The organized crime cannot be dealt with if we do not have credible intelligence, and crime threat analysis point us to modus, it points us to groupings, it points us to commodities, and it points us to what it is they are doing. If you take that, you take the investigations by the Hawks, guided by the prosecutors, organized crime can be dealt with differently. For me, the strategy, though, cannot be an NPA-driven strategy. Organized crime is a country problem, and I do appreciate that there would have to be more engagements, and there has been buy-in by the police and the DPCI, but we need them to be signatories to the document so that implementation is a proper buy-in and everyone understands their role and responsibilities.
Okay, before members do follow up on my issues and take over the question, just one thing that I observed, which was quite an interesting thing I saw. You've got on your reference Mr. K. Behari.
Correct.
What's your relationship? Friends, colleagues?
I had known him for over 35 years. Is it a week ago? He was suspended. I called him. I hadn't spoken to him in months. It's not somebody I engage with every day, but it is someone I've known for a very long time, Minister. I spoke to him.
How do you put somebody, when did you change your reference on your CV?
The documents had already come in.
Oh, okay.
So I chose not to change it. Okay. I knew that if any issue arises, I must answer the issue. Okay. Changing it and then resending does look like I have something to hide, and I have nothing to hide.
I'm talking in the context when you say you have not spoken to him.
No, he had been a reference. If you look at my CV, Minister, those two references had been references perhaps for the longest time on the CV, and had been there as well in the previous interview for NDPP. I called him and said to him, look, I had been nominated and I accepted a nomination. I cannot have you as a reference on my CV. I, however, cannot change it now because those documents have gone through. I did inform him that I will inform the panel, as I do, that he cannot be a reference on my CV. However, I must say, Minister, I did ask about the reasons for his suspension, which he did provide, and I did say to him, while I hear you, you have to appreciate, I am not judging you, but I cannot be having you on my CV. So I unfortunately did judge my friend, who hasn't been found guilty of anything. But in this position, the perceptions do matter. And Mr. Behari has understood
that's why I'm
that he,
it, as
that
head
he
of
will be.
IDEC, and with what is coming at the commission with reference to Ekurhuleni, I got concerned to see him as your reference, and that's why I wanted to ask the context of your relationship with him.
It had been such an old reference. I think even if I had to print CVs from prior, him and the other reference had always been there. The suspension happened after the nomination and CV submission, but I did tell him I have to remove him, and we also agreed that given the allegations that are made, given the fact that he is suspended, although we hadn't talked for months, we will not be able to talk at all till his issues are resolved. I did stand in judgment. I might lose much more friends because I am judgmental, but I had to do that because in the seat that I'm sitting in today for this position, the perceptions do matter, and I've had to do that.
Prof, you want to say something?
As the head of IDEC, I'll assume that your first instinct is vigilance and
Correct.
verification.
Correct?
And it does look like in some instances you allow for this profound blind spot.
Not
Because let me escort my logic.
Sure.
When you are to put someone for reference, the common practice is to go back to them and talk to them to say, I have applied for A, and now I've applied for B, I've applied for C. There is no retainer in reference where you say, you will always be there.
Understood.
So it would look like you have not spoken with the person for months, but you were able to utilize their reference as such. You verify if the number is still the same, the address. Are you in agreement? Because at times some people will say, I cannot be referenced for this particular one. That's one. The second one, from your previous answer, is the one of most of the time you talk about the reforms that ought to be made based on precedents and what you have encountered as the NPA or IDEC. What I've not seen or heard coming out clearly, it's the strategic foresight to say this is the emerging trend of organized crime or corruption which will define the future, because you may resolve things that have happened from the past and have to go back to the drawing board for those things which are coming very fast into the future of crime and so forth. Would you comment on those two? I would have added the third one, but I know that my chair will say don't overload or front load. Yes.
Prof, I take your point, and I'm being as forthright as I can be. I'm saying to you those two references had been there. When I was nominated, I sent the person my CV that nominated me, and I sent it as is. I did make a few amendments in terms of things that I had done since then. I didn't think I needed to call them because I know his number didn't change. I hadn't spoken to him in months, but he's always had that same number. And I am aware he's lived at his address for quite some time, and I was not aware that he had changed. And I think given
So
that...
that one, when was the last time? When you say months, when was the last time?
That I spoke to him. Minister, it could have been February or March, other than now last week, when I did call.
February, March this year.
This year.
Okay.
Yes. And I hadn't been to visit him in more than a year and a half, if not more. And with the other reference as well, there's nothing wrong with the other reference, but I also didn't call that reference because it is someone that I know her number has not changed. And I didn't think about the address. It's the reference and that they are contactable. But with Mr. Bihari, I known him most of my adult life for over 35 years. And when there was cause, Minister, to contact him, then I did. In terms of reforms to be made and the strategic foresight, sorry.
You just mentioned the second reference. I was going to come to it. Also, it's problematic for me. There's no position called acting judge in the Department of Justice.
I appreciate that, and that is my error. She is a magistrate, a regional court magistrate at the moment. That is, I'm saying I didn't change those things at the time, and that it's carelessness on my behalf.
Advocate Johnson, there's never been a position called acting judge. You are either a senior advocate, because acting judges come a week or two, sessionals, but it's not a position.
At the time, she was acting as a judge in the High Court for a term.
Yeah, a term is 6 weeks. Yes, because I signed the appointments of acting judges. So
this was
per
a
cycle, it's 6 weeks maximum.
I take
Others,
it.
for example, now the acting judges will be now in December, when the normal judges are on recess, so that they can hear urgent matters. So it can be a position. I'm trying to flag that because I'm looking at this. It says name of referee, Ms. Mngube, company DOJ, position acting judge, Pretoria High Court.
That was at the time. That is my error, and that is what I made the point. I sent my CV. I didn't change my references. She is a magistrate, and I apologize. I didn't
So she
change
would have
it.
been a magistrate under DOJ.
Under DOJ, and still is minister.
Okay. Answer the other one.
So in terms of the reforms to be made and the strategic foresight, Prof, the reforms are made within the various business units. And they are made where we do sit together for the NPA strategic plan, and it is in part of that planning where the strategy was that in order to deal with organized crime, there hadn't been, for example, a country organized crime strategy. Not even the police have one, Prof. They have standard operating procedures and they have how they work, but there wasn't a national organized crime strategy. That is part of the strategic foresight of the NPA team, that we need to formalize a strategy that is able to deal with the crime threat, which is organized crime. In doing so, I am aware that there were lots of consultations with people who are in the field, experts in the field who helped guide the strategy, as well as then with law enforcement. With the corruption, the strategy in IDEC has been to deal as holistically as we can with the various corruption matters that we have, and to ensure that they get enrolled. But I can see Prof's hand. I may not have answered it in the way the Prof anticipated.
No, he still had other questions as well.
Oh, my apologies.
I asked them not to go too much. They just ask questions, you answer, and then they can do a follow-up. Proceed, Prof.
The reason I invoke the issue of strategic foresight is that, for the most part, either you talk of IDEC where you are, but we wanted you to lift your gaze to the horizon of a vision
For the NPA.
for the NPA. And that is where I was trying to say, can't we lift that gaze? Because you will not be appointed back to IDEC should you be a successful candidate.
Understood.
But having said that, you mentioned twice the meeting of targets.
Correct.
Would meeting of target generated by your institution or your unit be the same as having an impact? Because there's one compliance matter where people say these are the targets. There's another one where you say, no matter the targets, the needle is not shifting. Can you reflect on that?
And correctly so, Prof. I know that there has been much debate. Even when we go to Parliament, Parliament has asked, well done, you've achieved your target. But what does that equate in terms of impact on the people whom you serve, which would be our South Africans, regardless of the crime type? And that is an issue that I know that we have been discussing in the NPA overall. How do we measure impact? Targets are numbers, but do those targets deal with the right cases, the cases that can elevate what we are doing? So if you take, for example, I remember there's a matter, it's a corruption matter not in IDEC. It deals with the Lepelle Water Board, I think in Polokwane. And because of the fraud and corruption there, it was identified that the corruption in that matter must be dealt with. What it did is, if you deal with that matter, and if asset forfeiture is able to bring back the money, one might be able to put it back into the criminal asset recovery account and therefore give government the impetus to then put in a water supply for the community that was robbed of its water supply because of the corruption. That is how I consider as defining impact. Targets are numbers. And so what we have to do differently is understand which matters affect the South African population. So impact can be measured differently. It is what kind of recourse do you give to a community when you address the crime in that community. It's the same with drugs, Prof, is dealing with drugs and dealing with drug syndicates may bring relief when you arrest those persons. But in other matters, you need to be able to recoup the money so that services and service delivery goes back to a community. That, for me, is the impact of matters. Targets are part of performance achievement. They are part of the indicators, but not all targets talk to impact, because you have to identify those matters that will make impact across the board.
Thank you, Minister. Advocate Johnson, admittedly, humanity is fallible. But the position that you hold requires a higher degree of care and skill in the execution of your function.
Correct.
Now, I'm raising this issue at the backdrop of the two cases that were mentioned earlier, which you readily admitted to have not handled properly. The Estina matter, as well as the Cocoa matter, that they were placed on the roll prematurely, and that you've drawn lessons from such mishaps. But the higher standard of care and skill wouldn't permit us to just brush it aside and move on as though it's business as usual. Because that higher standard of care and skill does not, regrettably, allow a space for complacence. And my view and take in handling of these two matters points towards you having been complacent and having exercised poor judgment in rolling matters or enrolling matters prematurely. Now,
I'll let you finish, sir. Sorry.
Now, this talks to consequence management. Reverting to my earlier sentiments, it cannot be, and these matters cannot be treated as business as usual. Surely there should have been consequence management, looking into the calamitous effect of having such high-profile matters withdrawn due to lack of readiness on behalf of the state. Was there such consequence management applied to you specifically, other than just having drawn lessons from such mishaps?
The Estina matter, just to be clear, was not a premature enrollment. However, the court there felt that the evidence that we gave, albeit that we provided it to the defense a year before, because we provided it in a different medium later on, they should have been allowed an opportunity to go through that. So, but in the Cocoa matter, yes, we took the lessons, but I take the point. The national director did call me in, as I reported to her, and we had to provide a report on how we made that kind of error in underestimating, and the only error was the underestimation of time to complete those specialized services. The national director did indicate to the team and I, as we were all called in collectively, that the matters need to be adjudicated differently. She did talk about what you mentioned, and that we should have more care in how we enroll these matters. So I'm not sure how far the consequence management should have gone, but we were addressed. And that was part of how we now, in terms of the question also by the minister, where one would expect there to be more enrollments, there aren't as many enrollments because we exercise a duty of care more diligently given what had happened with that premature enrollment of the COCO matter.
So that was just a slap on the wrist. There was no disciplinary action whatsoever taken, notwithstanding the consequences.
So in terms
or
of
the effect that this had, not only towards the proper administration of justice, but in perpetuating the erosion of public trust in prosecution.
I know that for myself personally, when it came to my performance assessment, I received a score I had not received in my 28 years at the time of being a prosecutor. The national director marked me down to a 2 as part of my not having performed as I should have in that area of work. But that was as far as it went, and I take the point. I can't take it any further.
Okay.
That is what was done.
Just one last point. You indicated that you got to know of the impact of the GBVF when you
went to Parliament.
When you were in Parliament, and that was the first time you got to be aware of the impact, or rather the statistics and the challenges that bedeviled the institution at the time. And part of your reason for being oblivious to that fact was that was not necessarily your area of focus. But you're sitting here today as a candidate for appointment to the highest echelons within the NDPP. I would take it that you did not develop interest in this position overnight. And I take it, if I'm correct, then you should have had interest in broader areas of performance within the institution. And by your own admission, you didn't really have demonstrated that interest, because you had proximity to management, you had proximity to access reports that will inform you of the direction the institution was taking, and you missed that opportunity.
May I expand?
Yes.
So I wasn't oblivious to GBVF. You cannot be a woman in this country. And I am the mother of a girl child. I'm not oblivious to GBVF in the country.
Within the, sorry to interject, within the context of the statistics that I'm referring to, which you are not aware and up until you were in Parliament.
I was aware that there are high numbers of GBVF cases across the board because it is publicly published and talked about. I became keenly aware of our failure as the NPA in dealing with GBVF in a specific area for a specific time because it was raised where I was. That it doesn't take away that I was aware that GBVF is an issue. I was also aware that there are high-profile matters within the NPA. I do follow in terms of the serial rapist matters, matters that affect children, child rape matters. Those I'm aware of as as a citizen, but also as a prosecutor. But the numbers, I was not aware, sir, of the
Maybe
numbers.
just to assist them, Mr. Mutlong, maybe I put it differently, Advocate Johnson. You're part of the management of NPA as
Correct.
a senior manager. So has NPA in its executive meetings ever considered the performance on sexual offenses, conviction, and what has been? Because listening here, it doesn't look like it has ever been. And it's one of the areas that NPA has not been doing well.
So they do provide those figures. At the majority of the time, it is presented at the NOM meeting, which is the one that is chaired by the head of the NPS. I don't attend those all the time. But when we are at EXCO, yes, there is a breakdown at every meeting of the performance of the NPA. So I was aware of the global performance and on non-performance. What I was trying to point out is the specific and how bad it was at the time that it was raised. What it didn't do, and I'm subject to correction, I cannot recall what the breakdowns would be, but I did know that we were not performing well as the NPA in sexual offences matters, but became more keenly aware when this was raised in the very specific way, Ndata Matlong, as it was in Parliament.
Thanks. Just last part of that is the Omotoso case as well.
Yes, sir.
That you were also not aware of the nub of the case itself, because that also fell outside the purview of your area of work.
No, correction. Yes. It's not that I was not aware of the nub. That was such a widely publicized case in the country. So I was aware of the charges. I was aware that there were many charges that were facing the accused at the time, and I do know that the case took long. Where I then drew an acute interest was how we lost the case. I then drew interest therein, but I was not oblivious to the case.
Yes,
there are some matters that you become aware of, sir, because, as I said, in the meeting that is chaired by the head of NPS, some of the high-profile matters are, in fact, mentioned. And this was a matter that took 7 or 8 years, and during the course of that time, this matter was mentioned, but not that there were challenges in the matter, at least not in a meeting where I was. Remember, sir, that those meetings that they would have about GBVF would also not be in the management meetings. There would be separate meetings with those people who deal with GBVF and or the respective DPP office.
Thank you.
Ms. Mmamoloko.
Thank you, Chair, and good afternoon, Advocate Johnson.
Good afternoon, ma'am.
So earlier on, you talked about an observation around morale of staff. I think your words were, one's got to be clear about to what extent low morale's got to do with disgruntlement and whether or not it's legitimate matters. What is the conversation that's being held at the Executive Committee or at MANCO, which I believe you're also part of, that around the morale of staff? Could you maybe give us a sense about the conversation that's being had on this very topic?
So the main part of the conversation is had we gotten to the source of the problem? We hadn't, but we had been having conversations about how is it that we've had a changed management, that we have more resources, that we have more capacity, and that we have more training, that staff are still disgruntled. And what we sought to do in those meetings is to look at, I know they did cohesion sessions for the staff with outside parties. That feedback was brought into the fore to understand what the unhappiness was about. A lot of the unhappiness, from my own understanding and interpretation of those, has been that prosecutors feel that especially communication of management issues are not conveyed timeously when you have changes of management. People want to know, why is Andrea Johnson in that job? Were we given an opportunity? No, we were not given an opportunity. People may see that in terms of certain appointments, people are favored, and they make their own deductions about why people might be favored. And so those are long-standing issues. And I think one of the most important things is something Minister has done, and if Minister will allow me to allude to it, it's become very important in how we do our appointments, especially of senior management, because the appointment of senior management talks to transparency and it talks to credibility. And that the NPA, that has been the biggest gripe. People on the ground want to know how senior managers are appointed. As the panel would know, most, if not all, from the DPPs to the SDPPs, DNDPPs, are appointed, Minister, you'll forgive my wording, at the behest of a national director. These people do not attend interviews, etc. That is the core gripe, Mmamoloko, of the staff. And the one thing Minister has made very clear is that must change. Also how we recruit internally. The panel cannot only consist of internal people. We must have someone from outside. It brings an independent mind to bear. It also brings a sense of comfort and confidence to those NPA officials that are applying for the post. The majority of it is within the recruitment. Secondly, it is the morale talks to the training. Unfortunately, when training initiatives are presented, not everyone is available. You end up finding that the same person goes to 2 or 3 training ventures for that year, and then that in itself causes a lot of dissatisfaction. But the majority of it has been how appointments have been made, and the transparency with appointments, because people want to know, and they have every right to know.
So earlier on, you talked about the organized crime strategy, right? That had been the outcome of a consultative process with other institutions. And it was approved, I think you said late 2024. What's the status of its implementation as things stand, and what is the current conversation about it at EXCO? So
the organized crime strategy became actionable from the date of the signature. So I cannot remember the exact date, but in 2024 when it was signed. What that has done is it has made, there's a different engagement with prosecutors on the ground. So organized crime prosecutors always formed part of a component, and they just dealt with the matters as they came in. What now happens is, if you take a division, the DPP gets to understand at a higher level what the organized crime priorities are. And the DPP has to then ensure that they have dedicated staff to deal with those priorities, and also what the engagements must be with the stakeholders, who the relevant stakeholders are, and what will drive the identification, investigation, and prosecution of those matters. They are happening in all of the organized crime components as they are across the country. And then there is a lot of engagement with the organized crime component that sits at head office in terms of mentoring and in terms of ensuring that the plan is implemented and that the partners still remain on track, especially the DPCI, because the organized crime, Mmamoloko, that we talk about is the higher levels of organized crime dealt with by the DPCI. And what the NPA also does is there's an active engagement in the projects committee. In the divisions, provinces, they're called provincial project committees, and then the national projects committee of the DPCI, where the NPA also sits. Projects are then presented, and they then get to decide in terms of priorities as a law enforcement group, together with asset forfeiture. I believe the South African Revenue Services sit there, the FIC, as well as the SIU are also in attendance. So the approach is holistic, and the partners, together with the NPA, drive the priorities and the crime types that are identified. So it is being implemented.
Thank you, Minister. Advocate Johnson, I just wanted to ride on Professor Fikeni's comment. This one is a comment just to say I'm a bit concerned about your level of vigilance, because one would expect it to be much higher than an ordinary person. Not belaboring the issue of the deductions that started in 2000. They're going for 20, I don't know what years now, 26, 25 years. And that is worrying to me because that has got an impact on who you are in the eyes of certain people inside. That's one of the many reasons. But secondly, I also, why I had to bring it back, the issue of referees, I would expect somebody who has got a friend who is maybe a scientist or something to say they were acting as a judge and write that, not you and me.
Correct.
We are lawyers.
Correct.
And it's worrying me that we had to pick it up here. You know how judges act. This person is a magistrate.
Correct.
You have written a senior judge. It's almost, it's bordering, if not full-blown, misleading. Because if some of the panel members or all of us did not know what an acting judge is, it gives it a different turn altogether. One of your referees is an acting judge.
Correct.
As opposed to a magistrate. Those things worry me. They're small, but they worry me. A third one is the Estina matter was also thrown out of court as a result of unreasonable delays. And you have not mentioned it. So that's how I say maybe it's just comments, but unreasonable delays in the courts is fundamental because it goes to the heart of justice and a fair trial and access to the courts and therefore access to justice. So it's worrying me that the way you look at things or the way you couch them, it's a different certain level of a truth as you see it, but not necessarily an absolute truth. I think I'm also trying to be strategic.
No,
but you hear me.
No, I hear you.
It's already 3 examples.
Yes.
Wherein, at the end of the day, you have not been entirely truthful. Let me just put it out there.
Absolutely, and I want to be very clear. I have not been dishonest.
Okay.
I honestly overlooked those referees. I honestly did. Because at the time when I received the call, I sent my CV. You have no reason not to say I have to be even more vigilant. And in Estina, I didn't hide anything. Part of the unreasonable delays was the disclosure. I talked to what the court found about why that matter was struck off the roll. So please, do not see the response as being dishonest. I responded as I do because I took the points that I saw. At no stage is it ever my intent. If that is the impression that was created, I can't fault me for making the deduction that you do. It was never the intention.
Should we then conclude that, maybe the mic there? Should we then conclude that your ability to pay attention to detail is a bit of an issue? Let me tell you why. Let me give her the CV. Your CV is full of flaws. There's inconsistency between your CV and the form that we've sent you.
Sure.
And that is worrying for me. I just looked at it. If we go to your CV, and because you work with me, you know me by now that I do pay attention to details. Look at the position you're saying there. Page 4 is fine. It's Investigative Directorate 1 March 2022 to date. You go to the next one. Company section, DPP Pretoria, Senior Deputy Director Public Prosecution, February 2012 to date. You go previous employer, company, Department of Justice, Section Magistrate Court, Next one, prosecutor, 1996, 1998.
Yes. At the time, it was the Department of Justice.
But the years are not correlating. Oh yeah, that one is fine.
Yes.
Oh, that one is fine. It's the other one that I picked up. And then you go to 98 to 99.
Yes.
That's what you had corrected on the form. Go to the next one, and then 1999 to 2004. That one is fine. 2004. I'll show you the other one that has a problem. Because I've been corresponding with this one. Check on the one of...
On page 8.
On page 8 as well.
Correct.
There's a problem there. The next page as well, let me just show you.
The dates.
Employment period is a problem as well. The next page as well, 6 February 2019 to date, a problem again.
The to date, yes.
So you see what I'm raising. Again, you go back to page 11, National Coordinator Organized Crime, 2019 to date. This is your CV. Now, your CV is meant for us to be able to use as a determining process as well. So that's why I would correspond between the CV
and the question
form. And that's why I'm saying, if you're saying that it was not misleading, then I conclude that you do not pay attention to detail.
In this instance, I didn't. I clearly didn't. Unintentionally, I didn't. I really sent my CV. And if you'll allow me, Minister, there can be no excuses, but I'd like you to hear the following. I don't apply for jobs. It's not something I do. But I take the point that I'm supposed to be more vigilant with the CV. I sent my CV, and I accept that I was wrong. I should have checked it first and then sent it. That is why when I had to do the questionnaire myself, I was vigilant in the questionnaire and was able to properly set out, because that was then the document I was penning myself. But
no,
I can't argue from the point.
Advocate, I hear you are taking it, and I think this is just beyond here. Because we published this thing, this CV, before we could get the form. We've never published the form. We took your CV and published it.
I accept that.
The team emailed you to say, please verify this CV because we are going to publish it. Because I asked them to get permission from all of you before we could publish the CVs, so that you are not found wanting. Anything that you are not comfortable about, please take it out. This is what you sent us. And that's what I'm saying. My issue is the ability to pay attention to detail. It's the membership of the union. You didn't pay attention to detail. It's the CV. It has for a prosecutor, senior prosecutor, and a head of an investigating directorate that has the work that you carry a huge weight in your shoulders, not to be able to pay attention to detail.
I know that, yes, here you are correct. I really am vigilant. When it comes to my work, I really am. Here, I can't take away that I didn't pay attention to my CV. I really didn't. And I don't have excuses to make. There's none to be made. Even on the item that Prof raised. It's been there. If it's to be corrected, I will correct it. It's been going off my salary. There's nothing to hide, panelists. It is as I answered.
Minister, yeah, I was going to say, for a member of the public out there who would say, since 2001, there is a small amount that is being deducted. How do you know that there isn't a 100 rand that is being deposited by some shady person who tomorrow can turn around and say, please, you do know me, check your bank statements?
So in terms of my bank account, the difference is getting those notifications. I get the notifications, and I do check my bank account. This goes off my salary advice. That membership goes off as a stop order. That is what we were expected to put in those many years ago, Mayor. So those go off differently. They don't go off my bank account. They get withdrawn before you get your salary. So I'm saying it is there because it's always been there, but not in my bank account. I am clear about what's in my bank account.
Thank you, Chairperson. Good afternoon again, ma'am. I don't want to flog a dead horse, but you know, if you do send out your CV, you contact the person who's your referee to say, listen, I've sent you my CV. Somebody may call you and to tell you that, that you are my referee. So again, attention to detail and to be vigilant, because this is normally what happens. But I want to follow up on my colleague, the AG's, the issue about the morale. And you have explained in detail, how to work with people in terms of understanding the strength and the weaknesses, and also to be inclusive and have that leadership style and so on. But the fact that you talk about the morale and then explain about people, wanting to know who's getting what and what positions and so on. Two questions. Does it mean that the morale is so low in the organization, as a whole, all its business units, and that affects the output and the productivity and the output that creates the kind of problems that we see, that you yourself have identified? So people will say, the morale is low, we don't know what's happening, why must I do all my work and so on. So should you be successful, what is it that you're going to change, apart from the stuff that you say, that how you need to engage, understand, and hear what people are saying. But the point is that if an organization's morale is low, the staff are concerned, it does affect their work and the quality of their work and what work they put out. And does that not then constitute an injustice to the people that you serve and have to defend? Thank you.
So so over and beyond the other issues that I raised, Mr. Nissen, about the appointments, etc., and the training, what has also become very important is people want to understand what the strategic vision is of the NPA. And I think that what happens on a higher level, managers know it. And I don't know that they communicate it as widely as they should. So people see themselves as, I've just got to do this work. I hear this is a priority, this is the priority I have to do. So what a national director has to do is ensure that the management, which are the DPPs, the special directors, chief prosecutors, and senior public prosecutors, engage with prosecutors every single month. They must be able to meet with them. They must be able to tell them what the objectives are, what their commitments are for that month, hear what the challenges are in achieving the convictions and ensuring that matters are not withdrawn. What do those prosecutors need? It is engagement and communication. And I think it sounds simplistic, sir, but if you engage and you communicate, people tend to understand and have ownership. And when you have ownership, you are able to perform differently. It will also go back to the question that Prof had raised, targets versus impact. When people understand the true impact of corruption, organized crime, GBVF, that it's not about achieving numbers, this is how we make impact, then people operate and perform differently. It's really the communication of what we want and the why. And it has to be done on a continuous cycle. It's in that, if you'd allow me, that you get to understand what the shortcomings are of your own prosecutors, not just it's a morale issue. People may want to perform. People don't also necessarily tell you, Mr. Nissen, that I need more training. But when you engage more, you get to understand. And I think all of those will talk to how we then perform, because the morale becomes a positive as opposed to a negative. At least that is how I see it.
Advocate Johnson, I wanted to take you back just 1 or 2 steps, nothing hopefully too hectic.
Coming from you.
Yeah, coming from me.
No,
I
sorry. You know, sorry,
okay.
Minister. He smiles, and then when he asks the question, it doesn't leave you smiling. So I say in jest. Sorry, sir, I interrupted
It's okay. Maybe that's the whole point of making everybody comfortable, so that we don't have to look at this process as if it's an interrogation room. It's not. So, and that's what the minister encouraged us to do, not to deal with colleagues as if we are in an interrogation, sir. I wanted to check with you, when you talk about the consequence management scenarios, I want you to cast your mind back from all the responsibilities you had to carry in the NPA. IDEC, you started leading it 2 years ago. I think it has 2 years since then, if I understood you correctly. Then you calculate the number of years that you served in senior management in the NPA. My imagination tells me that you have been in senior management for the longest time to be able to be part of that communication that you are currently talking to. And my understanding says the current incumbent has been in the institution for at least 6 to 7 years at most. And you have been there throughout. She actually found you there. And that's how I understand you. Now, having been part of that development of that very same first strategic plan that you guys created and developed, and even agreed about how it filters down, how you communicate it. Let me then understand from you, what became your role in that space of that communication, of that strategic plan, to filter it down to the very junior prosecutor who just entered the prosecution role in the courts? How did you assist that, or perhaps not assist that?
So at the time that I became involved, I was at head office organized crime, and that was from February 2019 till the end of February 2022.
Okay.
So part of that engagement was ensuring that in order to achieve our organized crime targets, to help prosecutors understand, especially at head office, part of the head office component's duties was to enable prosecutors to understand racketeering, what was required for racketeering, what the priorities were. So when we had the National Operations Management Meeting, which is the management meeting of the head of NPS, we would engage with the DPPs to ensure that them and their divisions understood what was required. We would also go to the divisions. I would travel, for example, to Mpumalanga twice a month. I would engage with stakeholders for the illicit mining. Another colleague would go and engage on environmental matters. I engaged stakeholders in terms of serious violent crime, cash in transits, and we also then engaged with the stakeholders. When we came back, where it became necessary in terms of the achievement of the strategy, we would make sure that we wrote the necessary letters or guidance documents, criteria documents, and sent them down through the provinces, because in the provinces it is the DPPs that are in charge. However, we were allowed, and we did. I would engage with the organized crime nodal points in each division. We also had meetings to understand that they knew what we needed, to tell us what they needed, and to indicate what their challenges were. Those then got escalated higher. So there was that engagement, but only because I was at a head office level. But the DPPs, we engaged with them, and from there they engaged with their staff.
In line with that, if there was discontent amongst those staff members that you are speaking about. Was the discontent at managerial level with the DPPs across the country, or was it a head office based discontent?
No, I don't know if that's the right word, but the challenges that prosecutors had.
I don't want to use the word disgruntlement because I'm not very sure where you got it. Okay. So I'm just using a simpler word that gives you opportunity to explain when a colleague says to you, I don't understand how Mr. Nelson was appointed. That is how you want us to understand you. So I want you to understand me that way.
Understood. So when those issues were raised, especially where I had those meetings with the organized crime nodal points, we documented them, we did send them back to the DPPs, and we asked for feedback because the head of the NPS must ensure that those challenges are actually dealt with, and they would get dealt with. The majority of the issues that were raised were issues of resource at that time. Not all prosecutors are specialist prosecutors. And so you found that those prosecutors who had to deal with organized crime invariably were in the DPP offices, and there were very small numbers of those. The majority of prosecutors were in what is called the general prosecution stream. So those prosecutors, the biggest issue was resources. The other issue that they did have is challenges with investigations, but they dealt with them then in the province. But they would escalate and indicate those. When we had the national meetings with the Hawks, we would make sure that General Labia and his team were informed of the investigative challenges that were encountered in a specific division with the organized crime component. And him and his organized crime head would then ensure that they dealt with it there.
But the point I'm trying to get from you is this disgruntlement. Let me use your own word then. Maybe it would be easier. This disgruntlement, did it exist or does it exist in your area within the 2019 up to date or until 2022, or did it exist in the general public prosecution space as you want us to understand the two separately?
It's across the board because you had resource constraints, whether it was commercial crime or corruption. We had resource constraints in the sexual offences unit. We had resource constraints as well in organized crime. So it was a generic issue of resources, and there was a generic issue of investigations, capabilities of investigators, training for prosecutors, and that was across the board. It wasn't unique to a specific unit, and that was at the time. I know now that there's more engagements between DPPs and their units. You also now have special directors in those specialist units, and the problems are escalated and dealt with there as well. It's only where a problem cannot be dealt with that it is raised with the head of the NPS, Advocate de Kock at the time, now Advocate Mzinyati, and they also do get escalated, especially resource issues to the Office Strategy, Operations and Compliance, which deals with capacitating and training. Prof?
Thank you. Thanks.
You've been with the NPA long enough to be able to characterize it. You've mainly referred to staff and prosecutors at the leadership level. Is NPA a house divided, or do you have any other type of leadership challenges? And if so, should you become the head of the institution, what would you do to cure that problem? And the second layer of that question, if you can help us lift one or two things in your long career within the institution where you say, I initiated this particular change and championed it and saw it through in terms of its implementation, and it will forever be remembered as something that I initiated. Not what the group, what the leader said should be implemented, but something that is your flagship when you reflect.
Myself.
Yes.
So on the first question, Prof, is the leadership divided? It's not divided, but even within that leadership, I think there are challenges. I think it is also borne out by the Kabinde inquiry and how it has been playing itself out. And that leadership issues are simply, again, back to appointments in the main and communication. I do sit with the DPPs and the special directors, and the biggest issue is when decisions are made in the NPA, we want to be consulted. They all want to be consulted. It shouldn't be a group that is consulted, and they feel that the consultation process isn't as wide as it should be. That is the main disgruntlement, for lack of a better description. And when people feel that not everybody is part of, not everyone can be making the decision, but they should give input into certain aspects that will affect how they operate. They want to be consulted. They do understand that there are certain instances where a person must make it.
Can I press you on that one? Do you feel like there are people who are insiders who get consulted and others who do not within the leadership?
So I have not personally experienced that, but I speak in terms of when I talk to colleagues that feel there should have been consultation. You take, for example, we had an issue, Minister might be aware of the issue with when the DPP for Johannesburg was suspended, there was a lot of issues around we are fellow DPPs. Tell us what is going on. This is a senior colleague. It can happen to us tomorrow. Now, I understand why you, on discipline issue, cannot talk to everybody, but my colleagues felt, all of us felt, at least give us a high level. What is happening? The senior colleague is suspended, and there are steps that are now going to be taken. It makes them feel disenfranchised, because all that happens is those that remain look at one another suspiciously. Did you know? Did you know? And you can't have second guessing. And that is a key issue when we are not, we have to be taken into confidence on key strategic issues. When you deal with a senior member of the NPA, it is not, oh well, Andrea Johnson is suspended. We're not going to tell you why. It cannot be. In terms of change and champion, over the years we've done things as a collective. But the two things, or the one thing, when I took office at IDEC in 1 March 2022, IDEC did not have, as we used to have in the DSO, an operations manual. An operations manual that dealt with all of the administrative duties, that dealt with the role and function of investigators, criminal and financial, and that dealt with the role of prosecutors and how matters came in, intake criteria, and the processes that were needed. I remember sitting down and I took a A3 and I started in my head to map out how we should operate. From start, when we get a matter, till we get to court. It really was an ugly handwriting drawing. I still have it. It is my pride because I penned it out of my own experience. And
through you, Chair, IDEC, because you are starting it it's naturally going to be, we had to do the following. Like anyone starting an organization, they'll say, have A, B, C, D, E. But within the NPA,
So
prior to that,
why I wouldn't, if you would allow me, why I wouldn't brush it off?
yes.
The ID was proclaimed in April of 2019. We are talking about 2022. There wasn't such an operating document. IDEC is in the NPA. You want to deal with corruption, which is a country priority. You must have a plan. You must have a process. We did not have that. So that is a key initiative changed and championed by myself. Penned it, and then had our management sit together so that together with our strategy management office, take them through the document, what we understood. At the end of 6 or 8 months, we have a IDEC operations manual from start to finish. It is there for every new employee that comes in. And we were the only ones, still are the only ones, that have a full operations manual from all the specialized units in the NPA. So I do take your point, Dr. Fikeni, Prof. Fikeni, but unfortunately, there wasn't anything from 2019 to 2022 March in that area where you clearly could tell the people what is expected. So as we get new employees that come in, it is part of the induction program, and they then get the training manual, which they are able to use regardless of what rank or capacity they are appointed in.
Okay, I've been asked that all of us pull the mics closer. We seem to be fading away for some reason. It's late in the day. Proceed, Ms. Mopp.
Thank you, Chair. Advocate Johnson, I'm trying to figure out what would you do differently if you had to be appointed as the NDPP to ensure that you dealt with these matters around communication, as my colleague, Mr. Mvundlela, was exploring with you, morale, cohesion at EXCO. And I say cohesion because that you heard about the GBV matter in Parliament suggests that the critical conversations around key mandates for NPA and key priorities for NPA are not effective at the collective of leadership within the NPA. If I listen to your answer about that, your answer about the implementation of the organized crime strategy, because the question I asked was, what is the conversation about it at EXCO? So what would you do differently to ensure that you build an institution where the collective leadership works in a cohesive way towards achieving the mandate?
And that's not going to be an overnight success for anybody, not just me. And I think it is because of how the organization has to operate. It has to be operational and perform while still attending to its strategy and ensuring that the strategy is understood and implemented by everyone. And it is finding time to, so if we start at the top leadership, it is a national director with the deputy nationals. In the time that I've engaged on that platform, there is clarity amongst them on what each one's roles and responsibilities are. I think where the disconnect might be is from there to below. In terms of every deputy national should take the DPPs, special directors, more into their confidence on what the objectives are. Now, every deputy national deals with it, but they deal with it, the head of NPS, the head of AFU, the head of SOC. we do have a MANCO, and at that MANCO, these are also discussed. But I guess given the time when these meetings and the length of those meetings, you don't discuss all the details. And we have to find the time to make sure that the details are dealt with. A national director is responsible for all the prosecutors, processes, prosecutions, whether they're instituted and where they are stopped. The national director has to make sure that all the prosecutors, now how do you get all the prosecutors to know that these are our responsibilities? It's not just about having regular meetings with your top management. It is about going down to grassroots level. I know that our current national director had been doing that in this past year, where she's had regional visits and she's engaged more with the staff, and she wanted staff to understand there is a different level of understanding and appreciation for where we are at and what we need to do. That has to continue. But you also have to deal, in terms of the staff, need to know that their actions have a reputational risk to the NPA and what that reputational risk does to our performance. And we can only do that if we are talking to them through the different levels. So, again, I say it sounds simple, but the communication and what is being communicated, when it is being communicated, and then holding those different levels of managers accountable. Dr. Motlong, there has to be consequences for why we don't engage our people, perhaps, as much as they want us to engage. What stops us from talking to our people about what needs to be achieved? Now, a national director cannot be seen to be the head of the organization divorced from his or her people. You must be able to communicate the message. So if we had to talk about the GBVF, what must a national director communicate? A national director must be able to communicate to all prosecutors, we are doing really badly. Where are we doing badly and why are we doing badly? And what is the consequence of us not doing that work? And I think when you have those kinds of communications, it affects positively all of the other levels: morale, performance, impact, and understanding why we are the NPA. It really is the communication is the golden thread through which any leader of an organization is able to reach his or her people.
Thank you, Chair. I've actually been trying to resist the temptation to venture into this question, but I think it's quite relevant that I should pose this question to you, particularly taking into account the role and mandate of IDEC. What's your view on the landmark decision of 2011, the Glenister versus the President of the Republic of South Africa? That's a preamble to a follow-up question.
When the legislation was promulgated for the creation of IDEC as a permanent body, they considered Glenister 1 and 2. We looked at the STIRS requirement to make sure that it forms part of how we're going to operate and engage.
And there has been some developments since then, and a case in point is the introduction of Constitution 21st Amendment Bill. What's your take on the proposed bill?
Is that the private members' bill?
No.
No,
the Constitution 21st Amendment Bill. That proposes the Anti-Corruption Commission.
Okay.
Maybe let me just help, because they don't deal with the legislation particularly. It will be in the department. So I'm not so sure if she would have seen, because it's a proposal, it's a private member's bill, definitely, by DA that we responded to.
Okay, so you may not be aware of it.
I'm just aware of it as the private members bill, but as Minister says, the legislation is with the department, and where comment is required, they would have asked us.
Okay, thank you.
Thank you, Minister.
Other question? Okay.
Thanks. Dr. Johnson, Advocate Johnson.
He says smilingly.
Do you share the view? I'm smiling because I called you doctor, and I was scared that you would remind me that generally in the legal field, LLD may not be something that we actually put forward much about. Not that we don't encourage people to study. Do you share the view that there is, and there may have been or could be situations where there was political interference in public prosecutions? Do you share that view? Because it does exist in society. Maybe just to give you comfort. You would not be the first one to say
no,
so.
I am aware of that view.
Okay.
I can tell you that in my time, no one has interfered, no minister, whether within the Department of Justice or elsewhere, or the President, in the work that myself or my team have done. I am aware that when we were in the DSO, there were talks that there would have been political interference. And I know that that was dealt with both in the HEFA and in the Janwala commissions. And that's the extent of it. But in the actual operational work, there are allegations of political interference in state capture matters. But in the matters that we've done to date, there hasn't been political interference on that, where you can say, it is Minister so-and-so, it is this political person, etc. What we do have that is different is you have in the group of criminality politically exposed persons against whom allegations of crime are being investigated and made. So I am aware of what you say, but I have not experienced it, nor has anyone in my field where I currently am or where I've come from in terms of organized crime.
Great. Now, with that in mind, possible elevation to the National Director of Public Prosecutions. And perception in South Africa has become a norm. You know, anybody can say anything and then everybody believes it, in whatever form that it is said. How do you see yourself managing that possible perception, at least for the benefit of the NPA's reputation? Because that is what this country needs. An NPA with a reputation that is beyond reproach. How do you see yourself playing a role in that space?
I think maybe because of the kind of cases we've had to do and the work that I've had to engage in, it's been easy to deal with the work. And when you deal with the work, when you deal with the evidence and the law, there is no room for somebody to come in. You do not allow for somebody to come in. And the very first time that that happens, you've got to escalate it. It doesn't matter what the rank of that person is. And if there's a fear that if you escalate it within your structures to which the NPA reports, then you have to find a way to ensure that that interference is brought to the fore. But you cannot, I have no intention that if somebody says, sorry, Johnson, those cases, why aren't they being dealt with? Unless there is a public interest and a member of public may have raised that through a specific individual, that individual must put in writing what are they asking of the National Director so that the National Director is able to deal with the public interest issue of whether or not something was done in the NPA. But where there is actual interference, you have to deal with it the very first time, even if it is not overt. And there's someone is suggestive in the way they approach you, and they are of that position, you have to deal with it. We have a minister. I'm not sure how long. My minister is my minister. In this administration, this is my minister. And our minister has never once, and I'm happy to say that, and she can leave the room if she's uncomfortable and then she'll come back because I'm talking about her. But this minister has not asked, even of IDEC, which has such highly controversial matters where there are politically exposed persons. This minister has not asked of the ID and anyone in her staff, why did you enroll that matter and not that matter? The only thing we have had to do, not with this minister, but any other minister in the NPA, in the work that I have done, they are entitled to ask for a Section 33 report, which is a very high-level report. But that is as far as the reporting or what are you doing. But the what are you doing talks more to not why you're not charging this person or why have you charged this person. It's can you account for the work. I am the overall counter of your work to Parliament. I'm not happy. Account. And that is the only accounting that we've been asked to do that I am aware of.
Thank you, Minister. That's all.
I think it would be a rider to this question in a hypothetical, probably projected situation. With the Truth and Reconciliation cases loading, Zondo Commission cases loading, current cases of the Madlanga Commission loading, it stands to reason that political pressure and appetite to interfere may happen. It also stands to reason that with the turnover of ministers, it may not just be a person. How would you institutionalize insulation of your work irrespective of who is there?
The only way I know how to deal with it, Prof, is you have to stick to your strategic plan, you have to stick to the mandate, and you have to ensure that the work that we do is in terms, and I've said it before, and I'm sorry if it sounds like a repeat, the work we do must be evidence and law-based. When you do that, it is very difficult for somebody to compromise your work. We must also be open to review of our work. I think that that is the one thing that we don't do as well as we should. We must be able to account to the public. Perhaps every quarter we should have a state of prosecution report. Tell them where we are as the National Prosecuting Authority. What were we intending to achieve in that quarter? Why haven't we achieved it? When you start talking to the public sentiment changes. And when public sentiment changes, the room for someone wanting to interfere is curtailed because they know you will go out there. And when you tell your story, you'll have to tell that part of the story.
Any other question? We're done. We move to the next one. You want to? Okay. Let me hand over to Mr. Mutlu to take us through the public comments. You would have seen them, and we would have given you an opportunity to respond, but he will take you through.
Thank you, Minister. Advocate Johnson, as Minister when she introduced the flow of the process, intimated that we have received a high number of public comments. And it's on record that we received a whopping 209 comments. And out of the 209 comments received, only one supported your appointment. So essentially, we're sitting with 208 objections. And now, I would like to take you through a whole range of these comments. But obviously, I wouldn't go through each and every comment. So I'll package these comments in terms of their similarities in content. The bulk of the comments which raised objections to your appointment has to do with conflict of interest, ethical concerns, and this stem from your recent participation in the ad hoc committee. But I'll deal with those. But there was also other comments separate from this, and I'll also deal with those comments. And they touch on issues of poor judgment, but also ethical concerns in how you dealt with some of the cases that they've listed. So perhaps it would be prudent that I should take you through the comment that deals with your support of your appointment and just take it out of the way. And this is a comment that was received. It's under 190. You should have received it. Column 190. And this comment comes from Robert Mailula, who says, Advocate Johnson leads the investigative directorate and has long-standing experience in organized crime and corruption cases. Her Scorpion-era background shows a strong commitment in accountability and results. Her strengths are skilled in handling high-level corruption, strong operational knowledge of the NPA, and respected within prosecutorial cycles. So this is the support that you receive. But then, if I can take you to a comment on column 10. You should have received it as well. And you had the opportunity to respond to it. This comment says, Advocate Andrea Johnson has been compromised and cannot be trusted with such a high-profile office in our justice system. I recommend that she's removed from the shortlist. And there's a comment from on column number 19, which just sums up as well how the public felt about your candidature. I register my objection to the consideration and possible shortlisting of Advocate Andrea Johnson for the position of National Director of Public Prosecution, South Africa. Or South Africa not risk appointing an NDPP whose ethical record, actions and conduct have already been publicly questioned and criticized, including by the Madlanga Commission, which highlighted serious concerns about governance failures, conflict of interest, and compromised decision-making within NPA's leadership structures. Some of these revelations involves or implicate the leadership environment in which Advocate Johnson operated. So this is part of the comments that I needed to highlight to you. So this has to do with, among others, your admission to have been involved in the selection and recruitment process involving your husband, which you admitted at the recent ad hoc committee sessions. Now, there is also a comment which you are aware of, and this comment is from Mr. Matsela Koko, who raised an objection. And for the sake of transparency, I'll read the contents of.
Also, do you indicate that he didn't indicate that he's got a case that is in IDEC as he did the objection?
Indeed, he didn't mention that. And the objection also is unrelated in as far as this case, that the pending case is concerned. Dear members of the NDPP selection panel, I'm writing to formally submit my objection for the consideration of Advocate Andrea Johnson for the position of National Director of Public Prosecutions, NDPP. As a former ESCOM Group Executive, directly impacted by the matters outlined in my submissions, I believe her actions in relation to the 2022 Alternative Dispute Resolution and Cooperation Agreement with ABB South Africa Pty Ltd render her unfit for this critical role under Section 9(1) of the National Prosecuting Authority Act 32 of 1998. Please find attached my detailed submission titled The Constitutional Disqualification of Advocate Andrea Johnson for the position of National Director of Public Prosecution, which sets out the constitutional, policy, and evidentiary grounds for the objection. For your reference, the submission includes the following supporting attachments: Well and Sontag article, dated 16 November 2025. 2, the Nkabinde Commission transcript excerpts from Advocate Shamila Batohi, testimony, 27 November 2025. High Court of Canton of Zurich judgment, which is translated. This judgment was given out on the 20th of November 2024. DCP Directive, ADRCA, Constitutional Review, Gauteng Division, Pretoria, set down for April 2026. I'm available to provide further information or clarification if required. By contact details are provided below. And as you would be aware, the attachment that is referred to has to do with an agreement between this company that is referred to, the ABB South Africa, and this was an agreement for payment of an amount of 2.5 billion in exchange of indemnity to prosecute on crimes related to breaker and poker, among others. There is also an objection that was posted on Facebook where the author indicated that you should be stopped from being appointed as a director of National Director of Public Prosecutions.
Verify Facebook linked to DOJ as a submission.
Indeed, Minister. This you would also locate under an attachment PCJ 3 that you would have received. South Africa cannot risk an ethically compromised NDPP. There was also an attachment referred to as PCJ1, which
PCJ1.
Yes.
Can I request that we do not process that here?
Yes. Oh,
I've
okay.
been alerted, that's what will be on my desk. It relates
Yes.
to decision of prosecution and perhaps having to inquire of her fitness to hold office. Advocate, I just became aware it's the one that relates to a decision on the Mapisa Ngakula case, and that the team jeopardized Nombasando Zondwa Ndlovu's own prosecution. So the issue is on how the prosecution process has been handled in a court. I hope I'm clear on that one. My voice seems to be going, I don't know what's happening with it. So that PCJ, that's what I'm picking up. It's more on cases that are running.
That are live in court, yes.
Yeah, that are live in court. So I'm going to request that we do not deal with those.
Thank you, Minister. So, Advocate Johnson, these are the objections received from the public, which obviously you were afforded the opportunity to respond to such. So these objections were made, you were made aware of the contents of the objections, and you were given the opportunity to respond. Now, for the sake of brevity and transparency, it would then be prudent of us in this process to allow the opportunity to place on record your response to these objections, and so I can afford you that opportunity to do so.
Maybe before you omitted the Daily Maverick one, because I do think as much as the support, there's issues that they're raising. Should I do it?
Thank you, Minister. That's the first one, actually.
Is it? Oh, okay.
Yes.
Yeah.
Yes,
But I
that's the
didn't
first
hear
one.
you.
You can do it.
flag.
Yes.
Can I do it? Yeah.
Yes.
Daily Maverick makes a comment here. Johnson has a reputation as an excellent prosecutor. She has set up the investigating directorate against corruption. She's the best chance SA has of fighting organized crime and corruption. She's the most experienced prosecutor in the field. Her appearance before Parliament's ad hoc inquiry into Mkwana's allegation did not go well, and this could be a markdown for her. Johnson has temperament for the role and is fearless, but her management smarts are not great and she would need support, says insiders who support her. So I would want you to also reflect. So there is an issue around your management skills from your peers as they reflect.
If I could start, would you allow me to start anywhere, or must I start at the start?
Anyway.
So just to be clear, Minister and members of the panel, the objection raised by Mr. Koko, I'm not prepared to discuss. It is currently litigated. All of the documents that he has attached as part of his objection, Minister and members, is part of court papers. It is part of a motion application.
I think I can rule that we leave it there.
Yes.
I might have missed it like the other ones. That
No, and it is understood. The state is opposing it. Just for the record, we have filed all of our papers. All of the necessary parties have filed in that Motlong, so I cannot discuss that matter.
You can move on to the next one. Thank you.
If I could deal with, in the Daily Maverick, we talk of the Mkhwanazi allegations and what happened at Ad Hoc. Minister, I made it clear when I was at Ad Hoc, I didn't understand the 6 July media briefing. It had taken me by surprise, as I testified, simply because General Mkhwanazi and myself in particular had worked well over the years and had not had any disagreements either about what each was doing or what we did collectively. I had to respect the process. I said at the ad hoc committee that once I'm done testifying, I will in fact call the general because I need to understand we are both still in our spheres of work. The work doesn't stop while ad hoc and Madlanga carry on. I in fact did call General Mkhwanazi, perhaps 2 weeks after my testimony at the ad hoc was done. The gist of the conversation that the Motlong was, General, I told the committee I will call you. I'm calling you to understand where did we go wrong. I didn't understand that we had a challenge. And if there's something I was not aware of, please tell me. And I want to set the record straight. It is telephonic, but we should have a meeting. Said, I want to be very clear, as I was at ad hoc. The only matter, you talk of a big five. I don't know your big five. I also do not know the organized crime the so-called big five are involved in. The only matter we have where there is...
Johnson, I'm going to ask you to deal with what we're dealing with. I don't want to get into the Madlanga and ad hoc committee space.
Okay. It was just the Mkhwanazi allegation as per the Maverick.
No, let me help you. What the objection or the comment is about is that the objections are mainly about your role in relation to the appointment of your husband.
And I will deal with that.
And the performance, don't go into detail about those investigations because we don't want to overreach our responsibilities. And lastly, because they just made a reference to the committee, how you performed. That committee, I think the comment from Daily Maverick says it was your law. I think they put it in that way, your law. So deal with that. Don't go into the detail of what your statement in Parliament would have been and all that, because I don't want to have a situation whereby we start wanting to correspond what you had said and all that.
Understood.
Yeah. Deal with the interview, not the investigation into the allegations said by General Mkhwanazi.
So without the detail, just for the committee to know that work continues and that in terms of a conflict with regards what was raised in the Daily Maverick about the ID and or investigations being compromised, those have been dealt with. But the comment that is made there, Minister, about my performance at ad hoc, I answered to the best of my ability. It will not find favor with everyone. I could only be honest in my submissions, and I accept that. I will take the criticism that comes. And for me, I could only answer as I was asked. There's nothing different that I would say today if I was asked the same questions. When it comes to the main complaint, Ndate Motlong, as I saw it, the majority of it, when it relates to the conflict of interest, ethical leadership, I'll ask the panel and Minister to bear with me. I said, and I have to repeat, and I repeat only because I had nothing to hide. When the question was posed to me, I didn't flounder and fluster. I heard the question, and I was able to respond and say as I did, because I have no different answer. In 2007, I formed part of a panel. I cannot remember the rest of the panelists. What I did do in 2007, I did disclose. that I was married and to whom I was married. And I did physically recuse myself from the shortlisting, where he was shortlisted, the actual interview, and the actual adjudication. And that was in 2007. 17 or so more years later, when it is raised, that is the only truth I have. But what it means is that I had to reflect, which is what we have to do, about the perceptions out there about whether or not my disclosing and my recusing myself from the process when he was in the interview is sufficient. And all I'm saying is, I accept that maybe what I should have done back in 2007 was recuse myself completely. It was a misjudgment. I had no intention to misrepresent anything, because I did not misrepresent. I did disclose. I did recuse. It goes back to the question you raise of the standard and duty of care, and I'm saying, in hindsight, Ndate Motlong, I accept. I could have done better, and I could have done differently. As a national director, given that at that time, those were the two things I knew I had to do, which was disclose and recuse. I am saying we should have more clarity in terms of a code where we must have express, written declarations of ethical conflict of interest. We must all be held to that, and that must be adjudicated by an independent panel, which can also consist of outsiders. So I am saying I accept. How it looks is not good. I cannot change what I did. I have to accept that. I accepted it at the ad hoc. I accept it here. In hindsight, I should have completely removed myself, and not just when he went for the interview, the shortlist, and the adjudication. If you'll allow me, I just want to check. I think everything.
That one. Was DSO under Public Service and Administration? Was it the recruitment? Were you under?
We were in the NPA, and it was NPA Act appointments.
Okay, those ones.
Those
your
ones,
husband
yes.
was under NPA Act,
Yes.
not under Public Service, because
No.
it's dual.
No.
Okay.
I think all of the rest that the Motlong flow from there. Questions about ethical leadership, etc. I have always prided myself, and I think it also talks to what was said in the Daily Maverick article and in the positive article you read. That is how I have conducted myself. This was an error of judgment. I'm not going to change it. I can't take it away. This panel will have to judge me on my entire performance, my history in the NPA, where I have faltered. And if this panel feels that in terms of that happened in 2007, where I did what I knew I was supposed to do, but when we fast forward, in hindsight, you should do differently, I can't take it further. I really can't take it further. And if I am to be penalized on a misjudgment made then, it is the penalty I have to live with. And all that you do is you say, because of that misjudgment, you will never be allowed, as you have in the rest of your unblemished career, to be able to move ahead. And I accept that. I came here knowing that those were the questions. I came here knowing that South Africa expects me to be different. I have always carried myself in a very particular way. And you can talk to stakeholders and colleagues, etc., across the board. I have a way that I have conducted myself. If I am to be penalized on this, I am where I am. And don't smile. No, I am where I am. Sorry, Minister. It is where it is. He was trying not to smile.
Okay. What level was he? Which area? What was he appointed for? What was the position?
At the time, it was for a special investigator
It
or
was the
a
special
senior special
investigators.
investigator. I honestly cannot recall all of the details, and everything I give you is what I have from memory. The chair, unfortunately, has passed, or else that would have assisted me, because I can't remember anyone else, Minister, that was on the panel who'd be able to say what documentation I filled in as part of my disclosure, and to corroborate that, in fact, I was not in that adjudication process, I wasn't in the shortlisting, and that I had physically recused myself and wasn't even in the vicinity when he did the interview. You only have my word.
Did he declare?
Yes, he did.
He did. Because remember, as the investigators, there's a vetting process.
Yes, he did declare.
So the vetting didn't pick up that you were sitting in the panel in the process and you had to step out. Because you sat in the process, so vetting should have been done before his appointment.
Minister-
because the Act requires vetting process.
Sorry. Yes,
That's why I was asking at which Act was he appointed, knowing that NPA has two elements of it. It's got the Public Service Administration, which all the appointments that are in that side are governed by Public Service Act. And then it's got the prosecutors and investigators that are governed by, the appointments are governed by NPA Act. And the specific processes that must be done. So that's why I'm checking, and it could be not a fault of the two of you, but the person who was responsible for the recruitment or overall in terms of a final approval, because the vetting is required by law. So at that point, no one raised anything.
Not at all. And
Neither
just,
to you, neither to him.
not at all. And just to be clear, Minister, from that date, this was the first time anything was raised at the ad hoc.
Okay.
I just wanted to clarify. I cannot tell you why it wasn't, and that is why I'm saying that the travesty of this situation is the chair has passed, and the chair would have been the person who signed off and would at least have been able to indicate what documentation we filled in with regards the disclosures of the relationship and or otherwise.
Okay. Colleagues wanted to do a follow-up. I just wanted to clear that one. I was checking. You were still on the floor. Okay, you are doing your questionnaire, but I think everybody wants to do a follow-up on this one. Prof, and then we'll come.
Just two things. In such an illustrious career, and this blemish must have been very traumatic to you.
Yes.
And it surely must have helped you to try and retrace your steps back to that moment. I'm struggling with you saying you can't remember the details, because in a career that is unblemished, when something happens, you normally want to go back and reconstruct
Yes.
that moment. And also your husband is there to say, can you remind me on some of these and so forth. That you can't recall, it's a bit of a challenge for me. The second one, with the help of hindsight maybe, let's assume you are the successful candidate for the NPA. Would you allow, even if there were no specific laws, anyone to sit, help even in the crafting of the specification, shortlisting, adverts of a person who is a close relative of theirs, mother to child or a spouse, a cousin and so forth? How would you approach that? It's an ethical issue. Sometimes it doesn't have to be regulated by law. It's a matter of what you think is right, what you think is wrong in terms of judgment.
Just to add, Advocate Johnson, on this, I also am finding it difficult to understand how you are not able to remember the panel, and the only other panel member is the chair that you remember, and unfortunately the chair has died. That is worrying, you know. And why it's worrying, it's not that one can prove right or wrong. it's exactly what we were talking about earlier, where as a result of some of the gray areas that were allowed, that you have overlooked, where your judgment seems to have been found wanting, it almost like falls inside that pot. I guess it's a comment, but I just want you to take it with you and reflect. It does bring about doubt, yeah. And then on the issue again, in your response, you said, to be clear, there were many processes that I would have had to follow thereafter before the appointment. At no stage was I questioned or informed that there was anything in which clarity was sought. This response to me also adds to the, it's almost like still not seeing anything wrong. I know you have said I should have approached it differently. I could have. Your words are I could have, not should have, which in itself is worrying. Could have is a choice. Should have is I had no choice. I had no business doing that. I shouldn't have done it. And this is what is still worrying me, that the hindsight is still, but no, man, it's not that bad after all. Kind of, it gives that feeling, that sense, because of choice of words. But even here, when you say many processes, just on the many processes, if you could tell us what those processes were that followed afterwards, and wherein no one asked, who should have asked and did not ask. Thanks.
So if I take your comment, Mayor, and the question together with Prof's, I cannot recall who everybody was on the panel. It was 2007, and I don't have the documentation. And what I said was it was the first time from 2007, now in November 2025, when the issue was raised. I go only on the memory that I have and my discussions with my husband, because he does recall that I wasn't there. He does recall he disclosed. And I said to him, yes, I also disclosed. The point is, it wasn't even a secret, but we both disclosed. It was known that we were married at the time. I don't want Mayor I understand the could have and should have. Please do not make a mistake. I am not by any means minimizing what happened then. What I'm saying is, in hindsight, it should never have happened. I should have removed myself. Sorry if I used the word could have. I'm saying that's what I meant. I should never have done that to myself. Because look at where we are sitting 17 years later. That's what I'm saying to you. I should not have been in that situation. That is what I'm saying. And it is unfortunate. I don't have anything to refresh my memory. I really don't. And there's a reason why I remember the chair. It is because the person passed away not so long ago. And when this issue came up, I remembered, wait, because I know where that position was that he had applied for, that was the chair. He was the chair in most of the positions because it was a specific unit. And that's how I remembered the chair. I know there would have had to be another panelist. And on that, I go on how we operated in terms of panelists, and there would have had to have been an HR representative. And when I talk, Mayor, of those processes, I talk from my general understanding and recollection at the time. You have the interviews, the chair would have signed off, and it would have gone into HR and those processes. And then it would have gone above that for the appointment to be signed. And that is what I mean, is I don't know who in terms of actual individuals it went to. I talk of the process it would have followed as other processes in the DSO followed where I had been a member of a panel. That is what I'm talking about. So that is how I recall it, not that actual process. And then,
Minister, can I just ask for clarity?
Okay. I have one more question.
Okay.
We can do this, Minister. If it is follow-up to that question, let me deal with it, and then I'll deal with the second question that Prof raised.
Sorry, Minister, about that.
No, I didn't want to disturb train of thoughts as well.
Oh,
Yeah,
okay.
because on that, I thought you were coming with another one.
Oh, no. Let me just go straight to the point. Yet you had been sitting with this panel the whole time and recused yourself when Mr. Johnson came in. Is this what you're saying? You'd been sitting with them, interviewing other people, then candidate number 6, Mr. Johnson, guys, this is my husband. You walk away.
No,
Was
not
that
at all.
it? Okay, all right.
Not at all.
Okay.
The panel said to me, we'll deal with the candidates. We dealt with the candidates. The panel said to me that they are now going to call Mr. Johnson. I had left the room. He came in, would have gone for his interview, and they then messaged me to come back. When I came back, he was gone.
The question is, because it's the advert, this is the post.
Yes.
So were you interviewing other candidates who were part of the interview panel of the other candidates who competed for the same position as Mr. Johnson?
Correct.
That's what she's asking.
Oh, sorry, ma'am,
So
that is
you
correct.
actually sat through the process, but recused yourself when Mr. Johnson was to come in as part of the interview. During his interview, you were outside. You were not part of the process.
No.
You didn't interview him. But at the time he was finished, you came back to be part of the process, almost concluding the interviews, let's say, and also the deliberation that eventually made a recommendation.
So when
Can I write on that one, Chair?
maybe if I answer, then Prof will see if you want to write on it. Okay.
I just want to check, were you part of the process of conceptualizing the position,
Not at all.
specifications,
No.
adverts,
No.
and then sitting in the other interviews?
On all of the first mentioned, no. I was not part of conceptualizing, not part of the advert process, not part of the other aspect you raised. But I did interview other candidates who were shortlisted for that post.
And this was a position under your unit, right?
Not my unit. It was in the DSO in a different unit.
Okay, thank you.
To the question, Minister, when I had come back, so how it worked is, I can take it from what happened with the other candidates when I was in the room. As each candidate finished, we scored the candidate. The deliberations would take place once all the scoring was done. When I came back in, he had been scored by the panel that interviewed him minus me. When they did the deliberations, we deliberated on the candidates. I was part of the process. I knew his score, but I was not part of the discussion. At that time, I was now gone. That was the end of the process. So when he was recommended, I did come to know that he was recommended, because what happens, Chair, is what happens, Minister, is the Chair must send the recommendations for every panelist to sign. That we all had to sign. And that is where I saw that he was recommended by their deliberations. But I was part of deliberations of other candidates. I was part of scoring of other candidates.
And you signed the form?
I would have signed the form. What I'm saying is, I look at
So
other
everybody
processes.
else was scored by all the panels?
Yes.
Including yourself?
Yes.
And then let's say it's 6 panel members. And then at the time, how many were they?
You see, Minister, I don't know if there were,
Okay,
we
you
were
don't
4.
remember. I'm just going to assume. Let's say it's
correctly,
4 people.
I don't know if I was replaced. I wanted to get there. I don't know if I was replaced, who I was replaced by. I left.
But Advocate Johnson, let's take it you are a manager now.
Yes.
And when an appointment is to be done, for example, at those levels, like you were explaining, that we had to introduce, for example, an external observer so that there's transparency and all that. But when you have a panel, you can't say in the middle of a panel, then you change the panel. For example, these members know that we must stick with it until the end. None of us can leave. Otherwise, they make the process irregular. Or none of them can have a replacement, because it skews the interviewing process. Because how do you determine that this person is suitable if you didn't sit in that person's interview to ask questions. We can make a reflection if we were not in the room. That's why we can't stand up, even go to the bathroom. We must sit here until we finish with you. Whether it's a question asked by this colleague or this one, we must be here to hear the responses so that when we deliberate, we have that. So I'm trying to understand. You said it's 2007.
Yes.
It's not very long.
And unfortunately, I really cannot remember. I'm not trying to be obtuse about it.
I know I inherited the good, the bad, and the ugly as a minister. So we didn't have systems that could detect an irregularity in the process. Because that, as you are saying to me, where I'm sitting as a minister, that process was irregular.
And I accept that. And I'm saying to you, Minister, I have not been asked about this process till now in the ad hoc.
No. I'm not even worried about you now. I'm just worried about
the process
I
then.
believe in systems.
Yes.
So
and that's what I'm saying. I did at the time what I knew we were doing was to disclose and to have recused myself. And that's all I knew that I had to do. And that is where I am.
Okay. No, understand me. I have a part. I know members are looking at a part. Because I'm a minister, I'm looking beyond just what you are saying to understand what could I be dealing with.
Yes,
beyond just you as a candidate.
But in the NPA...
Because, you know, I'm stringent on issues of governance and processes.
Yeah. So in the NPA, and I know also when we were doing interviews, especially for the advocates at the DSO, when we did them in Gauteng, we actually had a questionnaire, and we asked the same question of all candidates so that no one is prejudiced in the interview, and we did keep the same panel. In the NPA, in my years after...
No, Advocate, maybe let's tell you, those of us who specialize in corporate governance, it's not about the question, it's the entire process.
Yes.
End to end. Every step of it is critical.
Yes.
Because at the point where a person is being shortlisted, remember, there will be a panel. That panel must decide on the shortlisting. A panel that shortlists can be the different panel from the one that interviews.
Correct.
You are aware of
yes,
that.
And that is the processes that we do run. So in terms of the processes in the NPA that I am a part of, even in IDAC, we first, our HR sits with us and they put together the specs for the advert.
Yes.
The advert goes through. Once that is advertised and the closing dates, all of the applications are submitted where they are submitted. They have that pre-shortlisting to see that the forms are correct, et cetera, and where there aren't, those fall away. Then those that qualify in terms of the administrative minimum requirements are then brought through. But before we even get that, simultaneously, we have to apply for a panel approval. Depending on the level of the person, the panel could be approved in the NPA, but it's only on lower levels. The majority of our panels, especially in IDAC, for example, have come to the Office of Minister for approval. When the panel is approved, the shortlisted CVs after the pre are then brought through. First, a date is set for the shortlisting. Panel must sit together. We do deliberate, and then we indicate how many positions, what is best for so many positions. So if you have 4, it might be best to have 12 people as an example. We sit together. Once we are done with the shortlisting, we then inform HR, this is the final shortlist. We put it on a form, and there's a form all of us sign.
Yes.
Those candidates are then informed because we then, as a panel, agree to a date. That date is communicated to the potential persons that must be interviewed.
Good.
In that time, the panelists sit together, work out, but we do that so there's no compromise. On that morning, we all have to get in an hour earlier. We all sign declarations of conflict of interest, those forms, and we then work out the questions. The questions are then typed so that every candidate is asked accordingly. If there's a practical, the practical question is also done, and then the candidates come in one by one. And when they do their practical, Minister, there is always someone that is sitting with them from IDAC HR to make sure that none of the candidates talk to one another. And then when we are done, we all do sit and deliberate. The scoring is done. Sometimes we find candidates, sometimes we don't, but there is a stipulated process that we have to follow and that we do follow.
Now, explaining what you know now and the processes that you are following versus what you got involved in, what's your view?
I should not have gotten involved in it at all.
Okay.
And if there was any irregularity, I really would have appreciated at the time someone to have just raised it. And that process, Minister, if it was raised that this is irregular, I can bet you, me being me, we would have asked that it be set aside. That opportunity was not there, and I do regret. I really do regret, because here I am sitting and talking to all of you about a 2007 issue when, with everything else,
But
I'm
in
going to
law,
go.
what does that mean? There is no old case. There's no. It
Minister,
doesn't get rotten.
I leave it to you and to the panel to adjudicate, but bear in mind,
No, it's
Minister.
not for the panel.
I'm saying that bear in mind, Minister, a complaint has been raised with your office. I have to leave it to you and your discretion.
Okay. No, I just wanted so that the panel is clear.
Yes.
And I'm glad you explained from the point of, because I was worried, you leading quite a number of interview processes.
No,
I didn't want to have a sense that you are not following the process
No,
and you are not doing
we
the
are,
correct,
and especially
and
the
will have.
conflict,
So
conflict
I'm
issues we
I'm
deal
glad
with.
that,
Yes.
Yeah, you are dealing with that.
Thank you, Minister. There is one comment that received from public interest, but before then, just a rider on this issue. I think to classify or categorize this misnomer as irregular is actually downgrading it. It's actually grossly irregular. And for you to suggest that had someone brought it to your attention, you would have recused yourself, you wouldn't have acted the way you did. I don't think...
Just to be, are you sure that it's a complaint that has been brought before me? I've not received it.
No, what I'm saying, yes, I only received feedback of it yesterday.
That I am
where
receiving
it said
I
that it will
have
be.
been involved in this discussion then on it. I'm not aware that.
And I accept you may not be
consider.
aware, Minister. I was also only informed. I saw
know
it
the
in
other,
the
that's why
midday
I
yesterday.
stopped it. Okay, I'll have to be circumvent on it.
Okay, thank you. Actually, the conduct is inexcusable. And what was expected of you was actually very basic and elementary. Okay.
Can I interject you and ask, purely from this possibility that the minister just spoke about, just high level, that we leave it at that explanation and we leave it as the candidate has explained it? I'm sure that we can sit here and tear into it for longer, but because it has a potential then to end up at the minister's table, if it at all perhaps there is such a possibility. I don't think that taking it further than up to where we are may actually not compromise it one way or another when it has to go to somebody who has to adjudicate it. So
No, accepted, Minister.
Yeah.
But regrettably, we cannot unhear what you have heard. But I just wanted to bring to your attention.
No, that's why I had to make it on record that I was not aware.
Yes.
I've got my iPad, so I've been looking. I've not received it from it. Possibly it's coming with a fiscal memo that is coming through.
Thank you.
So it was something that we're dealing with. We could have managed it differently,
Thank
but I think let's take it in that way. By the way, the OEA is under you.
No.
No, it's okay.
Advocate Van Rensburg in the office of the NDPP. Yes.
Okay. I'll take you through the objection from public interest essay. This complaint was authored by the chairperson of that institution, Tebogo Gas. I hope I'm not butchering the
I
surname.
think it's Tebogo class.
Class.
Yes.
Okay. The Gas.
Is it Gas?
It's Gas. It's
I think
KH.
in a document I saw,
Yes.
class. Yes.
Yes.
Sorry.
And I'll go straight into the key issues that concerns that he raised as an objection for your appointment. Her failure to recuse herself in matters affecting her husband constituting a clear conflict of interest. The existence of serious allegations linking her spouse to factional battles within SAPS, creating severe perception risks. Her misuse of prosecutorial authority in pursuing a matter that was plainly a SAPS-HR/disciplinary issue. The premature and poorly prepared enrollment of the Matela Koko state capture prosecution, which collapsed at great financial and reputational cost, and broader performance deficits during her leadership of the investigating directorate. The NDPP plays a pivotal role in safeguarding public trust, prosecutorial independence, and constitutional integrity. In our considered view, the cumulative concerns outlined in the attached submission materially compromise Advocate Johnson's suitability for this critical appointment. We thank the panel for its important work and trust our submissions will assist in ensuring that South Africa is served by an NDPP of the highest integrity and competence.
I dealt with the issue of the conflict. I can't take it further than what I dealt with. With the Coco matter, I also dealt with that at length. With the alleged HR matter, which involves the head of crime intelligence and others, I'd like us to be mindful the matter is sub judice. It is a criminal matter currently in court. Safe to say that the charge sheet is a public document. It is not an HR matter, and it was not about him sitting on a panel. It is about allegations that happened before the interview, during and after, that compromised the entire process. It wasn't just in a specific part. Lots of things happened before, during, and after, but that's not the only charge. There are fraud charges as well. So even if one says the corruption matter fell away, there's still other charges that they must answer to. And I want to be clear, Minister and panel members, IDEC did not look for a case. I did say at the ad hoc committee, there was a Section 27 referral that was made. We had to look at where this matter fell. And this matter fell not because it was one matter. There are 6 matters that form a collective of activities of these matters that fell within the definition of our state capture matters. Hence, we took the matter. With regards to what whatever challenges my husband has at work, I'm not in his place of work. He must deal with his place of work. They must deal with him. In the same way that if I have challenges with colleagues in my workplace, the national director, as my immediate supervisor, must deal with me. It can never be expected of me to enter that fray. I have never, and I won't. And I would expect that my space of work be respected in the same manner. It's not for me to have entered it. And I have not dealt with any matters because my husband works at Crime Intelligence. He's been there since 2009. These matters came to us in November 2024 through a complainant, and that we didn't make secret, and that there are 6 different matters that we have dealt with. And the head of Crime Intelligence, as he is now, has been there since, I think, 2021 or 2022, Minister. Just to be clear, if what we do is look for vendettas, cases would have been dealt with a long time ago. Cases could have been made up. That's not the job. We got a referral. In fact, if you'll allow me, Minister, I actually commented the other day, I said, if we didn't get this referral, we wouldn't have had any matters in that space, because that is the truth. These are the matters we were dealt, and that is why we're dealing with it.
Thank you.
Thank you very much, Advocate Johnson. You'll be happy to know that we've come to the end of the interaction.
So you take the smiley one away? Because he also infected the prof, because at a stage the prof was smiling.
So the smile just went through.
And even when May was telling me about my could and should, she still smiled. No,
at least the panel is friendly. No, thank you very much, Advocate Johnson, for coming through and for availing yourself to be put through the process. It's a process that we know it's quite interrogating. I hope we didn't come across as interrogating, but having a conversation with you. So thank you very much that you made yourself available, and the process ends here. I wouldn't explain to you, you know the process, you are internal as well,
yes,
how it's going to run from here.
I am aware.
And thank you very much.
And may I take the opportunity to thank you and the panelists. I wouldn't have expected any better, smiles or not. This is a rigorous process, and what the NPA needs is exactly as it was explained. Nothing is personal. So I'm glad you gave me the opportunity. I have to let you deliberate as you see fit, and I thank you.
Thank you very much, and have a lovely evening.
I will. Thank you.
Okay, that's it, members. Until tomorrow.